Bring the candidates then. Commissioners, can I have your attention? In the early hours of this morning, a resolution was taken to confer upon the chairperson dictatorial powers to make sure that everything goes well. The way Commissioner Klaba is looking at me.
ACJ, there's one point we need to cut against. The number of what you call follow-ups. Because those follow-ups must not degenerate into a debate with the candidate.
No, that's true. But on a serious note, commissioners, can we accept that I can be stricter and you will understand? Of course, if it's something you feel quite strongly, just let me know. But I'm sure we will cooperate properly. Yeah. And we'll stick to the 6 persons to put questions.
And also limit the number of follow-ups.
Follow-ups, yeah. I'm going to be strict with the follow-ups as well. Okay. They are conferred, yeah. Yeah, thank you. Thank you. Yeah.
And what is the effective date of this proclamation? Is it coming into operation right away or tomorrow morning?
With immediate effect.
I mean, if I want to speak, I'm going to call K-Sack.
Yeah. Okay. And let me welcome the Judge President of the Eastern Cape Division, Judge President Benenge. Judge President, you are welcome.
Thank you very much, ACJ.
Thank you. I am told that the Premier of the Eastern Cape has delegated Mr. Fundile Gade, the MEC for Education, who will join us virtually. I don't know whether he is already there. Are you there by any chance, MEC?
I am there.
Oh, well, welcome. Thank you for joining us. Okay. All right. Let's start. Good morning, Mr. Tugara.
Good morning, Acting Chief Justice, the President of the LCA, and the Honorable Commissioners.
How are you this morning?
I'm feeling a bit shivers. Yes.
I thought that you might say your complaint is that you are going to speak without being paid today.
Yes.
Because you normally get paid when you speak.
Yes, thank you.
Thank you very much. Welcome, and thank you for making yourself available for consideration for appointment as a judge in the Eastern Cape Division of the High Court. Umtata. I have noted your qualifications, that you hold a B. Juris degree from Walter Sisulu University, as well as, I see here they made it triple LB, LLB from the University of Natal, is that right?
Yes.
You obtained your BUris in 1983, is that correct?
That is correct.
And your LLB in 1988.
Yes.
Yes. You started your working career as a clerk in the Department of Justice in 1978, is that right?
That is correct.
Up to 1980, and in 1984 you became a prosecutor, is that right? Is that correct?
That is correct, acting.
Yes. And you later became an assistant magistrate. That was in 1984 to 1985.
Yes.
Yes. When were you admitted as an advocate?
I'm not sure about the precise dates, but it was in 1990.
Yes. And you joined the Society of Advocates of Transkei at the time.
That is correct.
Yes. And in 2009, you joined the Society of Advocates of Johannesburg.
That is correct.
Yes. So have you been practicing as an advocate since 1990 up to now?
That is correct.
Without any interruption.
There were no interruptions.
Yes. And that gives you about what, 30 years of practice? 31?
30 years, yes.
30 years.
30 years.
Yes. That's quite a long time.
Well,
Yes. Can you share with the commissioners the types of cases that you have been handling in your practice over the past 30 years? What types of cases, what branches of law you have been handling?
Acting Chief Justice, it's a variety of commercial, administrative, and constitutional cases, like medical negligence, MVAs, and it's just a variety. It's
Well,
difficult.
I want to know the variety. So I want to see your exposure to different branches of law. So contract, matrimonial matters, administrative law, constitutional law, commercial law, competition law, customary law. I just want to have an idea.
Well, I've done a lot of medical negligence cases. It's quite difficult to say. It's a variety of them, Chief Justice. It's quite a lot of them, and it's difficult to pinpoint one.
No, I'm not asking you to pinpoint one. I'm asking you to say, my practice gave me exposure to cases that fall under competition law. For example, if there were cases under competition law that you did, and I also did a lot of cases on labor law, or maybe not many, but some, and I did cases in matrimonial law, I did cases in patent law, I did cases in commercial law, or my practice, for whatever reason, focused on criminal law, administrative law, contract law. I just want you to give the commissioners a good idea of what experience you have got over the past 30 years.
Yes, I've done a lot of cases in labor law matters and commercial litigation generally. It's quite, they escape my mind, a lot of them now. They escape my mind, a lot of them.
You can't remember which branches of law the cases you did fell under?
Yeah, I can't remember now.
How does that happen?
It's,
Are you only able to remember 2 or 3 branches of law?
commercial litigation generally,
Yeah.
Chief Justice. And I did a lot of insolvency and company law matters at the inception of my practice in the bar, but it was not quite a lot. It was just an exposure to company law and
Okay. Are there any reported cases? Are there any cases which you argued or trials that you were involved in as an advocate which resulted in reported judgments?
yeah, it's quite a lot. Just Chief Justice, the list appears in my CV.
When I looked at the questionnaire, I didn't see a lot of them. I saw some, but less than what I would have expected in a period of 30 years. I think at page 16, it's written reported cases handled as an advocate, and it's 1, 2, 3, 4, 5, 6, 7. Is that correct? 7 reported cases that you handled as an advocate that are reported?
I can.
I'm looking at page 16 of your bundle. That's I think that's in your curriculum, in your CV.
Whereas the cases under the heading reported cases handled as an advocate.
Yes.
Yes.
So it's 7 reported cases.
Yeah. Yes.
Yes. You might have a different impression. I'm under the impression that I would have expected much more over a period of 30 years.
Well, maybe it's because Chief Justice, the attorneys didn't have an interest to brief me.
Yeah.
That's why the number is small.
Yes. And then out of those cases, have you got 1 or 2 that you regard as quite important that you can just say this is why this one is very important?
Okay. Which ones?
Any one of them, in terms of their importance as you know them. Is there 1 or 2 that you want to tell us about?
Yeah, the one which I regard as the most important is that of is F, Vacation Others versus Premier, Eastern Cape and others. It was a dissolution of a corporation by the state without having consulted with the employees, and the case went up to the SCA. The petition by the employer, the Premier, was dismissed.
Okay. And you have acted as a judge on a number of occasions, is that right?
That is correct.
And are there judgments that you wrote which have ended up being reported?
Pardon?
Are there judgments that you wrote as an acting judge which ended up being reported?
Yes. I think it's Jenkins. It's supposed to be in the list of cases handled.
Yeah, that is page 17. It's
Jenkins.
under your CV, Jenkins.
Yes,
is
but
it
it's
only one?
It's not. Yeah, only one.
Yes.
Which was reported was acting as an advocate.
Yes. you say acting as an advocate, we're looking at those that you wrote as an acting judge.
Sorry, as an acting judge, sorry.
Yes, okay. Have you acted on a number of occasions, many stints over the maybe past 20 years or so? Or have you acted only for on few occasions?
Well, I used to act not year after year.
Yeah,
At the beginning, it was year after year. Then, after some time, I decided not to do so. But from 2017 to 2020, I've been acting.
yes,
Yeah.
yes. Okay, and I suspect you enjoyed acting. Otherwise, you would not be availing yourself if you didn't enjoy, adjudicating.
Yes, I enjoyed acting.
Yes,
Yes.
yes. Now, in your CV, it's written that your areas of expertise are constitutional law, administrative law, medical malpractice, employment law, public procurement law, and commercial and civil litigation generally.
Yes.
Is that correct?
Yeah, that's good. That's correct.
So have you done a lot of constitutional litigation matters?
I've done. I wouldn't say quite a lot, but I've done.
Yes.
I've done them.
Of course, I saw one of the cases which you listed as reported cases that you argued with Ngumba, which was in the Constitutional Court,
Yes.
and I was there when you argued that matter.
I argued the matter.
Or you
Unfortunately,
did it in the High Court, but somebody else did it in the Constitutional Court? Or did you argue it in the Constitutional Court?
I started in the High Court and then ended up in the Constitutional Court, where I had the misfortune to lose before you. Yes,
But it's reported anyway.
it's reported.
Yeah, yeah, okay, no, that's all right. That's all right. Oh, I think Advocate Noche was your opponent, is that right?
Advocate?
Advocate Noche,
Yes.
he was your opponent.
No, it was in Ngogaitobi.
It was Ngogaitobi.
Yes.
Didn't? Oh, okay, okay. Why did I think it was Advocate Noche?
Yes.
Okay, no, that's all right. So now, as an acting judge, have you dealt with matters where you have had to declare a piece of legislation as unconstitutional and decide on an appropriate remedy?
No, I've not met such a situation.
Yes. As an advocate, have you appeared in a matter where that was the issue, whether a particular piece of legislation was constitutional or not?
No,
And the
I have
court
not.
was asked to declare it or certain sections of it unconstitutional?
No, I have not met that situation either.
Yes. Okay. And in terms of administrative law, do you remember some of the issues of administrative law that you have been involved in cases?
Yeah, yes.
Do you remember some of the administrative law issues that you have had to deal with?
Well, that Kakesha case F, under the heading reported cases handled as an advocate, was whether the Premier had an obligation to first give the workers a hearing before dissolving the corporation by a proclamation.
Yes.
And then the court found that the Premier had such obligation.
Yes. Okay. Obviously, you have done a lot of motion court work as an advocate in terms of arguing motion matters. And as an acting judge, you would have done a lot of motion matters as well, isn't it? Is that
Yes.
correct?
Yes,
And civil trials and criminal trials, both as an advocate and as an acting judge?
that is correct. Yeah.
Yes. Okay. Judge President, may I hand over to you?
Thank you, ACJ. Good morning, Mazibuko.
Yes. Good morning, Judge.
Let the whole world know that I've known you for something like 43 years. Is that not the position?
That is the position, Judge President.
You were my senior at the University of Transkei when we were doing juris, and then we, at some point, converged. We became members of the then Transkei Bar. Is that not the position?
That is the position.
And we shared chambers.
That is correct. And PAs.
Yes. And is it also the position that there was a time when just the two of us were silks in Umtata, and we used to be opponents quite a lot?
Yes.
Two of those cases are actually featuring Ngokumba, the one that has been mentioned by the ACJ, and the other one is Majibi.
Yes.
No, I just thought I should mention that. Thank you very much.
Yes.
Commissioners, through you, ACJ, there's a spreadsheet that I have prepared. I do not intend reading that document line by line.
Yeah.
And it relates to basically all the candidates.
Yes, okay.
So at some point I may or I may not refer to it.
Yeah.
Advocate Tukata, the GCP has expressed certain concerns regarding your appointment. I've just got one question to pose. In your view, are the concerns legitimate or not legitimate?
Maybe, Judge President, before the candidate responds, just to make sure everybody knows what to talk about, although everybody has the documentation, if you could just say, this is the complaint or these are the grounds of objection by the CP, and then he can then respond to that.
Yes. Maybe ACJ, let me elicit from him whether he is aware that there are these concerns.
Yeah.
Are you aware of the concerns that have been expressed by the GCP regarding your appointment?
Yes, Judge President, I'm aware. I've responded to those allegations.
Yes. In your view, are the concerns legitimate or not?
The concerns, Judge President, are not legitimate. Briefly,
I'm sorry. Could they be taken like one by one? On this one, this is what they say. This is my response.
Yes.
And then, through you, ACJ, maybe to facilitate a speedier process.
Yes.
The one concern relates to your state of health, in the sense that they are of the view that it is not consistent. Well, let me put it like this. What is embodied in the application form is not consistent with those things that they have specified there. The fact that there was a time when you actually specified your health condition, and they are taken aback that that doesn't appear on the form. So we could deal with that from the perspective that you are saying the concern is not legitimate.
Judge President, about my health condition, all the information came from me, not anybody. What I wrote in the CV came from me. It doesn't matter whether at first I did not mention something, but the second occasion I mentioned it, it all came from me. So for the sake of credibility, I do not see any reason why that should be questioned. A view or information coming from me.
When you are talking about questioning, you are referring to the GCP.
That is
You are
correct.
not necessarily referring to me raising the issue at this point.
I'm questioning what the GCB is saying.
Yes. And then the other issue relates to the fact that when last we were here, there were certain concerns that had been expressed which culminated in you withdrawing from the race, if I may put it like that. And the transcript of the previous hearing says as much. They are concerned that it does not appear that you've resolved the problems that beset you, culminating in you, in the first instance, withdrawing. What comments can you proffer in relation to that?
I'm glad that Judge President, you've raised this. There was a first complaint by the Department of Justice and Constitutional Development concerning certain invoices I sent to the Office of the State Attorney in Umtata. And the GCB or the appropriate committee of the GCB sent the complaint to me and for responses, and I responded thoroughly to each and every complaint. Then the committee of the GCB wrote to me to say that you are not guilty of any unprofessional conduct. That's the wording of the committee. And the matter is closed, and the matter was closed. Thereafter, after some time, could have been 5 or 6 months, there came a complaint of the Special Investigating Unit. The complaint was based on all the invoices which had been dealt with in the complaint raised by the Department of Justice and Constitutional Development. Now, the committee of the GCB appointed an advocate to do prepare a report concerning the second complaint. And in the report of the second complaint, again, the advocate who had been appointed came to the conclusion that I was not guilty of any criminal offense. And all what they should consider is whether I'm not guilty of any disrepute of the bar. I don't understand now why would that be done, because effectively what the bar was doing was opening the earlier complaint of the Department of Justice and to the complaint of the SIU. Now, if the complaint is closed and I'm found not guilty of any unprofessional conduct, that is closed. It can't be opened again. Now, what happened is that the SIU complaint is now combined with the complaint of the Department of Justice. When both complaints have been dealt with by the GCP, and I was found not guilty of any unprofessional conduct. That is how far I can take it now.
Yes. Thank you, Mr. Tukata. Another question, maybe? In my experience, and I don't know whether things have changed now. There are constituent bar associations operating within the GCB. Is that still the position?
Yeah, that is the position.
And both the Mthatha Bar and the Johannesburg Society of Advocates are part of the GCB.
Yes.
In my experience also, when you move from one bar to another within the sisterhood of the GCB, you need to have a letter of commendation or a letter of good standing. Is that not what normally happens?
It has happened.
Come again?
It has happened.
Has it happened in this instance? Your move from Johannesburg to Mthatha, did it have the blessings, or shall I say, a letter issued by the Johannesburg Bar mentioning that you are a member in good standing?
Now, Judge President, I made an application to the Mthatha Society of Advocates for admission as a member. And I was admitted as a member. As to what was considered by the Mthatha Society of Advocates before, writing to me advising that I'd been admitted as a member, is something which I don't know.
So your answer is simply that, much as it should happen, in this instance, you don't know whether it did happen.
I don't know.
Thank you. One last question. What are your views about judicial case flow management?
I don't have much knowledge. As somebody who acts, and at times I am not familiar about what you are asking me, Judge President.
Thank you, ACJ.
Thank you, Judge President. It would be important, I see that there are various issues being raised with regard to the candidates, including references to a report of the SIU. It would be important that we cover those issues properly, So I'm just checking whether you are satisfied that they have been dealt with the candidate adequately.
Well, at the level of placing the information through the candidate, I think I've done what I could and what I should have done.
Yes, okay.
Answers were proffered.
Yes.
It's for the commission then to pursue whatever they believe requires that.
Yes.
The rest will be dealt with during deliberations.
Yeah, okay.
Thank you.
MEC Gade, may I give you a chance if you have questions for the candidates? I give you a chance now.
Thanks, Chief Justice and the panelists. I don't have a question per se, CJ.
Yes.
I just have a comment because I was a bit worried when you were probing on the implications of the invoices that were raised in the report or submission, which of course the candidate have actually clarified through the submission of the committee of the JCD. So I was a bit uncomfortable with the explanation earlier on, but as you were probing on this question, then I happen to be a bit comfortable and satisfied. So I don't have a question except that one, and I'm comfortable now out of the extensive explanation that you gave. Thanks, CJ.
Yes, thank you. Commissioner Nyambi.
Thank you, Acting Chief Justice. Morning, Advocate Tukat.
Morning, Commissioner.
The issue being raised by JP, and the last time you were here, anything that you think has changed that must make the Judicial Service Commission to seriously consider your recommendation to the President for appointment? And if nothing has changed then and now, what message do you think will be sending to the public that are following what is happening here? Given all the issues, I don't think it will be fair to take them one by one. Of course, Acting Chief Justice tried to do that, but you know all the issues. And I think the last time we were here, you decided to assist the process and do the right thing to make the standing of the judiciary in South Africa not to be compromised. But convince me to make me to understand what is it that has changed then and now, because we're still dealing with same issues that made you to do the right thing then. That's my view. Not unless you can convince me otherwise.
And before the candidate responds, Commissioner Nyambi, I do want to say, except for issues of time, there is nothing wrong with dealing with the issues, because this is an interview for somebody who, if successful, would become a judge of the High Court. And I see that there are concerns that are raised, and some of those allegations, if they were to be true, they would not qualify the candidate to be a judge. But so we need to be alive to satisfying ourselves that if we are going to recommend the candidate, we must not be seen to have swept anything under the carpet. So I just thought I would mention that it's important that we deal with the issues quite transparently.
Let me take it further, Acting Chief Justice. Part of what happened the last time Advocate Dukada was here was for him to have enough time to deal with all these outstanding issues. But sitting here today, I see not even a single issue has been attended to. And I was happy the last time I was here. It shows somebody who understood the serious implications of those issues that are still facing us today.
Mr. Dugada, you may respond.
Yeah, thank you, Commissioner. Commissioner, when I was here last time in April, nothing was posed to me by the commissioners, except for me to say that I'm withdrawing the application because my organization has not given me a certificate of clearance. And then the commission dispersed. Now, fundamentally, Commissioner, what happened was that I could see that my organization, my society, is not acting to the best of my interest, because there are two complaints, as I mentioned earlier on. The first one, in fact, both of these complaints I was exonerated. The second complaint consisted of 22 invoices. Out of these 22 invoices, 17 were invoices which were dealt with by the Department of Justice and Constitutional Development. And I was cleared as having not guilty of any unprofessional conduct. So this time is different from April, because in April I did not have a certificate of clearance, whereas now I decided to terminate my membership of the Johannesburg Bar because I could feel it's an organization which is not helping me. As to what up to now they are doing about that, because in the objections that they have just raised, they're saying that the matter is still under investigation. I'm no longer a member of the Johannesburg Bar. I don't know what they are investigating. I'm a member of Mtata Society of Advocates.
But Mr. Tugata, you can't terminate an investigation by resigning from the organization and then say they can't continue with investigating. You are a member of this organization, this society. They are investigating. You decide to terminate your membership, go to another one, and then you say, "Well, I'm no longer a member." The issues might still be alive. It may be that in terms of jurisdiction over you, no, but the issues may still be alive, and they would be entitled to say, as far as we are concerned, there are question marks on this candidate. We might not have jurisdiction over him anymore, but when he left, there were these issues that had not been resolved yet. That would be legitimate, would it not be?
My big problem, Acting Chief Justice, is that the first complaint was dealt with and I was exonerated of any unprofessional conduct. Then the second complaint by the SIU was also dealt with, and I was found not guilty of any unlawful act. All what is indicated by the person who was tasked to compile a report was that, well, this thing must be investigated. He might be guilty of disgraceful conduct. Up to now, the complaint of the SIU came in September 2018. Up to now, nothing has been done. I'm still mated. I lost the opportunity to be appointed in April this year. Now, does it mean now I'm going to lose again another opportunity because I'm still being investigated? How long will the investigation take place?
But one of the concerns which I've picked up here is that, for example, you did not disclose that there are these investigations that are alleged to be continuing, where in the questionnaire you were supposed to disclose.
No.
That, and that's got nothing to do whether you are guilty or not, but to say, you know, there are these investigations, and then say why you think they should not be given any weight.
I think Acting Chief Justice, it's mentioned in my CV that there was a complaint from the SIU. I think that is mentioned.
Well, the concern raised is that in the questionnaire you did not disclose in regard to a question which required you to disclose that.
I think it's mentioned quite clearly. Acting Chief Justice, it's mentioned in my CV.
So is your argument that you may not have disclosed it in the questionnaire, but you disclosed it in the CV, and the two were put together?
Yeah, in one of the documents, Acting Chief Justice is mentioned.
I'm sorry, I think Commissioner Nyambi, I intervened. The candidate was still responding to your question. As you complete your response to Commissioner Nyambi's question, I just want you to go back. Earlier in your answer, you said there were X number of invoices,
Yes.
and you said 17 were resolved in your favor. It looks like there are others that you haven't addressed. I don't know if I misunderstood. So if you haven't, please do address that.
Yes, I was saying, Acting Chief Justice, that out of the 22 invoices mentioned by the SIU, 17 had already been dealt with by the committee of the bar. And what was left was the 5 invoices, which I dealt with in my responses. quite convincingly. Now, what has happened now is that
But did the bar deal with those? Did the bar deal with those outstanding ones?
no, it didn't. What happened was that the bar, when it received the complaint of the SIU, opened the earlier complaint it had closed against me from the Department of Justice and combined these two complaints. Now, as to why was this combination? Because the earlier one had been closed, I was found not guilty. And even in the second one, I was found not guilty of any unprofessional conduct.
Remember, you were also addressing Commissioner Nyambi's question in terms of what is different now to the position that obtained in April when you came here. But I do recall that you said the reason why you withdrew was because there was no certificate of good standing. Is that correct?
That's correct.
You didn't withdraw for any other reason. Is that right?
Now, what I said to the Commissioner, Acting Chief Justice, is that the situation now is different from April. In April, I did not have a certificate of good conduct from my bar, which is Johannesburg Society of Advocates. But now, I have a certificate of good conduct from the Umtata Society of Advocates.
Before you terminated your membership of this Johannesburg Society of Advocates, were you concurrently also a member of the Umtata Society of Advocates?
No.
Okay, so you were just a member of the Johannesburg Society of Advocates.
Yes.
So you had issues with that society.
Yes.
And then you terminated your membership.
Yes.
They had received certain complaints and they were looking into certain complaints. You terminated your membership. You became a member of the Umtata Society of Advocates, and that society has issued a certificate of good conduct. Is that right?
That is correct. It's a society which I had been a member for 16 years before I went to Johannesburg.
And did you fully inform them of what the Johannesburg Society of Advocates was aware of that led you to terminate your membership of that society?
Yes, I fully, when I was applying for membership, I disclosed that fully.
Okay, all right. Commissioner Dodovu?
No, I'm covered.
You are covered.
I think that you and Honorable Commissioner Nyambi have extensively exhausted all the issues.
Yes.
I just have a feeling of ambivalence where I am.
Yes.
Yeah, I think it's okay.
Okay. Commissioner Makwanisha?
Thank you very much, Acting Chief Justice. Good morning, Advocate Tukata.
Yes, good morning, Commissioner.
Do you have any correspondence from the SIU that has said that they have cleared you?
The what?
Do you have any correspondence from the SIU that says that they have cleared, they are no more investigating you?
No, I did not even expect such a correspondence.
I am asking this question, Acting Chief Justice, because I know that the investigations in Umtata State Attorneys is part of a bigger investigation.
Yes.
And we have not received the final report.
Yes.
So I do understand that he has been cleared by the Johannesburg Society of Advocates, but I would be very much interested in hearing the view of the SIU, they've got a bigger in forensic investigating capability? Because I'm concerned about, for instance, the response that you say you never kept a fee book and the invoices, in fact, you do not have the invoices due to the passage of time. Now, given all of those things, I think I would have much more comfort if the SIU can give a report that exonerates you. Do you have that one?
No, I don't. I don't communicate with the SIU commissioner. I don't have any report from them.
So we can assume that it's possible that their investigations are still ongoing.
By the SIU. No, my understanding of the report of the SIU commissioner to the Johannesburg Society of Advocates, they placed information before the Johannesburg Society of Advocates, and they were seeking an opinion whether a conduct like this by an advocate amounts to a criminal offense. They wanted an opinion. That's my understanding.
Was it a preliminary report or a final report?
A criminal report?
Was it a preliminary report or a final report?
Well, I can't answer that question because it was a complaint by the SIU to the Johannesburg Society of Advocates. Whether it was preliminary or not, I don't know.
And then my last question, Acting Chief Justice. There seems to be a concern about production of judgments, that you produce judgments very late. Can you comment on that?
Well, I don't think, I think there's one judgment which is referred to in the complaint from the GCP. That case, Commissioner, it was very difficult for me to handle in the sense that it was a big case, and a day before the hearing of the case, I was given 7 legal arch files. It was in the afternoon to peruse. Then the following morning, more affidavits were coming. And then by the time the matter was heard, I had not even finished a quarter of the documents presented to me. And I was in Grahamstown, and I traveled to Mthatha where I was stationed. And when I arrived in Mthatha, I told the Deputy Judge President that, look, I have this case which requires at least more than a week for me to prepare a judgment. Even an order without a judgment. I was not given an opportunity to prepare, and then that delayed now the delivery of the judgment. I don't believe that that isolated case could be applied to me as a person who delays in delivering judgment. That I was forced by the circumstances, if you call it a delay, but counting the days, it was not an unreasonable delay.
Thank you, Chief Justice.
Thank you. So is the position that, to your knowledge, the SIU was conducting some investigations which resulted in them laying a complaint with the Johannesburg Society of Advocates against you?
Well, I'm not aware about any investigation by the SIU against me, except what was placed by it before the bar.
But did the correspondence that the SIU may have addressed to the Society of Advocates, which I assume would have been disclosed to you, did it not reveal that they were conducting a certain investigation and they came across certain alleged conduct on your part, which they then thought they should bring to the attention of the Society of Advocates?
Yeah, I would agree with you, Acting Chief Justice.
Yes. And when was that, when they laid that complaint?
I think it was September 2018.
Yes. And, but you have never found out what that investigation was about. You don't know whether it's still going on or not.
No, I would assume, Acting Chief Justice, that they have completed their investigations against me. Hence, they reported the matter to the Society of Advocates to deal with it.
Yeah, well, they might have completed, they might not have, but I think it may well be that this body should know before it can recommend a candidate who has been in that situation, whether the SIU's investigation has come to an end or not, because obviously it would be most embarrassing if this body were to recommend that a candidate be appointed as a judge, and then it turns out later after that the investigation of the SIU had not been completed, and they complete it when the candidate is already a judge, and then, for example, they say there must be criminal charges against the judge. That would be most embarrassing. One would prefer that one be certain that everything has been cleared. Would you not agree with that approach?
No, Acting Chief Justice, what is important is that one should read the report of the SIU addressed to the Johannesburg Society of Advocates. It's a full report. And it does not indicate at all that there are still pending issues to be investigated against me. And it calls upon the society to pronounce whether my conduct is a criminal.
Thank you, Mr. Tugata. Minister?
Thank you and good morning, Advocate Tugata.
Good morning, Minister.
Firstly, I confirm that indeed the chairperson of the committee is correct in Parliament that there is a broader investigation of the SIU countrywide, but far bigger in Mthatha, and that the report is not yet final, particularly with regards to Mthatha. I'm not sure on your matter specifically whether they finalize it or not. What I just wanted to find out is what the chair, when he was asking you on this response that you have provided to the GCB, that you did not keep records of bookkeeping and of the invoices because of the passage of time. What is your response to that? Because I'm struggling to understand that part. How does that lead to exoneration?
Can the minister repeat himself, please?
That you have, in your response to the complaint, is that due to the passage of time, you have not kept, you have never kept a fee book, and you no longer have the invoices that were in question.
Yes. or the invoices which were sought by the SIU.
Yes.
Yeah, because the information you wanted to dated as far back as, I think more than 6 or 7 years ago.
Okay. My second one relates to the comment, I think is the, if I'm not mistaken, is the LSSA, where they speak about a certificate of good standing and a letter of recommendation. I think it's Nadel. What is the difference of this and why that? Yes, I heard the acting CJ asking you about getting what is a clearance or whatever from the Johannesburg Bar of Advocates, but now I'm asking you about the Mtata Society of Advocates. That indeed you have a letter of or a certificate of good standing, but they did not give you a letter of recommendation. That is what is the comment from Nadel. What do you say to that?
Well, I'm not in a position to remember what Nadel is saying, but a certificate of a good standing amounts to a recommendation, as far as I can read it, that the candidate is suitable to be appointed as a judge.
Okay, thank you.
Well, I may misunderstand the position. My understanding was that a certificate of good standing says nothing more than that you are up to date with your subscriptions. It doesn't say they recommend you for any particular position. It simply says you don't owe them membership fees or things like that, isn't it?
Yes.
But why do you say it amounts to a recommendation?
Yeah, but the letter, it's a pity the letter is not in front of me, acting as Chief Justice. The crux of the letter is to motivate my appointment.
Well, we can look at that. It's just that you simply said it amounts to, so maybe what you meant was the letter amounts to. I thought what you were saying is merely having a letter that says you are a member in good standing amounts to a recommendation. And I think you agree that that alone doesn't amount to a recommendation. But you are saying this particular letter says more than that.
Yes.
Okay.
The letter is at page 18, capital A.
1-8.
Yeah, 1-8.
Yes, okay, all right. You can ask your questions and you can deal with it. Commissioner Tsepe, if you want to, it's your turn.
Thank you, ACJ. Good morning, Advocate.
Yes,
Just to follow up on the Acting Chief Justice's point about the letter. The letter from the Mtata Society of Advocates is there at page 18A. And as Acting Chief Justice states, that letter is a letter of good standing in the manner that the Acting Chief Justice understands it. It doesn't say anything more than that you are a member of the society and that you are in good standing with the society. It doesn't extend it to a recommendation.
Yes, definitely, Commissioner, because if my society writes that I'm in good standing in the organization, it means that I can be appointed in any sphere.
No, Mr. Tugata. No. You say a letter that says you are a member in good standing amounts to recommending you.
Yes.
But that can't be right.
That's what I understand.
I mean, earlier on, I said to you a letter of good standing says nothing more than that you are up to date with your subscriptions and you agreed. And I said to you, I was taking that up with you because it can't be so. And then I said to you, but you seem to be saying this particular letter goes beyond that.
Yes.
So apart from saying you are up to date with your subscriptions, it also recommends you that, and you said yes. That's why we went to the letter. Now Commissioner Tsepe has looked at the letter, and she says the letter doesn't go beyond that. And you say the mere fact that it says you are up to date with your subscriptions amounts to a recommendation. So you have told us two versions about this issue within a few minutes.
Acting Chief Justice, this letter was addressed to the JSC for a specific purpose. That is for purposes of the JSC considering whether I'm fit and proper to become a judge.
For nothing more than that, you are in good standing with them. You have paid your subscriptions, as far as I understand the position.
Yes. Well, let me just say, Acting Chief Justice, we differ on this.
You say it recommends you that you are of good character. You can be appointed to any position.
That is what I understand when it's specifically addressed to the JSC.
Commissioner Mtolo Lepu?
Justice,
Oh, you are not done.
That was not my question. I was just
okay, you're clarifying.
with
Okay.
clarifying on
Yeah,
that.
put your question. Yeah.
Thank you so much, Acting Chief Justice.
Yes.
Advocate Dugata, I just wanted to ask regarding your age. I note from your application that you are 63 years old.
Pardon?
That your age.
Yes.
That you are 63 years old.
Yes.
Is that correct?
Yes.
I wanted to find out, do you think it is appropriate for, obviously it's not a disqualification, your age, I'm just saying, is that appropriate at this stage of your age for the Judicial Services Commission to consider your appointment given your age, and that whether that would still be fine for you to serve the judiciary within the time period you have?
Well, Commissioner, it depends on the candidate this commission is looking for. If it's looking for a young person lacking experience to be groomed by senior judges, then it will appoint that young person. But if it's looking for an elderly person who is to guide young judges, then it can appoint such an elderly judge even if it's 63 years.
Thank you.
Thank you. Commissioner Mtolo Lepu.
Thank you, Acting CJ. Good morning, Advocate Dugate.
Morning, Commissioner.
I'm just disappointed that we spend so much time dealing with this issue of the SIU letter of good standing. When we were here in April, if you remember well, when we withdrew your candidates, myself and the late Commissioner Sukok, we advised you what to do. You told us that you had a problem with your Society of Advocates. We actually said, go to the LPC, we will facilitate the information, because you said to us, they don't want to give us a report. We said we'll facilitate the report. We will facilitate information from the LPC, from the ICU, whether you are being investigated or not. And from there, the LPC will actually talk to the Johannesburg Society of Advocates and the matter be cleared. We had thought by now we had done it. So I'm just quite surprised that we are still talking about the thing when we actually took you step by step on what to do. I'm really disappointed.
Jay?
I'll note you, Commissioner Noches is the next one. I've allowed more questions simply because there are serious allegations against the candidate. I don't want us to, but Commissioner Noches, have you been covered?
No, it looks like I'm covered.
It's fine, okay, all right. Mlambo JP. I'll come to the commissioners on the virtual platform in due course. I will come to them in due course. Mlambo JP.
Thank you very much, Acting Chief Justice. Advocate Dugada, good morning.
Morning, Commissioner.
My role here, representing other heads of courts, is to raise issues that are generic in us running courts. So that's why I want to raise this question. There are complaints that you were dilatory in dealing with two applications for leave to appeal. One, you had a month after judgment was handed down, despite requests being made to you, which you were unresponsive to. That's one. But you eventually had it and gave judgment. But the next one, it was the same matter, and it was only disposed of by a different judge, Judge Robertson. Do you agree with me that an application for leave to appeal is by its nature urgent and needs to be dealt with expeditiously?
Yes, I agree with you entirely.
Right.
Commissioner.
Deal with, if you don't mind, please, with the one where the parties, having elicited no response from you for close on to 2 months, had to resort to the JP, who then allocated the matter to be heard by a different judge.
Now, JP, I can't remember this case you're talking about. And there's one thing which I think you should be aware about. There was a stage when I was sick and I had to terminate my acting appointment in your office to attend hospital. And I'm not aware that there is another judgment which we're supposed to deal with yesterday. But unfortunately, one of the parties wanted to have a legal alternative. It was postponed to next week, the 14th. I'm not aware about the case which makes you to make a basis that I delay in delivering judgment, but particularly judgment in an application for leave to appeal.
Just for the record, these were Eastern Cape matters, they were not Gauteng matters. And they were around the period October to November. Thank you very much, Acting Chief Justice. The candidate can respond if he wants to.
Thank you. I'm going to allow the JP.
Yes, I would like to come to his rescue.
Yes, only now. After that, then I'll go to the commissioners on virtual, and I would like us to.
Yes.
Okay, and then that you will be the last one on this side. Yeah. JP, go ahead.
Thank you, SCJ. The matter is referred to in the list of judgments by Eastern Cape candidates. You will see Advocate Tukada's.
Can you hear Mr. Tukada?
Yes, I can hear.
Okay.
There's a judgment at page 2 of the papers, National Council of Societies for the Protection of Cruelty to Animals versus Mawashini. You will see that the judgment was reserved on 6 August 2020. And then the reasons were in due course on the 15th of October 2020 delivered because there was an order without reasons. Then there was an application for leave to appeal around November, December, at a time when Advocate Tukata, his acting stint had terminated. So my colleague will bear me out. From time to time, council will go back to chambers. They become busy. Then we invoke Section 16. We allocate those matters to judges that are available. Section 16 of the Superior Courts Act. So that is the one situation. The other situation has been alluded to by Advocate Tukata. There was an application for leave to appeal in Umtata at a time when he had been hospitalized. Those are the two instances. So his response comes closer to what I've just said. And I think it does take care of the concern expressed by my colleague. You would have seen my hand was raised earlier on. Now that I'm on the floor, I just want to harp on something.
Okay.
Advocate Tukata, will you confirm that after the previous hearing, in light of what the chairperson of the LPC had said openly at this forum, I also encouraged you to interact with the chairperson of the LPC? Will you confirm that
Yes,
that happened?
Yes, that is correct.
Thank you very much.
Thank you, President Meyer.
Thank you very much, ACJ. Good morning, Advocate Tukata.
Good morning, President.
A quick declaration from me too that you and I are old friends and colleagues.
Yes.
I just want to satisfy myself about the state of your health. And I looking at your CV and your response to, I think it was the ACJ when it was, the JP when it was, your JP when it was raised earlier, left me still, not quite sure where you stand. Are you healthy enough to undertake the rigors of judicial office? It's as crisp as that.
President, I have not been healthy, and I attended some doctors in Durban, and I've recovered fully to an extent that I'm fully active in the bar. In September, I did a case which we ran for about 2 weeks, and I see no impediment to my functioning as an advocate.
All right. Thank you very much, Mr. Tukata.
Thank you. Commissioner Klaba, I had put you down earlier on, but
Yes.
you may be covered.
I'm covered.
You're
yes,
covered.
just to
Okay,
save
thank
your time.
Thank you.
Thanks.
Commissioner Moiman.
Thank you, Acting Chief Justice. Good morning, Advocate.
Morning, Commissioner.
There's an area that is raised by both the Minister and also Commissioner Bakwanisha around pending SIU investigation in Eastern Cape. I'm raising this point so that you are able to clarify, because the report that we have is that the investigation was mainly by the department and SIU was mainly centered around your practice in Johannesburg. And the reason why I'm raising this point is by virtue of the fact that between 2009 and 2020, you were in Johannesburg. Is there, can you give us comfort that by virtue of your relocation to Johannesburg between 2009 and 2020, in Umtata or in Eastern Cape, there's no cause for concern? Because I think you have not dealt sufficiently with this aspect. What we have elaborated more is about your practice between 2009 and 2020 in Johannesburg. Thank you, Chief Justice.
Sorry, Commissioner, can you clarify the question?
The point that I want to canvass with you is what was raised by Commissioner Makwanisha and the minister around the pending investigation of the SIU in Eastern Cape. And you have not dealt sufficiently with that to the extent that you are not saying to us that, look, because you were relocated to Johannesburg between 2009 and 2020, if there was to be an investigation by the SIU in Eastern Cape, which is still pending, nothing will be or nothing will be raised that could jeopardize your fitness to hold office.
Thank you, Commissioner. If I understood your question clearly, the complaint of the SIU to the Johannesburg Society of Advocates was a full complaint. It was not a preliminary complaint. So the SIU was calling upon the Johannesburg Society of Advocates.
I'm sorry, Mr. Tugat, I'm going to intervene because we don't have all the time in the world. The question that is being raised is this. The minister has told us, as well as I think Commissioner Makwanisha, that there is a big investigation relating to Mthatha that has not been completed. The minister has said, I don't know about you in particular, but I know that there is this big investigation that has not been completed. What Commissioner Moimang is saying to you is, as you sit there, are you able to assure us that we should not be concerned that if we were to recommend you for appointment, that big investigation might not come up with something that would embarrass the judiciary after you have been appointed? Are you in a position to give this body such an assurance? And obviously, you should think carefully before you say you can give that assurance, because it's a serious matter, and one would expect that such an assurance can only be given if certain steps had been taken to make sure that definitely there would be nothing that would come out that could cause the judiciary embarrassment if after you have been appointed. That's what is being put to you.
Yes, thank you, Chief Justice. Chief Justice, my reading of the complaint of the SIU indicates that it's a conclusive document about me, about the invoices relating to me. And then the SIU wanted the Johannesburg Society of Advocates to make a pronouncement as to whether on these facts, your member is not guilty of a criminal offense. Nothing was left by the SIU. Nothing indicates from the letter that there is still some investigation about the member, about certain things. Everything is stated in that complaint. I can give you the assurance, Chief Justice, that in the event of me being appointed, there will be no such an embarrassment to the legal fraternity.
Commissioner Mtolo Zlepu said to you earlier in April, they advised you to approach them, the council, so that they could assist in all of this, so that there would be certainty and clarity. And she said she was disappointed that you didn't take up that offer. And if I recall correctly, you had no response to her. Is that correct? Why didn't you take up that offer?
Chief Justice, I soon after I left the commission, I applied for membership of the LPC and I was admitted. I'm a member. And I also applied for a recommendation. But the process.
No. Why didn't you take up this offer that was made to you, which would have brought certainty?
No, what I'm saying, Chief Justice, I took the offer, but because of the delays, this appointment came at short notice.
Okay.
Can I make a quick
I'll go
follow-up?
to, yes, Commissioner Klaba.
No, thank you very much. Good morning, Judge. Mr. Tugata.
Yes.
It's clear that you still have these allegations hanging on your head. Don't you think you still need a bit more time to deal with them, and that you came to us too soon? If you could just answer that, I'm sure it will clear the dust.
Commissioner, the problem I have is that I was here in January and my society had not issued a certificate of good standing or a certificate of a recommendation. Now, today it has, well, I've terminated my membership of the bar in Johannesburg. And there is nothing for me to say I want something else to be done by the Society of Advocates because I'm no longer a member. They cannot do anything for me.
Sorry, Judge, listening to all these matters that have been aired in this meeting, won't you consider stepping down and then coming back once all of these have been cleared? We'll have these interviews again sometime in April next year. I think you still need a bit of time to clear them out.
No, Commissioner, I don't see any impediment about what I have submitted, and I think I have made enough and compelling submissions.
You think there is nothing hanging over your head?
Yes, yes.
And that you can be appointed as a judge, there's no problem?
Yeah.
Commissioners on the virtual platform.
Yes, please. Chief Justice, it's Jonas Brandner.
Yes, go ahead.
Thank you, Acting Chief Justice, and good morning, Mr. Depara.
Morning, Commissioner.
How are you?
I'm very well, except
Good.
that.
I have two questions for you, sir. You say in your CV, you say during 2019.
Can you restrict it to one, Commissioner?
Well, they're interrelated, Acting Chief Justice.
Okay.
Mm-hmm.
You say during 2019, the Special Investigation Unit lodged a complaint to the Johannesburg Society of Advocates against me. I dealt with the accusations, and the Professional and Fees Committee of the bar sent to me a report exonerating me of any criminal offence.
Yes.
You then tell us today that you regard that as having cleared you, and you don't know what the status is of the SIU report. My question is this: do you, with your experience at the bar, and particularly as a prosecutor, think that the Professional and Fees Committee of the bar can exonerate you of a criminal offence? A, and B, why have you not approached the SIU? They're the people who are investigating you.
Yes.
And any person, when they're being investigated, presents themselves for investigation. Why have you not gone to the SIU and said, here I am, what do you want from me? Let me help you get this thing done. It's becoming an irritation. If you could just answer that, please.
Yes, I'm trying to understand you, but you're a bit fast for my ears. Can you just put it in a...
She is saying, at least the second part, why didn't you go to the SIU and say, are you still investigating me? what do you want from me? I want this investigation to be finalized as soon as possible. I'm available to answer whatever questions, because this investigation of yours is taking too long or is an impediment on my career.
Well, I didn't find that necessary at all, because the committee of the Johannesburg Society of Advocates appointed an advocate to do some investigations. And that investigation was done, and I was exonerated from any unprofessional conduct.
Commissioner Breitenbach, I think there was an earlier element another element to your question.
There was, thank you, Acting Chief Justice. In your CV, sir, you say that the Professional and Fees Committee of the Bar exonerated you of a criminal offence, not of unprofessional conduct. My question is this: how can they exonerate you from a criminal offence? It simply isn't possible, and I'm sure you know that.
No, these exonerated, I think I said exonerated from any unprofessional conduct.
I read to you exactly what you said in your CV, sir, and you referred to criminal offence.
Now, the response is very clear from the committee of the Society of Advocates that I was exonerated from any unprofessional conduct.
Okay, I guess you are done, Commissioner Breitenbach.
Yes, I am. Thank you.
Thank you. I think we have come to the end of the interview.
Thank you.
Thank you very much, Mr. Tugada. You are now excused.
Yes, thank
you. Chief Justice, Commissioner Barnard here.
Oh, yes, I'm sorry, Mr. Tugada. Yeah, Commissioner Barnard, I'm sorry. You have a question?
Yes, I have a question. I just apologize. I'm having an issue with my camera, but I'll try and sort it out in the next break.
Okay.
If I can just, it's a follow-up really on the questions that have been asked by Commissioner Lepu and Dennis Breitenbach, and I'll try and do it in one. It was pointed out to you in the last interview by Commissioner Lepu that your organization can recommend you, but the clearing should come from the Legal Practice Council. So my question is, do you have a certificate of good standing from the Legal Practice Council? And secondly, why did you not attach a copy of the report which you said exonerates you from any criminal offence? Why did you not attach it to your application? Thank you.
The report about exoneration from any unprofessional conduct forms part of my application. I expect that all the commissioners have that report.
Okay.
And secondly, the LPC, I don't have any recommendation from the LPC because of time constraints. It was in the process, and I even asked even yesterday whether they are ready, but they were not ready.
Commissioner Lepu, do you want to say something about this?
Yes, Chief Justice Babu Dugard. I take an exception in that I don't think the LPC, once you want to enroll, you need a certificate of good standing. There's a rule that it's a rule that they have to give a legal practitioner within 7 days. So if we had gone, in any case, we didn't, what we wanted to do was to facilitate the bar issue and the SIU issue so that you shouldn't be left with a cloud hanging with the bar. Remember, the bar and the SIU, we are a regulator, we work together. We cannot exonerate you without hearing from others. So they would have given you. So, and at the same time, if there was still a complaint from the bar, we wouldn't have given you that certificate of good standing. We would have said to the bar, what is wrong?
Yeah, okay, all right. Okay, thank you, Mr. Tugata. You are excused.
Yes.
Next candidate. Good morning, Mr. Dunyan.
Good morning, Chief Justice and Honorable Commissioners.
Thank you very much for availing yourself for consideration for appointment as a judge of the Eastern Cape Division. I see that you hold the degrees of B. Juris, LLB, and LLM, is that correct?
That is true, CJ.
And you obtained these degrees, the B. Juris from the University of Zululand, the LLB from UNISA, and the LLM from the Nelson Mandela Metropolitan University, is that right?
That is true, CJ.
Well, if you obtained your B. Juris in 1983 from the University of Zululand, then you must have been in the same class as me.
I was your senior, CJ.
My
tax.
But I see that we may have gone to different universities, but must have become your senior when we did LLB.
That is true, CJ. I was doing
I
my...
overtook you.
Yes, you did, CJ. You did.
Oh, no. So you would have been, what, 1 year ahead of me?
Yes, CJ. I came to University of Zululand in 1980.
Oh,
Yes.
yeah, because I came in 1981.
Yes, CJ.
Okay. No, it sounds like a very long time ago.
That is true, CJ.
Yes. Okay, no, thank you. And you started your working career as a clerk in the Department of Justice in 1981. So you must have been on government bursary or something?
That is true, CJ. I was awarded that bursary in 1981.
Yes, okay. And then 1983 to 1984, you were public prosecutor.
That is true, CJ. I started to work in Manfred in 1983 as a public prosecutor.
Yes. And you began as an assistant magistrate in 1984.
That is true, CJ.
And that went up to 1986. And then in 1986 to 1990, you were a magistrate.
That is true, CJ.
Yes. And in 1998, you were a regional court magistrate. Is that right?
That is true, CJ.
I'm skipping the senior magistrate. I'm skipping the senior magistrate.
Yes, that is true, CJ. After acting also as a regional magistrate in 1997, Butterworth, yes.
Yes. So at this stage, you remain a regional court magistrate.
Currently, I'm the regional court president of the
Regional court president, yeah.
Yes.
That is from 2013.
Yes, CJ.
Yes, up to now.
But having acted also from 2010.
Oh, okay. Now, during this time, when you were a magistrate, senior magistrate, and regional court magistrate, up to president of the regional court, have you been exposed or have you dealt with civil matters in those capacities?
I didn't do much of civil, CJ, in those years because we were head of offices who were dealing with those few cases, more especially those involving customary law. There wasn't much of civil on its own, but you had few of those cases.
Yes. Okay. Let me just say, only acting CJ.
Thank you, CJ.
So how much exposure to civil work have you had?
I did have the exposure of civil work here in regional court, CJ, but the most serious part of it is in high court when I was acting for the period of plus minus or more than 1 year. The most part of my civil is the high court one.
And that was from when to when? The 1 year was from when to when?
It was different stints, CJ, but I think I started in 2011. But
Yes.
I also acted in 2014 and 2016, and mostly in 2020 and 2021.
Are you able to, when you said it was about a year, so I guess that when you put all the acting stints together, they make more or less a year. That's what you meant.
I meant, CJ, they make more than 45 weeks if I
Yes.
include the period when I would act during recess. But
Oh.
the period when I was acting with a judicial appointment, it is 45 weeks.
Was there a period when you were acting without a judicial appointment?
I mean, CJ, the period where, for example, one is finalizing cases from
Patent matters.
patent matters,
Yeah.
yes. That is the period
Yeah.
I'm including, yes.
Okay, but so when you include everything, when you were seized with high court work,
Yes.
You say it would be about 45 weeks?
Yes, CJ.
Yes, okay, which would be just under a year. Because in a year, don't we have 52 weeks?
I mean, CJ, I exclude the periods where there is recess. I was just including only the period where you are taking a term and then exclude the recess. I didn't include it.
So if you include all the times when you were busy with high court work,
Yes.
It would go up to how many weeks if you include that, more or less?
More or less, I would say 46 to 47 weeks if I include the recess periods.
Yeah.
But the ones where there is no recess, specifically, they are 45 weeks from my calculation.
Yes. And so you say when it comes to civil work in the regional court and magistrates court, whatever exposure you had there was quite limited.
But the one in regional court, CJ, I cannot necessarily say it was limited because as a judicial officer, I normally visit other centers where I hold courts, and I was also responsible for the civil implementation in the province of the Eastern Cape since regional court civil started from 2010.
Yes, but I just want to make sure we are on the same page.
Yes.
I'm talking about actual adjudication of civil
Yes.
matters.
Yes.
And maybe motion court and trials.
Yes, yes.
How much exposure did the regional court give you to that?
It did not give me the same extent which I got in High Court. The
Yes.
High Court one is more than the regional court one. And the reason for that is because each time I was acting in the High Court, I was just given civil to do, not criminal court.
Yes. And do you remember more or less how many judgments in civil matters you wrote in the regional court?
In regional court?
Yeah, in the regional court.
I don't think they exceed 10, CJ,
Oh.
acting CJ.
Okay.
But I'm not used to say acting.
But that would be limited, would it not be?
Yeah, it is limited. My highest civil experience is in High Court.
Yes, okay.
Yes.
And in the High Court, how many judgments more or less have you written on civil work, civil cases?
CJ, I cannot.
Just an estimate.
I think even the latest one, which I was writing now, consists plus minus 14, just from 2020 to 2021. I don't know now if I add all of them, including the 2014, the 2016, and the 2011.
You say there are 14 that come from your most recent acting.
The recent acting under the current judge president, yes.
Yes.
More or less, but I'm not accurate.
Yes.
Yes.
So do you think if you look at all your acting stints in the High Court, they might be more than 30?
They can be more than 30, JP.
Yes.
Yes, acting CJ, sorry.
Yes.
Yes.
And are there any of them that have been reported in the South African law reports? Or any of those reports that we normally use?
Unfortunately, CJ, I only have those reported in SAFLI, not in the South African law reports, yes.
Okay, all right. Now, what types of branches of law have the civil cases that you have dealt with fallen under? What branches of law, more or less, do they fall? Contract, matrimonial, competition matters, common law competition, constitutional litigation, administrative, customary law, delete, whatever.
Although I cannot recall them all, CJ, but I remember the first case I did in Mtata was related to the continued injury in the medical negligence. And other cases I've dealt with also include RAF, some include the Mandament Funds Poly, and some in the opposed motion court, included contracts and dealings, yes. Yes.
Judge President.
Thank you, ACJ. For the sake of expediency, I've prepared a spreadsheet, CJ, and maybe we would move swifter if we were to make use of it. Good morning, Mr. Tunywa.
Good morning, JP.
At page 3 of the spreadsheet, it sets out the acting stints during my JP-ship.
Yes.
Starting from 13 April up to and including 26 March 2021.
Yes, JP.
And then at page 4.
Do I have it here, JP? Or is it?
You're supposed to have it.
Oh, yes.
It's headed List of Judgments by Eastern Cape Candidates, JSC, October 2021.
Thank you, JP.
But you are being supplied with one now for the sake of
yes.
expedience.
Thank you, JP.
Let's go to page 4. Is it so that you've written judgments in 3 opposed applications?
I agree. Yes, JP.
And then 2 civil trials?
Yes, JP.
1 criminal trial?
Yes, JP.
And then 2 bail appeals?
Yes, JP.
3 criminal reviews?
Yes, JP.
When I started as well, way back then I was acting Deputy Judge President in Umtata. You will recall that there was a meeting involving yourself and regional magistrates. The concern expressed at that meeting was that civil cases justiciable in the regional court tend to serve before the High Court. And as a result of that, the role of civil trials is huge in Umtata and at the other centers, of course. You can bear testimony to that litigants tend to avoid the regional court and choose to go to the High Court by virtue of the fact that it's got inherent jurisdiction anyway.
That is true, JP. And even when I was introducing civil implementation myself in Port Elizabeth, where I was meeting legal fraternity of all centers, I was told the same, that regional magistrates do not necessarily have the same experience as the High Court when it comes to civil.
Yes, and you will bear testimony to the fact that sometimes it is good to have regional court magistrates acting in the High Court purely for one reason, so that they can emulate the work ethic of the High Court and plow it back in the regional court.
I can bear testimony to that, JP, because even myself, all what I learned in the High Court stints, I was able to introduce it in the regional court. And even above that, I remember that at one stage we had a meeting together where you indicated that we need to exchange the training. You give me the advocates to be trained in criminal law, and I also give you regional magistrates to be trained in civil law. And I also benefited from that.
Yes. And then lastly, you will also agree with me that in the High Court, the challenge is more civil cases than criminal cases. I'm not looking down upon criminal cases, but all I'm saying is the civil jurisdiction of the High Court is much wider, and it requires expertise in civil trials as well. I'm sorry, civil cases generally.
That is true, JP. I agree with you there. And it is in line with the fact that even my exposure to High Court is mainly civil, because of the fact that it was intended that I must gain more of civil than criminal exposure, which I already have.
Yes, lastly, if you've got 5 judgments penned from the period 13 April to 26 April 2020, or let me say the 3 acting stints you've had, you've got 5 judgments that you've written. You agree with me that more mileage, if it were to be gained, would place you in a better position?
Considering the fact that, JP, I'm not necessarily able to count the ones I did before, I would think that I have already done more mileage because of the fact that during this period I was acting, it was during the COVID period when court would not necessarily sit as usual, like it would have been under normal circumstances.
Thank you, CJ.
Thank you. Mr. Gade, MEC Gade, if you have any questions, I give you an opportunity now.
Once more, thanks, CJ, and thanks to the panelists. I don't have a question thus far, CJ.
Yes.
I would plead with you that let's proceed, yes.
Yes, okay, thank you. Mr. Dunya, have you, during your action stint, dealt with cases where legislation is challenged as being unconstitutional and you had to consider what remedy you should give?
Unfortunately, CJ, I have not done with the with the invalidity of the Act of Parliament and its unconstitutionality. I have not. I've just applied constitution in the normal day-to-day application of law, which is the Supreme Court of the Supreme Law of the land in any way.
Yes. And have you dealt with motion matters?
Yes, CJ, I've dealt with motion matters. For example, I remember one of the strongest place when it comes to motion court is Mtata. I remember that at one stage I was also following JP to be at Mtata when I had 133 cases which I had to do in one day.
Yes.
And I have also done opposed motion more during my previous stints of 2014, 2016. And I have done motion court in all the divisions, Port Elizabeth, Grahamstown, and Mtata, inclusive.
Okay, commissioners. Commissioner Tsepe.
Thank you, ACJ. Good morning.
Morning, Commissioner Tsepe.
There is a complaint lodged by, I think, Mr. Mbagaza against you. Have you had an opportunity to look at that?
I did, Commissioner.
And would you like to address us on that issue?
I can, Commissioner.
Please, thank you.
Mr. Mbagaza was the former deputy DPP of KZN, and his wife is working as a regional court magistrate in Zwelitsha. Apparently, he phoned me at one stage about the complaint he had with his wife, which necessarily was involving him and his wife, but I could not necessarily make head or tail of what he would like me to do. But later on then, I was told or informed by police at Zwelitsha from the Hawks department that they wanted me to give them an itinerary of all the journeys which were undertaken by Mem Kangani, the wife of Mr. Mbagaza. And I supplied the the itinerary to the police. I think it was a constable or Sergeant Bandy by that time. But later on, Mr. Bandy also said to me that he would like that to be commissioned and made a statement. Later on then, I then commissioned that and I made it to be a statement which was handed to the Hawks. But I think it could have been misunderstanding on the side of Mr. Mbagaza to think that I did not respond to that. I did respond, and I have a letter from the head of the Hawks which confirms that I did so, as well as the letter also which comes from our office which indicates that we complied with the request which was coming from the police.
Thank you, Mr. Have we been supplied with those letters?
We do. I don't have it with me, but I sent to the secretary, Ms. Kutwana. Yes, okay. The two letters.
Okay. Thank you, ACJ.
Thank you very much. Commissioners on the virtual platform, is there anybody with a question there? No question there. Is President Meyer?
Thank you, ACJ. Good morning, Mr. Dunyu.
Good morning, President.
I'm just
Meyer.
trying to find this commentary now. One of the professional bodies said something about, they expressed a concern about your health. And I was looking at your CV and I see nothing that indicates that you page 7. Well, you know your health situation best. What can you tell us?
I know my health situation best, Commissioner. The only thing which I developed, I think from around about 2010, was diabetes, which is the lifestyle disease. And later on, I developed hypertension. But I'm managing all that because I conducted even, what do we call this doctor? There is Dr. Yuri in Port Elizabeth who told me that the best thing to control your blood pressure, your sugar, is your diet. For example, I'm not as I was before. Anyone who had seen me before, I had a big stomach. Now you can see that I'm relying on vegetables and fruit, and my health has improved seriously. I don't think I have a complaint about my health. But maybe the only thing which I can mention is that maybe somebody who could have seen me after the acting stint in Grahamstown, I contracted COVID. And then it was at that stage that I was seriously ill and I woke up from the deathbed. Maybe somebody who might have seen me at that time then could have been able to say my health is a problem, or maybe there's something wrong with it. But from my side, I feel much younger now.
Okay, so in sum, those health conditions are under control?
They are under control, President.
Yeah, okay. Judge President Mlambo.
Thank you very much, Acting Chief Justice. Good morning, Mr. Dunyu.
Good morning, JP.
Just two very short points from me. I feel a bit bad that you haven't bragged enough in your CV. Why didn't you tell this commission that you also served in the National Judiciary IT Steering Committee?
I think it could have been my oversight then, JP, because that is where we managed to have many things for the lower court as a result of the chairmanship that you have for us in that JAIT meeting. That JAIT meeting is the one where we have since now established our own lower court JAIT, so that it must be a subcommittee to your own JAIT, because you you were always complaining, why are you not coming up with things from the lower court so that we understand why your IT is not necessarily up to date? And we are coming with those things now.
No problem.
Yes, Judge.
All I wanted to say is you're one of the pioneers in the regional court magistracy who is leading the judiciary to the fourth industrial revolution, isn't it?
Thank you, JP. That is true. When it comes to statistics, I think I mentioned that in a way to say, for example, for regional court, we develop statistics which are such that if you are a head of court, you must be able to monitor your region as a whole. When I'm sitting, for example, in Port Elizabeth or Kabeja, I'm able to know how many cases are outstanding in Kumbu. I'm able to know how many cases are outstanding in Alwal North. I'm able to monitor and see that the workload is going down in such and such a place.
Mr.
Yes.
Dunya, thank you very much.
Thank you,
I
Jay.
just wanted to help you brag about what you did.
Thank you, Jay.
Thank you, Acting Chief.
Thank you very much.
Thank you, Jay.
It looks like there are no minister.
Good morning, President.
Good morning, Minister of Justice.
Yes, I want to just take from where the JP ended. You are firmly aware of the ransomware that has attacked the systems of the department.
Yes, Minister, I'm aware.
I know that you are also involved in the processes of the restoration and all that. What would you want to advise the department and government in general, even the judiciary, as we now moving to the digital platform to protect ourselves in terms of cyber attacks and cushions?
Minister, that is a difficult question for me because I'm not necessarily, although I know or I'm more interested in statistics to the extent that at one stage, I remember that some of your directorate had to come to the Eastern Cape when we were fighting the issue of ICMS, saying that you can improve ICMS and do it better in this way. But the issue of cyber attack is not necessarily something I think can be within my good knowledge. But the only thing that we were saying was that it was necessary that at least the department must find other solutions, which in fact they did find other solutions because magistrates were complaining about the fact that they don't have claims. There were issues of maintenance not being paid to children, but those things have been done now, and we are really happy that at least those things have been corrected. But to say what remedy cyber attacks can be prevented by, I don't think I can be good enough to give you that advice, Minister.
Yeah, I'm asking you deliberately because I also know that the office of the OCJ at some stage had the same challenge.
Yes.
And it does look like it should not only be the department that and OCJ that prepares itself.
Yes.
You have that committee of magistrates and so forth.
Yes.
It does look like we all have to work together.
Yes.
To ready ourselves for this new world.
Yes.
So maybe that is it's what I was asking you to say. What do you think from your levels also as magistrates should be done that will also prepare yourselves to this reality of this new world?
Thank you, Minister, for that one. I agree with you that having developed or formed this new committee which deals with IT in the lower court, we interact with your people almost time and again. They reported to us time and again as to what is the latest information they have and what has been done by the department. I agree that is the best solution now, because we have been saying even before that the department must not develop new things without us being consulted, because those things, those engagements can make the system to be better. For example, we were saying some of the ICMS solutions are not necessarily what we need as judiciary, because as judiciary, we need an information which tells us how to manage our courts efficiently. But now that we are interacting time and again, we are able to inform our courts, and we are able to make some other means, for example, of saying, rather than for the regional court to be sitting in a particular place on a particular day, it can sit in another place so as to cure maybe a problem of SOS machines which is not working in that particular place.
Thank you. Thank you. Commissioners on the virtual platform, or had I asked them? Yes. Okay, I think we have come to the end of this interview. Thank you very much, Mr. Dunya, for availing yourself. You are now excused.
Thank you very much, CJ and commissioners. Thank you for the opportunity that you have given to me.
Thank you. Next candidate. Let's start. Good morning, Mr. Ngumsen.
Good morning, Acting Chief Justice.
How are you this morning?
Well, Chief Justice, I'm well as far as I can be.
Okay. Okay. Well, welcome to this interview session of the Commission, and thank you for having availed yourself for consideration for appointment as a judge of the High Court of the Eastern Cape.
Thank you, Jay.
I see that you hold the degree of BProc and then an advanced diploma in labor law and a postgraduate diploma in criminal justice. Is that what it is?
Yes, yes, ACJ.
Yes, and you obtained your BProc from the University of Fort Hare in 1991.
Correct, ACJ.
And your advanced diploma in labor law from the University of Johannesburg in 1998.
Correct, ACJ.
And the third diploma from the Nelson Mandela Metropolitan University in 2013.
Correct, ACJ.
Yes. And you started your career with the Department of Social Welfare as an administrative clerk in 1986, is that right?
Correct, ACJ.
and later on you went to the Department of Justice and as a public prosecutor.
Correct, SJ.
And in 1994, you became a magistrate. Is that right?
Correct, SJ.
And that went up to, you were in, is it Paddy?
Yes.
Yes.
Yes, SJ.
And then later you were in, I can't see, Komani, is that right?
Yes, SJ.
As a magistrate. And then as a senior magistrate and a district head in 2000 to present, is that right?
Correct, SJ.
Yes. As a magistrate at different levels thereof, have you had exposure to adjudicating civil cases?
Correct, SJ.
How much exposure have you had? Can you give us more information?
As a magistrate, SJ?
Yes, as a magistrate.
As soon as I got to Komani, which was in 1998,
Yes.
I was thrown into the deep end to do a civil matter, which was complicated in nature at the time. And I think this was just testing my mettle. And that matter, incidentally, was a matter in Afrikaans, or it involved Afrikaners, which I had to handle. And after having dealt with that matter, which went even to the appeal in the Grahamstown High Court, and it was upheld, I developed love for civil, and thereafter I never stopped to adjudicate in civil, and it became my forte in that I spent most of the time in the civil court, much as I also dealt with criminal work.
So you say from 1998 you have been adjudicating civil cases.
Correct, ACJ.
And did that change when you became district head, or did it not change?
It didn't change, ACJ. In fact, when I became the head, that's when the volume of civil work for me increased, because in most instances, in our courts, in the lower courts, civil becomes the domain of the district head. So instead, it increased for me.
Yes. So the picture you give us is that for more than 20 years, as a magistrate, different levels, you have been adjudicating civil cases. Is that correct?
Yes, ACJ, I have been, though it depends how busy the court is in civil litigation, but I have been adjudicating civil work right through my career in the district court. But
Now,
yes.
Yes, go ahead.
Particularly from 1998 and 2000.
And have you got an estimate for us of how many judgments you have written over that period? 300, 500, or more than whatever the number is?
I would prefer to be modest, ACJ, and say probably 300. I didn't count, and I'm sorry
Yeah.
that I
No,
didn't
no,
do
no, that's
that.
fine, yeah.
But I would rather choose to be modest and say not more than 300.
You say not more, do you mean not less than? Or?
Not less, sorry, not less than 300.
Yes,
Yes,
okay.
yes,
So
ACJ.
there's a chance that they could be 400
They-
and so on,
yeah.
but you want to stay with a number that you feel more comfortable with.
Correct, because they could be more in that I was involved in civil trials as well as the motion court. So there would be from time to time matters that arise at that stage.
Yes. Now, in motion court, in the magistrate's court, how heavy would that motion court be most of the time?
We held our motion court, which is still the practice now, ACJ, on Thursdays.
Yeah.
Especially before the National Credit Act, one would get plus or minus 30 to 40 files per motion court day.
Yeah, okay.
Yes, yes.
And what percentage of that would be opposed motion matters? More or less. Would it be about half of those or less?
Probably 30% to 35% would be then opposed matters, ACJ. Yes.
Okay.
Yes.
And in terms of what branches of law the motion court and civil work covered, are you able to give some indication?
Well, our civil work would cover a couple of areas, but mainly delict, damages arising from unlawful arrest and detention, defamation matters. Well, of course, in the motion court, various kind of applications would surface, exceptions, and of course, the bulk of the matters would be those that are related to debtors. Yes.
Okay. Judge President.
Thank you, ACJ. You've acted in the High Court, especially during my JP-ship, and you've also acted in Gauteng for a full term.
Correct, JP.
I was reading the spreadsheet 2 nights ago, and I must say I was in awe upon seeing that you've written 25 opposed application judgments.
That's correct, JP.
2 urgent applications, judgment on 2 urgent applications.
That's correct, JP.
12 civil trials.
Correct, JP.
6 criminal trials.
Correct, JP.
9 criminal appeals.
Correct, JP.
3 civil appeals.
Correct, JP.
1 criminal review.
Correct, JP.
And as I understand it, you are more steeped in civil work as a magistrate than otherwise.
That's correct, JP.
Do you implement any case flow management in the magistrate's court?
Yes, we do, JP.
In 2 or 3 sentences, what is your understanding of judicial case flow management?
Well, JP, the judicial case flow management is intended, among others, to track the pace of the cases. It is to try and find out whether there is also any issues that can be narrowed in the cases with the litigants, and to try and see as to how can we reduce the delay of cases ultimately getting to trial.
Thank you, CJ.
Thank you, Judge President. MEC Gade, if you have any questions, I give you a chance to ask them.
Once more, thanks, CJ, and thanks to the panelists. Thanks for the opportunity. I just want to have one question to candidate CJ. Have you ever ruled against any piece of legislation and declare it as unconstitutional? If so, what was the matter at hand?
Thank you, MEC. I haven't had the opportunity to declare a piece of legislation invalid or inconsistent with the Constitution. I haven't yet dealt with that area.
Are you done?
Thanks, CJ.
Thank you. Commissioners, yes, Commissioner Dodovo.
Okay, thank you very much, ACJ. Thank you. Good morning, sir.
Good morning, Commissioner.
Okay. What is an interlocutory application and what are its benefits?
And what is?
An interlocutory application.
Yes.
And what are its benefits?
Well, an interlocutory application can arise when in a matter that is before court and that there is something a party has picked up in which he or she wants the court to deal with first. An example, an interlocutory application may arise where a party may apply to the court to strike out, where a party may apply to the court for an exception on a particular issue that had arisen in the matter. And so the interlocutory application has got a benefit that it can dispose of a matter which the court would have been seized with and burdened with. But through that interlocutory application, the matter then is disposed.
This applications applicable to the civil matters or criminal matters?
They are applicable in the civil litigation.
All right, thank you very much. Thank you, ACJ.
Thank you. Commissioner Tsepe.
Thank you, ACJ. Good morning.
Good morning, Commissioner.
There are some objections that you have received.
Yes.
Some from the BLA.
Yes.
And some, I think, from the LSA.
Yes.
LSA.
Yes.
Would you like to address us on those complaints, just so we can hear your views on it?
Thank you, Commissioner. Upon reading the comments by the BLA, I gleaned that their concern is on two areas. One, it's in the area of having accepted a nomination from a particular advocate. I'm not sure whether I should mention the advocate. Should I mention the advocate? I don't have to. Now, BLA's concern was that it appears to them that this candidate, this advocate, has been harsh or has espoused views against a certain political organization. And the BLA therefore is suggesting that I should probably have turned down that nomination, or alternatively had asked the nominee to change his tone. My view on the matter is, fortunately, this advocate had attached the judgment concerned. And the judgment concerned, which I penned down, does not pronounce anything on the views expressed by the nominee. The judgment is very clear that it was focusing on the actors, and the actors in that matter was the plaintiff, whose complaint is that he was unlawfully arrested and detained. And my other concern, which is the actor in the matter, is whether the police have acted lawfully. Now, I had no interest in examining whether there's collusion between the IEC and the ANC, which is expressed or which seemingly is concerning the BLA in the nomination letter. Now, Commissioner, I do want to say that it is difficult to argue with someone on his or her views and opinions he or she holds, which has got nothing to do with me. And in this particular instance, I've got nothing to do with my judgment. And so that's how I can respond to that concern. I know the BLA has even suggested that I should apologize to this commission for having accepted that kind of nomination. I think that's too harsh. Let me address the second concern. The second concern is that the BLA seems to have committed an error, and that I say with respect, in that they've miscalculated my acting period and suggest that I've not acted enough. And as a result, much as I have a potential, their view is that I need to act more stints. Now, I don't think the BLA has taken into account a certain period which I've acted, that is 2019, where I've acted for 4 full terms in the Eastern Cape Division. That on its own, I think, would qualify me. And furthermore, I believe that my mere shortlisting suggests that I had met the requirements. So those are the two concerns that I find in the BLA's comment, unless there's another one. And quickly to the LSSA one. Now, the LSSA one relies on a matter of Manqina. Well, they have raised 2 areas. One is the case of Manqina, which was overturned on appeal, and the other issue they have raised is their concern in a matter in which I have not ordered costs at magistrates' court scale. Now, I'll start with the Manqina matter. I must say, Commissioner, rightly or wrongly, probably I was very adventurous in the Manqina matter. Because in the Manqina matter, notwithstanding the provisions of Section 17(6) of the Road Accident Fund, I looked at it in a more progressive way to say that really could the legislature have intended that a person of straw like a mother in Mtanzane who does not have the money to spend for her child who needed a special school, and she doesn't have that money to spend, is she precluded? And I'm saying that probably I was adventurous because the appeal court had turned me down, which I accept. Now, that matter was decided on my second stint in the Eastern Cape Division. It was early in 2019 when I had my second stint. And if the concern is that in light of that case, I need more acting stints, I think, Commissioner, the events must have render that suggestion now a bit late, in the sense that since that matter, I've had another long acting stint in the Eastern Cape Division and in the North Gauteng High Court. So I've learnt from that case, and I have been exposed even further. Now, the last issue the LSSA has raised is the issue of costs. Now, in the Van der Westhuizen matter versus Rigas, I didn't order costs at the magistrate's court scale. Well, of course, it's at the backdrop that costs is at the discretion of the judicial officer. I did not, even though the award I gave to the plaintiff is 60,000, I did not. The reason is that that matter to me had serious undertones. And the undertones that I identified in that matter, which I have not in so many words raised in my judgment, is that that matter has a racial undertone. If you had read that matter, you will find that the defendant says to the plaintiff, don't drive like this in Beacon Bay. Go and drive like that in Duncan Village, where there are people of your color at Duncan Village, because I have love for the children of Beacon Bay. Now, which I've raised in the judgment, my question was, if he's got love for the children, why would the children of Duncan Village, why would they be exposed to negligent drivers, right? And therefore, I did not order costs at the magistrate's court scale because of what I regarded in that matter as that I wish the defendant to understand the import of his attitude. I didn't. The Mbilini matter, which they are referring to, that which they are saying that, look, the judge may have been correct, is that in that matter, which was concerning Paia, much as I ruled in favor of the state institution, the organ of state, which was government, the manner in which that case was litigated and the tardiness with which the government handled the matter, I felt that despite having won the matter against the civilian, and not having ordered cost Dei bonis proprius against the attorney, I rather would order costs that each party pay his own costs. Now, that matter, if you had read it, you would have seen that the application for information was sent to the National Office of SOCDEV, Social Development. The National Department did not immediately return or send it back to say that, no, you are knocking at the wrong door. You should knock at the Eastern Cape Social Development. So there was tardiness to a point that the process went as far as the applicants now making an appeal in terms of Paia. It's only then that the National Office became alert and aware. And they said, no, we have transferred the matter to the Eastern Cape Social Development. Now, I'm saying, when it comes to costs, that look, much as SOCDEV has won, because I found that, look, the information that they had supplied should be sufficient. I then felt that I will order each party to pay its own costs rather than mulct the civilian. Those are my responses to LSA as well as the PLA Commissioner.
Thank you so much, Mr. Moose. Thank you, ACT.
Thank you. I have Commissioner Madonsela and Commissioner Mpofu, and unless somebody feels strongly, would be reluctant to take somebody else except for the ones on the virtual platform. But if somebody feels strongly, they'll indicate to me. Okay, Commissioner Madonsela.
Thank you, Acting Chief Justice. Good morning, Mr. Ngumse.
Good morning, Commissioner.
You did the right thing to go and attend Bethel College in 1982. That's my alma mater.
Oh, I didn't know. Thank you.
Can a magistrate declare a statute unconstitutional?
No, no, Commissioner.
Thank you.
Commissioner Mpofu.
Thank you. Good morning, Clarence.
Good morning, sir. Good morning, Commissioner.
Yes, mine is a very short one, but I just wanted to tell the DCJ that that place that the person said they must go and drive recklessly in Duncan Village, that's my birthplace.
Is it? I didn't know. There are so many coincidences here that I'm hearing.
Yes. Yes, no, I just wanted to, I see that you, like other applicants, have indicated that you would, you are applying for either Mthatha or Grahamstown.
Yes, Commissioner.
Or Makanda, actually. There's no
Yes,
such place as
it's Grahamstown, yes.
Do you have, just as a matter of interest, would you have any preference? If you qualified for either place, would you have any specific interest? And I say that for a particular reason. That reason is that, and I might be right or wrong, my view is that we probably need more black judges in places such as Grahamstown and Kabeja, I mean Makanda and Kabeja.
Yeah.
So can you answer that question in that context?
To be honest with you, Commissioner, I didn't have a particular preference, and the simple reason is that in my earlier days on the bench, I've worked, I would say, as Lalin. As the SCJ was reading, I worked in Ngushwa, Pedi, so I worked with Omama with big dukes. Queenstown is a semi-rural place which incorporates a lot of villages and ilalis, so I don't have a problem to be in Mthatha, which some people would not probably prefer. Neither would I have a problem to be at Grahamstown, any one of them. Well, Grahamstown would be, of course, advantageous in terms of distance for me, but I don't have a specific reason. I don't.
Thank you. Thank you, Chair.
Thank you. Thank you. Commissioners on the virtual platform, is there anybody with a question there?
Thank you, CJ. It's Jenny Kane speaking.
Yes.
Good morning.
Good morning.
I would like to just assist you in one regard. We only need one letter of nomination, and I understand you have a letter of nomination for both courts from Nardell. And so even if there were a problem with the other individual, which I think you adequately addressed, it would be fine. But I just also, for the sake of good order, wanted you to very briefly cover the objection raised by Mr. Steyn, where he says that you were presiding in matters where the attorney for one of the parties was a woman with whom you'd had a child and were living with. If you could deal with that very briefly.
Thank you, Commissioner. Well, Commissioner, what is troubling in Mr. Steyn's matter is the misrepresentation of facts, in the sense that I never presided in a matter where the specific attorney was a litigant. Even the matter that he apparently seems to be concerned and complaining about, though I do not know what interest he has, there has never been, one, a recusal for me in that matter. Two, the issue he is raising was non-existent at the time, and it's only after I had delivered judgment in the matter, a couple of months later, was I approached in chambers by someone who seemed to have an interest in the matter and said, if the plaintiff does not abandon judgment, he will see to it that he launches an application that would notify me in the High Court, which unfortunately I had to give him a go-ahead to do so, than for me, functus officio as I was, to get involved in the matter. So I do not know Mr. Stein as to his interest, nor do I know, because even his objection, it is my view, Commissioner, it's bereft of any material evidence. And if there was, it is my belief he would have much earlier had come out and had either laid a complaint or either been part of the review application or either assisted applicant with whatever kind of information he had at the time. So that is my response.
Thank you. That deals with the issue.
Thank you, Commissioner.
Thank you very much. I think we have come to the end of this interview. Thank you very much.
ACJ, sorry, I'm not sure whether you can see my hand or not.
No, I can't see it. You have one question?
I have a follow-up and then I have a question, ACJ.
Can you try and deal with either the follow-up or give up the follow-up or do the question rather than both? Is that something you can do?
ACJ, I would ask for your indulgence. I don't waste the Commission's time on
Okay, all right. Go ahead, follow up and the question.
The follow-up is very short. Good day, Mr. Nkomse. The follow-up is just on the Van der Westhuizen matter. LSA also mentions that in that judgment, when you write the judgment, you nowhere mention what amount of damages was claimed.
Right.
So the question is just your comment on that, and then I'll move on to the question.
Well, Commissioner, probably that's a justified comment that in that matter I have realized that I did not mention the claim amount, which unfortunately was an omission because in other matters which I've dealt with, I had mentioned the claim amount of the plaintiff. So I wouldn't take that matter any further really to argue against it, no.
Thank you. Now, on that matter of impreciseness, I want to draw your attention to an appeal that you granted where there was an incorrect order granted. I don't know if you can remember the matter. It was in the Minister of Police versus Du Plessis.
Yes.
In the bundle on page 89, and subsequently there was an amended order. So if we can just look at that quickly, or I'll just take you to it very quickly. The appeal lies against the whole of the judgment of the magistrate for a finding that the arrest was unlawful, as well as the fiction that followed thereafter.
Yes.
And then when you make the order is made, it says the appeal is dismissed with costs on a party and party scale. And then on the next page, 110 is then the amended order. So the first part of my question is if you can take the court through how it came about that such a wrong order was made. And then after that, even when you rectified, if one looks on page 111, I want to put it to you that once again the order is lacking, even in its amended form, because it says then, I am therefore satisfied that detention was lawful and the appeal ought to be succeed. And then you say the appeal is upheld with costs. The problem with the appeal is upheld with costs is one doesn't know what relief is being granted. I put it to you that it should at least have said that the claim is dismissed or something else, some other substantive relief in line with the fact that the appeal is upheld. So it's two parts to the question. The first thing is how did the initial error come about? And your comment on the fact that the order still is lacking in some regard. Thank you.
Well, Commissioner, look, I must say that when I was pointed to the error, I wanted to beat myself in the sense that I go through my drafts a couple of times and I would send them back to the registrar or my clerk a number of times. And it was so strange that even the second judge whom I was sitting with did not spot that we I've made an error in as far as the order. I can probably only ascribe this to the pressure of work that I had in the North Gauteng High Court. I must say I had a short time there, and I wanted to produce many judgments. I normally say I used to sleep at 1 o'clock and wake up at 4 o'clock. And when I get to chambers in the morning, I have a Bible of manuscripts for the secretary, who I could see now she's overburdened. So I think it was just a slip on my part, and this slip, strangely, even happened with my sister with whom I was seated, that we did not see that the order at the end is not what we were purporting it to be. So that's my explanation on that. And of course, we sought to rectify the order, as you are pointing out. I was not, I did not find that there is something lacking in the order. I did not find that. But I guess it's something that I need to apply my mind to as you are raising it. I did not find that there is something that was incorrect with our order.
You're done, Commissioner Barnard.
Thank you. I just want to make sure. So the candidate is then indicating that you are happy with the order in its form there. It shouldn't say that the claim should be dismissed or the claim is dismissed with cost. The appeal is upheld and the claim is dismissed with cost.
I have no qualms with that, Commissioner. I have no qualms with that.
With your indulgence, ACJ, is the order lacking in that sense? Would you at least concede that?
Commissioner Barnard, the order that you are talking about, is it the amended order or the earlier one?
The amended order on page 111 of the bundle, ACJ.
Must he amend it?
Well, the amended order says that the appeal is upheld with cause. But Mr. Ngumse, you want to comment on that? I think Commissioner Barnard wants to be sure whether you are saying you think that the amended order is fine or whether you think it is lacking, it should have said something else or should have added something else.
Well, SJ,
the claim is dismissed. The appeal is upheld and the claim is dismissed with cost. So that's the question, just to assist the ACJ on that.
which claim, I'm sorry, ACJ, may I just ask for clarity's sake, which claim are we talking about now?
Thank you. If one looks at the appeal is against a matter where a claim was, or it was held that there was an unlawful arrest.
Yes.
So if the appeal is upheld, should it not then say that the claim is dismissed?
No, well, I'm not...
Okay, maybe let me try and understand, Mr. Ngumse.
Yes, ACJ.
In the magistrate's court,
yes,
Mr. Du Plessis had instituted a claim against the Minister of Police. Is that right?
Correct, ACJ.
And the outcome thereof was in favor of Mr. Du Plessis. Is that right?
Correct, ACJ.
And the detention was found to have been unlawful by the magistrate.
Correct, ACJ.
And the Minister of Police appealed.
Correct, ACJ.
And the Minister of Police, in his appeal, wanted the decision of the magistrate's court to be set aside.
Correct.
And that the detention be held to have been lawful.
Correct, ACJ.
And you concluded that the detention was lawful.
Correct, ACJ.
And you then upheld the appeal.
Correct, ACJ.
Okay, and you upheld the appeal, but you did not set aside the order of the magistrate, isn't it?
Correct, ACJ. Let me just.
Should you have set it aside or should you not have set it aside? I think Commissioner Bana's question may be directed at that.
All right.
To say, if you uphold the appeal, do you stop there or do you go ahead, continue and then do something else?
Just. I'm sorry to waste your time, CJ. I just wanted to check the preceding paragraph. I just want to check the preceding paragraph from the original order. I just wanted to check something, but I don't see it now. ACJ, I won't make bones about this. If the reading of the order as it stands, if reading of the order as it stands, someone would still be in doubt about the claim of the plaintiff, which was upheld by the magistrate, and that I should have been specific to mention that that claim has been dismissed. Once again, I would not have a problem to say it's something one could add, but I wouldn't necessarily say that the order is deficient as it stands. I stand to be corrected.
No, Mr. Mumsa. If it's an appeal, you can't just say the appeal is upheld and stop there, at least in this context.
Okay.
If the lower court made an order that it should not have made,
yes.
In other words, made a wrong order,
right,
and the losing party appeals,
yes,
then on appeal, you say you uphold the appeal,
yes,
and you set aside the order of the court of co and replace it with the order that the court of co ought to have made.
Correct.
So if you conclude that the magistrate's court should have dismissed Mr. Duplessis' claim,
yes,
then on appeal you set aside the order of that was made by the magistrate's court, which you regard as wrong, and then you say in the place of that order, or you replace that order with an order that says the claim is dismissed with cause. That is what you would do.
I take that advice, ACJ.
Yes.
I take
but
that.
I see that actually at paragraph 107,
yes,
paragraph 55,
yes,
you actually say, I'm therefore satisfied that the detention was lawful, which means the minister succeeds.
Yes.
And the appeal ought to be dismissed.
That's where the error is, ACJ.
Yes,
that's where the error
the
is.
appeal
Yes.
Upheld.
Yes, that's where the error is.
Yes. Okay,
Yes.
all right. Okay.
Yes.
I think, yeah.
No.
Okay, I think we are done. Thank you very much, Mr. Ngomse.
Thank you very much, ACJ, for the opportunity, and I thank the commissioners.
Thank you very much. You are excused.
Thank you very much.
Okay. 111.
At page 1.
Yeah, no, I saw that. That's fine. But the point is, you've got to set aside the order of the lower court, so that it doesn't exist, and say this is the order that it should have made. Yeah.
Thank you very much.
Okay, all right. Thank you. You are excused.
Thank you.
I think we should take a break now. We are at 8 minutes past 12. We should have our tea break, and then we make that, 10 minutes? Yes. Let's make it 10 minutes, and then we come back. Okay, thank you. Yeah? Okay. But I thank you for
No problem.
You look like that also. I'm like, no, you get some chow here.
I really need to use the marking. Maybe when I give you that, but when I use the marking from the yes. Because I don't have to my interest when I give you the date, I need this thing. Let's give people they can charge. That thing doesn't charge you. That don't say that. Just give me the.
Okay, so listen, I'm gonna contact Chris to bring us many charge because this one is not charged.
That's not charged. No, when I'm taking the, let me take the charge. This charge, and that people on the package here. It works. Yeah, how to child to let's disconnect. Tell people we're gonna put this is not you know, when I put your bill through one, put your bill through one. Which is having number 2 camera so off.
Good afternoon, Ms. Rossi. Am I pronouncing your surname correctly?
It is Ms. Khusi, Acting Chief Justice. Good
Yes.
afternoon.
How are you this afternoon?
I am well, Acting Chief Justice. Thank you so much. How are you?
I think I'm fine. Thank you. Welcome to this session of the interviews of the Commission, Ms. Rossi.
Thank you. I appreciate the opportunity.
Yes, and thank you for availing yourself for consideration for appointment as a judge of the Eastern Cape Division.
Thank you, ACJ.
I see that you hold 3 degrees, a BUris degree, an LLB, and an LLM.
Yes.
Is that right?
Yes, ACJ.
Yes. And you obtained the BUris degree from the University of Transkei in 1997.
Yes, ACJ.
And the LLB in 1999 from the University of Transkei, is that right?
It is so, ACJ.
And the LLM in 2005 from UNISA.
That's correct, ACJ.
Yes. And you you have lectured as well, is that correct?
That's correct, ACJ, as a junior lecturer.
At the University of Transkei.
It is so, ACJ.
Yes, just tell us a little bit more about your life as a junior lecturer at the University of Transkei.
Thank you, ACJ. That began in 2001. I started as a contract employee. At the time, lecturing was more teaching orientated. And I came to realize that that was attributable to challenges that were unique to the institution at the time, institutional challenges, I would say. So as a lecturer, we were assigned specific modules or courses to lecture students on, and I did mention the courses that I would lecture students on, and that entail an assessment of students, but then insofar as delivery of lectures was concerned, it required extensive research and a substantial amount of writing, preparing my lectures. Yes, ACJ.
And for how long did you lecture?
It was from 2001 until 2006, I think, when I then joined Legal Aid South Africa.
Yes.
Yes,
but
ACJ.
You had been admitted as an attorney already at the time you started lecturing?
It is so, ACJ.
Yes. Which year were you admitted as an attorney?
It was in 2001, ACJ. I think it was in March.
Yes. And in terms of practicing as an attorney, did you practice as an attorney at any stage?
It was when I was an attorney in Legal Aid,
Yes.
at Legal Aid South Africa, yes, ACJ.
Yes, and how long was that period?
It was from 2006 to 2009, ACJ, when I took up an acting position as a magistrate in Mount Aleph.
Yes.
Yes, ACJ.
Okay. Now, as an attorney at Legal Aid South Africa, how much exposure did you get to doing criminal trials and civil trials?
By the nature of the organization itself, which at the time was largely dealing with criminal cases. So I was assigned duties as a criminal lawyer, if I were to put it that way. So that continued from 2006. At first, I practiced in the district courts, and later on, I was assigned duties in the regional court. Yes, ACJ.
Okay. And when you were lecturing, did you ever lecture on civil and criminal procedures?
I lectured criminal procedure, law of evidence, and commercial law courses, your law of contract, etc. Yes, ACJ.
Yes. And as a magistrate, did you deal with civil cases? Did you adjudicate civil cases?
In Mount Aleph, I worked with the former head of office there. There was one courtroom, ACJ. So when I arrived in 2009, the duty roster was such that civil court practice was overseen, or rather done, by the former head of office. I did criminal court, and even so, that was on certain days of the week because we had to share that one courtroom. And as and when I did preside over civil cases, it was not that much because it was a small town. Civil trials were really few and far between. So I would not say I did get as much exposure in civil court.
Yes. So is the position that you only got exposure to adjudicating civil cases when you started acting in the High Court?
No, ACJ. When I left Mount Aleph and went to Pietermaritzburg on a transfer, I continued with criminal court until 2019, when I was assigned civil court duties. And that is where I had been until I was invited to act in the High Court in the Eastern Cape Division, ACJ.
So in Maritzburg, is the position that in Pietermaritzburg you adjudicated civil cases as well?
Yes, I did, ACJ.
Yes, and you were in Maritzburg for how long?
From 2013, and I'm still permanently employed as a magistrate there.
So you have had about seven and a half years exposure to civil matters?
No, ACJ. As I respectfully explained a few moments ago, I only got to do civil work in Pietermaritzburg in 2019.
Okay.
Because the rotation takes place at the discretion of the head of court in accordance with the criteria they applied.
Oh, okay. So it's been 2019, 2020, and 2021.
Yes, ACJ.
But you also acted in the High Court during part of this period.
It is so, ACJ, from April 2021.
Yes.
Yes,
so
ACJ.
you have acted for 2 terms in the High Court.
I would say so, ACJ, and I am currently acting.
Yes.
Yes, ACJ.
Yes. Have you done both trials and motion court in the High Court?
Yes, ACJ.
How have you found those to be, those motion court and civil trials?
It was a new challenge, considering the fact that I was coming from the district court and had not had that much exposure to civil court. However, the transition from the judicial experience I had amassed in the district court was somewhat easy. I would say, ACJ, I did manage to rise up to the challenge, and I would attribute that to the research skills that I had gathered when I was a lecturer, such that it was never difficult for me to traverse issues on a given matter before me, to engage counsel, and thereafter to produce a judgment. And all of that was also facilitated by the immense support that I got from colleagues and the mentorship from my seniors. So it was not as challenging as I thought it would be at first. I would say that I managed well with respect, ACJ.
Okay, Judge President.
Thank you, ACJ. Good morning, Ms. Hosi, or good day.
Good day, Judge President.
There's a document serving before you, headed List of Judgments by Eastern Cape Candidates.
Yes, JP.
If we go to pages 10 and 11, it embodies a document that relates to your acting stint in the Eastern Cape.
Yes, JP.
Firstly, before we deal with this document, I just want to place on record something that was said about you. When I was recommending you for a second stint in the High Court, Ms. Monyamure, Chief Magistrate of Pietermaritzburg, had the following to say of and concerning you. I appreciate the appointment given to Ms. Hosi, and I don't doubt her capability and commitment. I know she is representing the Pietermaritzburg cluster very well. I'm just placing that on record. Then let's go to the document, pages 10 and 11.
Yes, JP.
Do you confirm that it is a true reflection of what you have covered, at least during the two terms, the second and the third term, 2020?
I do
2021
confirm.
rather.
I'm sorry, I do confirm, JP.
Sorry. There is a concern that you reserve judgments unduly, which doesn't find support from this document. But let's go to the one judgment, the second last at page 10. It took longer than 3 months. You confirm that?
Yes, I do confirm, JP.
And in accordance with the norms and standards read together with the code of conduct, you precognized me about the challenges associated with that judgment taking a bit longer than usual.
I do confirm, JP.
Can you share with the Commission what those challenges were?
The challenges were basically technical in nature, in the sense that I had finished writing the judgment and sought to send it then to the research component. And it would appear that it was during the time there were challenges with the departmental systems. I got to learn that it was because of the alleged hacking. So when I tried following up with the researchers on the progress, I was informed, unfortunately, that my email had not at the time reached the researchers. So I had to resend the judgment for it then to undergo the processes there. When I received it back, I caused it to be delivered then.
Yes, and the researchers that you are referring to are actually based in Grahamstown, or where?
In Grahamstown, JP.
And at the particular time, where were you stationed within the division?
I would either have been in Mthatha or East London, JP, but not in the Grahamstown station.
Yes, and the sum total of what we have here, against the background that from what I have gleaned, there's only one judgment that was handed down beyond the 3-month threshold period.
Yes.
8
JP.
opposed applications, you confirm that?
Yes, I do confirm, JP.
4 civil trials?
Yes, JP.
2 criminal trials?
Yes, JP.
2 criminal appeals?
Yes, JP.
1 criminal review. At page 11.
It is supposed to be a civil review, JP. That must be an error. the
Rev-
First National Bank Limited
I
versus Additional Magistrate Petty.
Yes.
Yes.
You're saying review in the context of a review application.
Yes, JP.
Yes. And can you tell this commission briefly whether, in your view, case flow management enhances the litigation process or not?
It does, in my view, in the following sense. It mitigates delays that often happen when cases are, I would say, with utmost respect, hastily placed on roll for trial without the necessary checks being undertaken insofar as those cases are concerned. And I have also observed that through the facility of case flow management, most of the cases that are otherwise sought to be enrolled for trial end up not even getting to trial, whereby some would be settled, either partially or wholly. All in all, I have found case flow management to be an effective tool to ensure that delays in the start and completion of trials are kept to the minimum.
Thank you. And then at page, or perhaps let me simply refer to the letter. It's a letter dated June, 17 June 2021, part of the bundle, book 1 of 1. Page 1 of the documents that relate to you. Paragraph 5 of the letter nominating you. In the short period as an acting judge, she has distinguished herself as hardworking, efficient, and justice conscious. Then it goes on to say, this is attested to by judgments which will accompany her nomination package as required. I have no doubt that on a serious consideration of her judgments, the above traits will be easily discerned. Now, the letter is penned by a senior attorney who has acted as a judge, and she had that to say about you. I'm just placing that for record purposes. But my question is more this. Did you find acting in the High Court a very challenging task?
No, JP. In fact, I enjoyed the period of acting. And were it to be a challenge, I would say it is a challenge that I thrived in overcoming. I did enjoy my acting stint and still do, JP.
But you do acknowledge that High Court work is more challenging than Magistrates Court work.
It is. I say that without a doubt, JP.
And how did you navigate that? How did you get around the problems generally?
Adequate preparation when given work that is assigned to me. Making it a point that when I go to court, I know what issues are to be dealt with, how they are to be dealt with, in what direction I would be steering the proceedings. And therefore, I would say that adequate preparation coupled to the support and guidance from those who have been there before me has made it quite easy for me to navigate the challenging ground of High Court work.
There are 5 centers in all in the Eastern Cape: Mthatha, Bishop, Grahamstown, Port Elizabeth. East London is part of Grahamstown, of course. It's a second local division. You did discharge duties at all those centers during your acting stints?
Yes, I did, JP.
Thank you. No further questions.
Thank you, Judge. Thank you, Judge President. MEC Gade.
Once more, thanks, CJ. And no, I think I don't have a question. I was just having a concern on the report or submission, CJ, which was indicating that she has reserved judgment unduly, but in the presentation as proved by the JP, she actually explained the process that might have been a challenging. That, by the way, she has actually triumphed on it. So I don't have. I'm thankful that they clarified that, because that was just a worrying factor for me because of the implications that are along reserved judgments for unduly, of course, and for a long time. Otherwise, I'm comfortable with the presentations, CJ.
Thank you very much, MEC. President Maya.
Thank you, ACJ. Good morning, Ms. Khusi.
Good afternoon, President.
In addition to what the MEC has just said, there is another concern that has been expressed by some of the professional bodies that you could probably gain from more acting experience, but I think your work output is evidenced by the statement JP Mbenenge has presented us with, dispels that notion.
Thank you, President.
Now, what I want to find out from you is whether you were able to produce any articles during your 6-year stint as a university lecturer.
Unfortunately not, President, for the reason that I respectfully mentioned, that at the time, the main focus for the university seemed to me to be more of teaching, and we did not have the necessary support insofar as writing articles. And I only obtained my LLM degree in 2005, a year before I would then leave the university. I did not have an opportunity to pen any article, President, unfortunately.
All right. My real concern, though, is what has been raised by Ms. Lanjwa.
Yes, President.
Who says that in the early 2000s you worked for an unregistered law office, which was illegally operating as a law office, receiving monies from clients without being registered in terms of the law, and that there was the public suffered huge, immense loss, financial loss when that office was closed, and she says you should have known better. Now, she raises another serious issue that later, around 2009, while you worked for the Legal Aid Board, you accessed and distributed pornographic material using your employer's computers, and you disseminated that material among male candidates, attorneys employed by the Legal Aid Board. And instead of dealing with that issue when it was raised with you, you resigned on a 24-hour notice. What can you tell us about this concerns?
I did have an opportunity to read Ms. Lanjwa's objection, President, and I availed myself of an opportunity to respond. I believe that my response is part of the documents that were then circulated to the honorable commissioners. Insofar as the first part is concerned, I explained respectfully in my response that in 2001, after my admission, that was before I got the contract employment at the University of Transkei, I secured employment at Advocate or Professor Dlova's offices as his researcher. That was not a long stay. because his office was not busy. I felt that I was underutilized because I would find myself doing other duties of office messenger. So it is my respectful view that Ms. Lanjwa's allegations are of no basis. I never dealt with any of Professor Dlova's clients. And at the time I was there, I had never been aware of any complaint regarding the illegality of his practice. I was merely a researcher, an employee of his.
So you did not know that the operation was unlawful?
I never received any information to that effect, President.
The second one?
At Legal Aid South Africa, we shared computers, President. And on my arrival, I found a setup similar to this, an open plan, where anyone would use any computer at his or her convenience. There was, of course, a stage where the management of Legal Aid South Africa complained that practitioners and other staff members were using office computers for private matters, private material. And when it was said that certain obscene material had been discovered in one of the computers, I was never shown any such obscene material. And I had never been told that this is the private material that belonged to you, that we found in the computer. So when I saw the objection, it was really difficult for me to even defend myself, so to speak, because I know the setup of Legal Aid South Africa at the time. Ms. Lanjwa appears to be a member of the community, never had been an employee of Legal Aid South Africa at the time I was there. So that's as far as I can take it, President. No obscene material was ever presented to me as being the obscene material that was, I'm not even sure how, President, it would have been possible for me or anyone, I would say, to access obscene material at Legal Aid through computers when there was not even access to internet. That's as far as I can take it. I was never, or rather, I never accessed any such obscene material.
Well, she goes further and says you were actually sued by the Legal Aid Board and it got a judgment against you in the Mthatha High Court. What was that in relation with? Was it in relation with this obscene material, or what was that about?
I was practically confounded. I was never sued by Legal Aid South Africa, President.
So there's no judgment?
There is no judgment against me by Legal Aid South Africa. Hence, I did mention in my response that, by all accounts, it would appear that Ms. Lanjwa's objection is malicious and somewhat defamatory. I was never sued by Legal Aid, and I did read, if I may go further, I did read that she says, while there was the issue regarding the obscene material and misuse of computers, I sped off to elsewhere on 24 hours notice. If I may respectfully ask to expand on the circumstances under which I left Legal Aid, with the permission of ACJ.
Yeah, yes, tell us.
When I arrived at Legal Aid in 2006, I had applied, or rather in 2009, early around June, July, I would say, I had applied to the Magistrates Commission for permanent appointment as a magistrate. That was while I was still in Legal Aid. So in October 2009, a magistrate or colleague met his untimely death, and the then Chief Magistrate Mpogane wanted someone to fill up the gap. I was one of the persons that were contacted by Chief Magistrate Mpogane to take up that task. I saw no reason why I shouldn't at the time, knowing very well that I had taken a leap of faith and applied earlier before that time. So I did not hesitate. I took up the position for purposes of career growth, amongst other things, of course.
Thank you very much, Ms. Kosi. I'm
Thank you,
satisfied.
President.
Yes, Commissioner.
CJ, I beg your indulgence. I want to forego my opportunity to ask questions.
Yes.
If you allow me to make some follow-ups.
A follow-up, okay,
On the
all
questions that President
Okay, all right.
has posed to the applicant.
Okay.
Now, let's start with this one of Legal Aid Board.
Yes, Commissioner.
When these allegations were made against you, according to this, you immediately resigned. You're saying that is not true.
The allegations were not even directed at me individually. All staff was confronted with the complaint that you are misusing office computers.
I mean, according to this.
Yes, according to Ms.
You
Landwa.
immediately resigned within 24 hours. I want to follow the sequence of what I pick up here in relation to your
Well,
your
it would be difficult for me to answer in accordance with what Ms. Landwa says, which I know has no truth in it. I resigned because an opportunity for career growth had presented itself at the time. A magistrate had died in Mount Alief, so I took up the post upon invitation of the then Chief Magistrate Mpogane.
Okay, that's fine. Now, you were saying to this commission that you don't have any judgment against you, even if an investigation can be undertaken. You don't have any judgment whatsoever.
I was never sued by Legal Aid. In fact, as I read Ms. Landwa's complaint, she says, as a result of me leaving Legal Aid on 24 hours, I was sued. I found that to be, with respect, outrageous. No one gets sued, in my respectful view, for exercising their legal right, their contractual right to leave employment. No judgment was ever obtained as alleged by Ms. Landwa against me, or at all.
Okay, the last one, in relation to the unregistered law firm.
Yes.
Was this firm unregistered?
I do not.
Or was
At the time, it had never come to my attention that Advocate Glover or Professor Glover was operating an illegal establishment. I was 24 years old, fresh from admission, with the pressure of getting employment.
No, it's okay, so I understand.
Yes, so it was never brought to my attention. I never heard of any complaint, Commissioner, that there was illegal operation going on there. And even though I was employed there as a researcher, nothing would have prevented me, had I known then, from leaving that establishment.
Okay, are you saying to this day, you are not aware that at some point this law firm was not registered? You don't have that information whatsoever?
At the time I was there, I was not aware. However, I have heard recently, and I think I read a judgment.
I'm sorry. Commissioner Dodov, do you think it will help? Because if she, at that time, didn't know anything, even if she subsequently got to know that it was illegal, the firm was not registered,
It's okay.
she would remain innocent.
No, it's okay, it's okay.
Yeah.
Just a quick
Thank you.
follow-up to forward my question.
Yes, Commissioner Klaver.
Thanks, CJ. Good day, Ms. Roos.
Good day, Commissioner.
Thank you very much. And I just want to follow up on the resignation issue.
Yes.
Were you not obligated to serve a notice period? And then maybe the question following immediately after that one is, when did you resign? The month, maybe let's leave it at that, month and year, and the date, and the month and year when you assumed the new job.
Okay. I would not remember the exact wording of my contract of employment. However, I know that an employee would have to serve their month period before resignation. If they don't, they would forfeit benefits accruing to someone that had duly served that notice. So in my case, having weighed my options, I decided to forego whatever benefits would have accrued to me by virtue of having fully complied with the service period. Remember, Commissioner, this is an organization I came to in 2006. I had made my observation. I had reviewed my position as an attorney there and assessed the potential for growth and opportunities insofar as that growth was concerned. That is why I did not bat an eyelid, leaving the organization when an opportunity presented itself. And for the sake of completion, Commissioner, I seem to remember that I resigned on 3rd or 5 October 2009. The following Monday, I started in Mount Alief because Mr. Kuchwa was no more.
Thank you so much.
Well, Ms. Rusi, I think the issue that is raised by Commissioner Klaver is important.
Yes,
I'm not
ACJ.
sure that your answer deals with it. I think his question goes to the question of whether you were under an obligation to give a longer notice or to give proper notice. Your answer doesn't seem to deal with that. What was your contractual obligation before you could leave?
Sorry, ACJ.
Normally, you wouldn't be allowed to just up and go. So what was your contractual obligation in terms of giving notice?
It would have been that I ought to give notice. However,
How much notice?
It would be a month.
Yes.
At most.
Yes.
There's something that I should.
And you did not give a month's notice?
No, I did not, ACJ.
Did you secure an agreement from your employer so that the employer could waive a month's notice?
They accepted my resignation, ACJ. Perhaps with leave of the ACJ. I should mention that because of, and I say this with utmost respect to the leaders of the organization, because of the toxic and to some extent oppressive nature of the environment at Legal Aid, it had become a norm for practitioners who get better opportunities to give 24 hours notice to avert any form of sabotage, if I may put it that way. And a lot of my colleagues there would attest to this. Not that I endorse this.
If one person, if a few people do something wrong, Ms. Rossi, it doesn't become right just because there are a number of people who have done the wrong thing.
Yes, ACJ.
If you were under an obligation to give a month's notice, isn't the position that you had to give a month's notice, or you approach the employer and ask the employer if they can agree that you don't give a month's notice and leave immediately. Isn't that what?
Ideally, ACJ,
Yes.
that is so. However, I was amongst practitioners who found themselves in that kind of an environment. And as I respectfully explained, I also understood at the time that if I do not serve the month's notice period, I would then forego the benefits accruing to someone that served the notice.
What benefits are you talking about?
When
Notice are good. I mean, if you serve the notice,
it is,
and in other words, you tell your employer on the 1st of the month that this is my last month. At the end of the month, I'm leaving. And they allow you to work. They know that you will be leaving at the end of the month. They start making arrangements because you have told them. That is serving your notice, okay?
yes, ACJ.
If you wish to be released from that obligation, you speak to your employer and say, I know that I'm under obligation to serve a month's notice, but I am in this situation, and you explain your situation. I might lose this opportunity. Would you mind to waive the right to a month's notice? Maybe I can give you a week's notice or 24 hours notice. Or they might say, okay, you can up and go because we appreciate your situation. We will be able to manage. Then you have made arrangements. That's different.
Yes. Thank you, ACJ. It is indeed so. Ideally, the benefits I am referring to would be the salary. I lost.
But you would not be
on the
entitled to a
salary.
salary if you didn't work.
That is what I.
If you didn't work for a month because you just upped and go and went, you would not be entitled to a month's salary.
Indeed.
So there's nothing you would be forfeiting.
Indeed, ACJ. However, in my view, in so far as the contract of employment with legal aid was concerned, I had also understood that nothing would prevent me from giving 24 hours notice given the circumstances. And as I respectfully mentioned, the environment was never conducive for any accommodation of employees when things like that emerged.
Thank you, Commissioner Nojesi.
Thank you very
Just a
much.
follow-up.
Thank you.
Okay.
No, there are many follow-ups before I speak.
Yeah,
What I mean is the sixth
hang on.
follow-up. We
No,
are following,
yeah.
there was follow-up, follow-up.
Nojesi.
No,
Okay,
this is not
Nojesi,
right.
go
No,
ahead.
this is not right.
Go ahead.
You
Go
know,
ahead.
it's either I will run this through follow-ups. Sorry. Now, look,
No,
what
he
I
has
want.
been waiting for a long time.
Yeah, thank you. What I want from you, the relationship between you and the legal aid is just a private matter.
Yes, Mr. Nokesi.
As to you submitting a resignation letter, that being accepted by the legal aid.
Indeed.
Is there any other point who must be involved on this?
I believe not.
Secondly, before you come to act in the Eastern Cape, sir, I have to say this. The attorney's profession in the Mthatha area actually had handed you and submitted your name to the JP because of your expertise. Are you aware of that? That your name, among other names that were submitted to the JP as a person who is recommended to be appointed for acting because of your capacity and expertise.
Now that you are mentioning it, Commissioner Nokesi,
Yeah.
and I appreciate that.
And there is a letter here written by the.
What page of the bundle, please?
I'm not
Mr.
sure on the feedback, if you have the small, but I will read the portion on the feedback. This is a letter by the entire Coastal Attorneys Association, which constitute the former Transkei area. And this is what they write. Paragraph 4. It is indeed our considered view that Ms. Khusi is not only fit and proper person to be elevated to the High Court on permanent basis, but is a suitable candidate for the above-mentioned vacant position. Have you seen that statement?
I have seen it, Mr. Nokesi.
And lastly, Within the short space of time that we have acted in the Eastern Cape, as it is demonstrated in this list that we have given of judgments,
Yes, Ms. Mackes.
within that short space of time, we have produced so many judgments as they are reflected.
Yes, Mr. Mackes.
Thank you, Ms. Koskose, for availing yourself.
Thank you, Mr. Mackes.
Yeah.
Just one aspect. I think it's going to resolve a
To
number
resolve,
of things.
okay, all right, quickly.
It is a matter of concern for me that objections will be raised and then candidates will respond as done by Ms. Khosi in a letter dated 23 September 2021, dealing with all these concerns on an ad paragraph basis. And then we are detained here. Same questions are raised against the background that there was a response and the letter was disseminated to all of us. And it means if we never received this letter by Ms. Khosi, then somehow there's a problem with the system.
Well, one needs to strike a balance.
Yes.
Because it's a transparent process.
I have no qualms with that,
Yes,
but
yeah.
the structure
Yeah.
of the questions
Yeah.
clearly moves from the structure moves from the premise that
Yeah.
she must deal with these things. Sometimes we don't even have to hear some of spurious allegations against candidates.
Yeah, yeah, no.
For instance, if one does short shrift in the form of a letter, it's as simple as we may not even have to follow up on some of the things.
No, some of them we don't have to check.
True.
To follow up all of them. Yeah.
Thank
yeah.
you, ACJ.
Thank you. I think Commissioner Nyambi was the next one, and then I think after her it's then it will be Commissioner Sepu and Schlema. Okay, Commissioner Nyambi.
Thank you, ACJ. Afternoon, ma'am.
Good afternoon, Commissioner.
Given the discussion and the letter that you have written to us and the information you have now,
Yes.
with the hindsight, don't you see anything that is wrong about the entire process?
My resignation at Legal Aid, you mean, Commissioner?
Yes, I'm talking about the letter that you wrote to us and the issues that they wrote about the objection. Sitting here now in the discussion after going through the letter and the process and reflecting about everything, don't you see anything that is wrong? As far as we are concerned with hindsight, we are still of the view that we have done almost everything in the correct way.
I hope I am understanding your question, Commissioner. When I received the objection by Ms. Lanjwa, I immediately penned a response.
Let me assist you. I'm saying there are some objections, right? We have gone through them, we have assisted us, we have responded in detail as clarified by JP.
Yes.
But I'm saying with the hindsight, because we have indicated that some of the issues we're not aware. But sitting here now and being aware and after the discussion, do you still of the view that everything that you have done, given another chance, you can still do things the same way?
No, not at all. Insofar as Advocate Lova's practice is concerned, it is indeed regrettable that I got to learn much later of things such as those. And insofar as the 24-hour resignation, that is not something I would do in the near future. And I don't condone what I had done in 2009.
My last, it's a comment, and then I'll quickly do it. Then you'll also comment if you want to.
Yes, Commissioner.
I get a sense that in dealing with the issues, like once you say there were some people working, using the computers, it's like you are justifying. But there's nothing wrong when you're still young to come here and take responsibility and will understand that. But once you want to justify, it's like you don't understand the magnitude. Imagine sitting here as members of parliament, as judges, as people representing these law bodies, and then you happen to have headline news saying an attorney that distributed pornographic material has been appointed by the JSC to be judge in Mthatha. It's not just putting the judiciary into dispute, but also us as members of this commission. But if you take responsibilities, assisting us to understand issues that happened a long time ago, instead of refreshing them as if they are new, they happened yesterday.
And unfortunately, Commissioner, I'll say this with the greatest of respect. Ms. Lanjwa's objection is simply spurious. I mentioned this to some of the colleagues, or rather my family members, when I showed them this objection that, you know, if I knew that there was a shred of truth in what Ms. Lanjwa is saying, I was going to spare myself the indignity and the embarrassment of sitting in front of this honorable commission with everyone, literally the whole world, watching me, being confronted with such things. This is what I told my family, that if I knew that there was an inch of truth in these things, I was going to withdraw. And I did not, respectfully, because I knew that here in this objection was nothing but malice and defamation, or an intent to defame me. I had never met a person by the name of Lanjwa Xoliswa ever in my life, not in my professional or personal capacity. Like I said, respectfully, she was not even a member of Legal Aid South Africa staff.
So you actually don't know her?
I literally, ACJ, I've never met Lanjwa. And what I noted from her objection is that she approaches the commission on anonymous basis, is not telling the commission what community she comes from. So it is difficult for me to take responsibility for something I know I would never do. Something I know I make sure even now, ACJ, that my children do not experience those things to the best of my ability, of course. It is difficult to defend yourself against something like this when you know that there's no truth in it. And there's none.
Thank you. Commissioner Mtolo Lepu.
Thank you, CJ. Acting CJ. I'm sorry, Mr. President, but I think you covered it because I wanted to see who's this Miss Lanjwa, or whether you know her or what.
I don't even know her. You know? And okay. What pains me the most with the leave of the ACJ is that I've made so much sacrifice to be where I am in life. I was listening to Commissioner Nukesi tell me for the first time how my invitation to act in the High Court came about. I was not aware. I've worked so hard, sacrificed quite a lot to be the kind of person that I am, to be where I am. For me to just allow someone to put a blemish on all of that.
I think you have addressed it. You say
thank you so much.
You don't even know this person.
I really don't.
I think Commissioner Moimang, and then it will be Commissioner Schlemmer.
I'm covered.
You are covered. Thank you very much, Commissioner Schlemmer.
Thank you, ACJ. Good afternoon, ma'am.
Good afternoon, Commissioner.
Could you please just put my mind at ease? I'm still a little bit concerned about your experience in civil law. And when you answered about some of the questions with the delayed judgments, there was talk about the researchers who are far away I'm not sure exactly, in Grahamstown, and you were sitting in Tata. Was that part of the reason? It seems like they were the civil law matters that you were dealing with, that you had more difficulty potentially in coming to a final conclusion and therefore had to draw more on the researchers, or am I understanding it incorrectly?
With respect, Commissioner, you are understanding it incorrectly. I delivered those judgments within the 3 months period. It was in respect of the one judgment that Judge President brought to my attention that there was a delay to the extent reflected in the document. And my taking the time I had taken had, in my respectful view, or it cannot be attributed to the fact that I had no exposure, because at the end of it all, I applied my mind to each of the 17 matters, resolved the dispute between the parties, ensured through my judgments that the parties followed my reasoning. That is as far as I can take it. And even though I acknowledge the fact that I had not had as much exposure to civil work, having acted in the High Court for this short period, I can assure this commission that I have now become more confident and more comfortable traversing issues coming from the civil court. And I believe, with respect, that the judgments I have in turn produced do tell insofar as that is concerned. That is as far as I can take it, Commissioner. Thank you so much.
Thank you very much. Commissioner Klaba, are you covered?
Yes, I'm covered.
You're
Thank you so much.
Okay, thank you. Commissioners on the virtual platform, is there anybody who has any question there?
Yes, ACJ, it's Commissioner Barnard.
Yes, Commissioner Barnard.
Thank you. Thank you. Ms. Rusi, perhaps also thank you for taking the commission into your confidence and doing effort to in the last couple of months also to show respect and getting out judgments. I think it's really impressive. The legal aid stuff happened long ago, but these judgments are very recent, and one notes from it that you made real effort. So the question here is maybe just with reference to the geographical location. I mean, Kanda, Bishu, East London, Tata, these are places far apart, and you seem to have appeared in all of those courts. That's my first point. And the second point is to just illustrate what type of commitment you showed to this process is, if you look at the 17th of August on the report that you did, you actually handed down 3 judgments, one in a civil trial in Bishu, one in opposed motion in Bishu, and then a criminal appeal, which was then in Grahamstown is indicated here. So that shows quite some commitment. Perhaps maybe your comment on that as well, please. Thank you.
I hope I understood Commissioner Barnard correctly. In the Eastern Cape Division, there is a system of rotation of judges. No judge gets stationed in one court for a continuous period. That is why in a given week, I would be in Mthatha attending to Mthatha duties, a week or two, depending on whether that is criminal court or civil court. In another week, I would be in Bisho. In another week, I would be in East London, Grahamstown, attending different duties in those courts. And the reason I delivered these 3 judgments on the same date is that there was a point where I sat in opposed motion and attended to 4 opposed motion matters. So I'm not sure if I am answering Commissioner Barnard's question, because indeed the Bishaw matter and
It's item 2, 8, and 13 are all on the 17th. I'm just trying to
yes,
follow the
indeed.
commitment process.
Yes, I had heard the matter of Hoji, for example, on 13 May, and heard the matter of Gola from 6 to 12 May. So after finishing the trial of Gola, I was stationed then in Bisho, where I heard this opposed matter. So I then finished these judgments around the same time. That is why then they were delivered on the dates as we see in this spreadsheet.
So thank you very much, and just thank you on behalf of the profession and the public for getting out these judgments. I think many people were waiting for them, and you showed true commitment in that. Thank you very much.
It is much appreciated, Commissioner. Thank you.
Thank you, Commissioner Barnard. I take it there is no other question from the commissioners on the virtual platform. I think we have come to the end of this interview. Thank you very much, Ms. Rusi, for availing yourself. You are now excused.
Thank you, ACJ, and thank you so much to the commissioners.
Thank you. Commissioners, we are at 26 minutes past 1. We can decide to take lunch now, come back at 2, or we can take the next candidate and then go to lunch after that.
Next candidate.
One
Chair.
more.
One more, Chair.
One more, okay, all right. Next candidate, please. Yeah, yeah, yeah. No, you see, we should.
We are now going for Somacala.
Yes, yes.
I would like you to write a note. Where is his name?
Yeah, yeah.
When you thank him.
Yes.
He lost his wife through COVID 2 weeks ago.
Okay, let's start. Good afternoon, Mr. Somacala.
Good afternoon, ACJ.
How are you this afternoon?
I'm fine, thanks, ACJ, and you?
Okay, no, I'm fine, thank you. I'm greeting you on behalf of everybody. So when I say I'm fine, it means we are all fine.
Thank you, thank you, thank you.
Thank you very much for availing yourself for consideration for appointment as a judge of the Eastern Cape Division of the High Court, and thank you for joining us in this interview session, Mr. Somacala.
It's my pleasure, Sir.
Now, you hold the degrees of B. Juris and LLB, is that correct?
That is correct, CJ.
And you got both of them from the former University of Transkei, is that right?
That is also correct, CJ.
Yes, and you got your B. Juris degree in 1988 and your LLB in 1992.
That is correct, CJ.
And your working career started, you started your working career as a public prosecutor, is that right?
That is correct.
In 1989 to 1991, and thereafter you did articles with Chiki and Sons attorneys.
That is also correct, CJ.
And you were subsequently admitted as an attorney, and you joined S-Team Jolie Incorporated.
That is correct, CJ.
Yes. And later on, you became a High Court prosecutor.
Correct, CJ.
Yes. And ultimately, in 2015, you became a magistrate.
That is correct, CJ.
And you continue to work as a magistrate.
Yes, correct, CJ.
Yes. Now, for how long did you practice as an attorney?
I practiced as an attorney from 1995 until 2002, when I left to join NPA as a state prosecutor in the High Court.
Yes.
And then again in 2002, towards the end, I think in September, I joined Legal Aid, the then Legal Aid Board, which is now Legal Aid South Africa, where I remained until December 2008. And then 2009 to 2012, I practiced on my own account until I went back again to Legal Aid South Africa in 2013 until 2015.
You went back to?
Legal Aid South Africa.
Oh, okay, okay. So during the periods that you practiced as an attorney, what types of cases did you handle in terms of branches of law?
Well, our practice, whilst I was a private, I was in private practice, it was a diverse practice, which involved criminal law work, civil, as well as some few administrative law work. Yeah, basically that. And also road accident fund work, that is the motor vehicle accident.
Yes, so it was some few administrative law cases.
Yes.
Road accident fund cases.
Yes.
What was the other branch?
Criminal law.
Criminal law.
As well as civil law. That is the general litigation.
Yeah, okay. Did you appear in court and do trials yourself at that time? Or did you brief counsel to do your trials and argue your matters?
I did both, ACJ. I did appear in the High Court doing trials on my own, as well as also in some other matters I did brief counsel.
Yes. Okay. And as a magistrate from 2015 up to now, do you do civil cases?
Yes, I do civil cases, but in the district
And
court.
how much civil work do you do? How much of your time is taken by civil work as opposed to criminal work?
Well, because I'm in a rural town, there isn't that much of a civil work there, but we do have it. And as the head of office, I'm the one who is mostly in charge of it. So I cannot put the number or the figure of it,
But however, if I were to put it in a form of percentage, I would say we do around about 20% civil and then 10% civil and then 90% criminal.
Yes. Now, on question or paragraph 6.2 of the questionnaire, which is paginated page 18 of the bundle, you were asked to indicate the proportion of your litigation work in the various fields. And under criminal law, you said 100%. You remember that?
I remember that, ACJ.
Under administrative law, you said 100% too. You remember that?
I remember that as well, ACJ.
Under constitutional law, you said 80%. Do you remember that?
I remember that as well, ACJ.
Under labor law, you said 10%.
I remember that as well, ACJ.
There's a problem with the...
No, I was giving that percentage based on the fact that I was thinking, that was my view in the answering of the questionnaire, about the proportionality of the bulk of the work, which I did on my own. If I were to put a percentage in it, insofar as the number of the matters, I didn't put 100% as the global figure and then break it down.
What did you have in mind?
I'm saying, ACJ, I was having in mind the aspect of the number of cases in general, not having to put 100% as the global figure.
Did you mean to say 100 cases?
No, I didn't mean to say 100 cases, ACJ. I meant to say I dedicated my time 100% on this particular area. That's what I was trying to mean.
Oh, so you were saying you dedicated 100% of your time to criminal law?
Yes.
And 100% of your time to administrative law?
Yes, as presented to me.
Yeah.
In my office, yes.
Well, I'm not sure that I understand it. But have you acted in the High Court?
Yes, I did have
yes.
acting
How did you
stint.
find the experience of acting in the High Court?
Well, it was challenging, but
Yes.
interesting as well.
Yes.
And interesting in the sense that I had been appearing in the High Court for quite a long time. So I somehow knew what I was to meet when I took the acting stint in the High Court.
Yes. And you did a lot of civil work in the High Court, civil trials and motion matters?
Yes, because during that period, I was only allocated civil court matters, no criminal court.
Yes. But I see that you actually have, it looks like quite a number of reported cases in which you were involved as an attorney, is that right?
That is correct, ACJ.
Yes. One of them is GASA versus Minister of Safety and Security. Another one is S versus Vanga, is that right?
That is correct.
Another one is S versus Mashi and another.
But the GASA matter was a civil matter.
Was a what matter?
Civil.
Oh, was a civil
it's
matter,
not a
yes,
criminal
yes.
matter.
Yes.
However, the Mashi one, I didn't do it as an attorney. I
Yeah.
did it whilst I was at the office of the National Prosecuting Authority.
Yes.
Then the Vanga one, I did it as an attorney.
These cases that are reported, was your involvement in them at the level of arguing them or doing trials or arguing appeals? Or you were involved as an instructing attorney and there was counsel who did the arguing?
No, I did them on my own.
You did them on your own,
Yes.
including the CASA one?
Yes, including the CASA one. I drew the papers. I argued the matter. I appeared before the judge, and then I argued the matter.
That is very good, Mr. Sorokal. That's very good. And there is Ndibombo versus the state. You would have argued that yourself as well.
Yes, I did argue that on
And
my own.
and Meva versus the state.
I argued that on my own as well.
I think that that's very good. Yes, Judge President.
Thank you, ACJ. Purely for the sake of completeness, let me say good afternoon, Mr. Somacela.
Good afternoon, JP.
I got to know you way back in 1988-89 when I was lecturing at the University of Transkei. You were active in the Judicial Society then. Is that not the position?
That is correct, JP.
Thank you. If you have a look at the spreadsheet at pages 3 and 4, is it 3 and 4? Sorry. Pages 12. It's actually just page 12.
Yes, yes, I've seen it.
I know you've not interrogated this document. In other words, you've not looked at your situation and compared it with that of another candidate.
No.
You haven't, yes. The situation appearing on page 12 points to you having done 5 opposed application judgments. In other words, you wrote judgments in 5 opposed applications.
Yes, yes, JP.
And then 3 civil trials and 3 criminal appeals.
That is correct, JP.
You acted just for one stint, which is July to September
That is correct,
last
JP.
year.
That is correct, JP.
You would otherwise agree with me if I were to say that if you were to gain more mileage, it would equip you when it comes to high court work. And I'm going to qualify my question. The scenario is simply that there is no civil court work that you are steeped in the magistrate's court. But you got good exposure when it comes to high court, civil court work. Is that not the position?
That may be the position, JP.
Yes. And but for your current personal circumstances, you would otherwise be acting during this coming term or the term, the instant term.
That is also correct, JP.
Yes. No further questions.
Thank you, Judge President. MEC Gade.
No, CJ, I'm comfortable.
You are comfortable?
Yes.
Okay, thank you. Commissioners, any questions? Judge President Mlambo.
Thank you very much, Acting Chief Justice. Good afternoon, Mr. Somacela.
Good afternoon, JP.
I'm just wanting to confirm that I also know you, unless you've forgotten.
How can I forget you, JP?
You were a very proficient lawyer for Legal Aid South Africa in the Eastern Cape before you resigned. And do you recall that I personally came down to try and persuade you not to leave?
I know that, JP, as well as the CEO. I do know that they also persuaded me not to leave.
Yes. And in that role, I don't know whether it was at the time when we had created high court units, but you were dealing with all manners of cases.
That is correct, JP, and by then, the High Court unit was already in existence. In actual fact, it came as at the time I was the manager of Legal Aid.
Yes.
And I was the one who was in charge of setting it up in the King Williamstown Justice Center.
And you were the so-called in-house counsel, because all the work coming out down from the office came to you as counsel and you went to argue them.
That is very much correct.
Thank you very much.
Also,
Chief
that
Justice.
if I can expand on that, during
Yes.
that period, at the Legal Aid Board, which is now Legal Aid South Africa, the Legal Aid Board was struggling into securing or employing suitable qualified counsel to do High Court work. And as a result thereof, I had to do it on my own. Until such time, then we managed to persuade some certain individuals who then got to be involved and get some employment.
Thank you. And once more, ACJ, through your permission, condolences on your recent bereavement.
I appreciate that.
Thank you. Commissioners on the virtual platform, and anybody with a question there? No question. Commissioner Dodovo.
Thank you very much, ACJ. Just one point that is confusing me. Page 11, you stated that, or there is a question that you are asked, whether have you ever been a member of a secret organization? And you said yes. Can you just clarify that, because below you say no,
I can
but on top.
I can clarify
Yes.
that, Honorable Commissioner. If you look at the answer, the actual answer, which is typewritten, it says, I was never, ever, I'm not, and I've never, ever been a member. It was a question of, I would say, an error on the, a mistake on the, on the ticking of
Okay.
the box there. But that ticking of the box does not talk to the actual answer.
Yeah, and I see that. That is what I'm saying. It's confusing. Now I understand. I was wondering which secret organization was that. All right, thank you very much.
Thank you. Thank you.
I saw
think,
that. It also embarrassed me when I saw it.
Okay, Commissioner Mutolo Zepu.
Thank you, TCJ. Good day, Mr. Sumakala.
Good day.
I'm just curious. I'll tell you why I'm just curious. You were doing well in legal aid, then you decided to, obviously you wanted growth, you wanted to professional growth. You went into private practice. Is that correct?
That is correct, Commissioner.
What made you not stay in private practice and go back to legal aid?
What happened is, Commissioner, I went to, I left Legal Aid South Africa to go into private practice. Whilst I was at private practice then, I was scouted and approached by the chief magistrate, the then chief magistrate of the Tata area, or the former Transkei area, to go and act as a magistrate after long persuasions. And then having taken that, and as my practice was growing up, and then it just went nose down. So I felt that being a responsible person, having children, so for me to go back and start that practice, which has just went nose down, is gonna be a milestone.
It looks
And
like we have...
it also proved that I left, as Judge President Mlambo was saying, I left in good spirit at Legal Aid South Africa. Hence, they also did accept me back when I went back to them.
They didn't want you to go. They were very
in
happy
fact,
with your services.
In both instances, they didn't want me to go.
Yes. Okay, I think we have come to the end of the interview. Thank you very much, Mr. Somakala, for availing yourself. And I must particularly thank you for continuing to come to the interview, despite the fact, as I understand, that you recently lost your wife due to COVID. So we really appreciate the fact that you decided you did not withdraw. You came to the interview. Thank you very, very much. We really appreciate that. And I hope that you will find strength.
Thank you very much, ACJ. I also want to thank all the commissioners for having allowed me this opportunity to come here.
Yes. No, thank you very much.
Thank
You
you
are
very
excused. Thank you. We are at 10 to 2, and I guess we should then take our lunch break. Shall we say we will be back at 20 past 2, which will make it 30 minutes. Yeah. Okay? Let's start. Good afternoon, Ms. Beneke.
Good afternoon, DCJ.
Did I pronounce your surname correctly?
You did, yes, thank you.
Thank you. Welcome to this session of the JSC interviews, and thank you for availing yourself for consideration.
It's my pleasure.
Yes. You hold the degrees of LLB and LLM, is that correct?
That is correct, sir.
You obtained both of them from the University of Port Elizabeth.
As it then was, yes.
As it was then called. Yes. And you started your career as a teaching assistant at the university, at the same university, is that right?
Yes.
And then in 2003, you did pupillage between July and December.
I did.
And you later became an external examiner for Rhodes University as well as Nelson Mandela Metropolitan University.
Yes, sir.
Yes, and when were you admitted at the bar? Is it 2004?
No, 2002, 28 September, I think.
Yes, and you started
No, sorry,
practicing
28
immediately.
February.
And you started practicing as an advocate immediately?
No, I did my master's
Yes.
in international criminal law.
Yeah.
And then I was called to the bar in 2003
Yeah.
when I finished my pupillage.
And have you been practicing as an advocate since then?
Ever since.
Without interruption?
Without.
Yes. Can you share with the commissioners what types of cases your practice gave you over the years?
Yes.
In terms of branches of law?
Yes. I set it out in some detail in the application, but I'll summarize. I did work in all fields of law. As a junior, one starts off in unopposed motion court, and I devilled quite a lot in contract and delict, and then later on I developed my own practice in both of those, both in the magistrates court and in the high court. I did some work in admin law and one or two matters in labor law, but predominantly contract delict, the run-of-the-mill stuff that one finds in Port Elizabeth.
Did your practice include competition law, commercial law?
I did some commercial law, not much. Competition law, I recall doing some deviling in a competition matter, but I don't recall doing anything save restraint of trade as far as competition went.
Yes. So what branch or branches of law dominated your practice?
Civil. I did predominantly civil law. I would say starting off, the vast majority of my matters were MVA, road accident fund matters. Right at the beginning, I also did quite a bit of legal aid work, criminal work. Most of those related to rape charges. That stopped in about 2005 when the Legal Aid Board changed its policy on how to brief counsel. It had to do with what percentage of one's practice was criminal, which determined which court one could practice in. And mine was of such a low percentage of criminal law that I could practice in the district court, despite having done 3 or 4 years of high court rape trials. But anyway, so I abandoned the criminal law and focused predominantly on contract law, stuff like leases or building disputes, matters of that nature.
All in all, You have practiced for about what, 20 years?
It's about 17 and a half,
About 17
nearly
years.
18 years. Yeah.
Yes, okay. And when did you take silk?
2019.
Yes. Okay. And you have acted as a judge as well?
I have for 3 months.
Yeah. And how did you find that?
Like coming home.
Yes.
As counsel, what we do is we analyze the facts and the law and hope to put the best version before the court. So when I came to act, it was a continuation of everything that I'd been doing up to that stage. And whenever I had difficulties, as one must when one starts something new, the permanent members of the judiciary were always there to assist me whenever I had problems.
Yes. Judge President.
Good afternoon, Advocate Bieneke.
Hello, JP.
Have you ever presided over a case running, say, for something like a term, gruesome sort of murder case?
I have not.
In light of the disclosure you've made regarding your state of health,
Yes.
would an extended acting stint involving allocation of work, such as I have alluded to, help the constituency and yourself establish that you can rise to the occasion in spite of the challenge you mentioned in the form?
I have no doubt that an opportunity to do something like that would obviously provide more evidence. What I can say is that I sat through innumerable rape cases, predominantly in respect of minor children, when I started my practice, and that was before I was treated for my anxiety and my depression. And I coped just fine. I had no problems there. My anxiety and depression is unrelated to the nature of the work that I do. It's an underlying general anxiety. When I am busy, I find I actually remain more calm. I don't have time to become anxious about the smaller details of my life, which is usually where my anxiety manifests. But definitely, any opportunity to show that I'm more competent or capable would be welcomed. But I don't foresee it being a problem. It hasn't to date.
Yes, Advocate, the issue is not about your competence,
Yes.
but it's about demonstrating to all and sundry that in light of the disclosure you have made, the concerns around that,
Yes.
for you to prove it to everybody that you can rise to the occasion, in the sense that you can run a marathon trial,
Yes.
running something like, 3 months, 6
Yes.
months, which often happens
Yes.
in Port Elizabeth.
Yes.
And sometimes
Definitely.
at the other centers
Yes.
within the division. Thank you, ACJ.
Thank you, Judge President. MEC Gade.
Judge President, good afternoon. I don't have a question.
Thank you. Commissioners, Commissioner Norjesi.
Good afternoon.
Good afternoon.
Advocate, you are English. What African language can you speak?
I am presently learning isiXhosa.
When have you started learning?
Well, the truth be told, I started in standard 3, but by standard 5, I abandoned it. And more recently, I decided that it is prudent to speak the language of the people in whose area I live. Fundamentally, many of my friends are posting WhatsApp social statuses, and
I can't understand them, and that's my own friends. And so I took the decision that it would be prudent to learn it.
Now, there's generally women in the profession have suffered from lack of briefings.
Yes.
They don't receive briefings, they have been undermined, or just overlooked for reasons that they are women.
Yes.
I hear their practice, you've done commercial competition, or what have you done to ensure that women, in particular black women, do access such lucrative work that you are exposed to?
Yes. Whenever I come across a brief in which I believe that a junior, particularly a black woman, would be able to learn, I approach my attorneys and ask them if it would be possible to bring on a junior. If the attorney says that the cost will be too high for the client, then I offer to do it on what is called a senior-junior mentoring basis, which is basically where I give a portion of my rate per hour to the junior. And I've done that in quite a few matters.
Have you done that?
I have, yes. I've got presently, I think, 2 or 3 black female juniors that I've brought on where I'm sharing my fee with them so that the client doesn't pay.
Lastly, I've just noticed that you probably have done criminal trials.
Yes.
At your early stages
Yes.
in the profession. And for sometimes we have not done any criminal case.
Yes.
Would you regard that you are properly equipped to preside over criminal cases, or is that an area that would need some improvement?
I may say that I haven't sat on or in a criminal trial for quite some time. Having said that, I am quite involved in pupillage and help train the pupils in respect of criminal law. I've also devilled for a number of silks and senior juniors in criminal matters on important procedural points.
Thank you. Commissioner Schlemmer.
Thank you, CJ. Good afternoon, ma'am.
Hello, Prof.
I see from your CV and the questionnaire that you've been involved at the university as an external examiner,
Yes.
and I just want to say thank you for the assistance that you provide to academics in this regard.
It's a pleasure.
I think it is important for practitioners also to show their interest still in the development of our students. Now, on another note, when you applied now to become a judge in the High Court, can you tell us what your judicial philosophy is?
My starting point when I'm sitting in a matter is to write for the litigants. I attempt to discern the dispute and to settle that according to the law. However, I'm aware that the law is not as perfect as it could be and can be developed in light of the Constitution. Where that is necessary, I would do so. I haven't yet come across an opportunity to develop the law in that way. For the most part, matters in which I've sat have been solvable on the law as it stands. So that would be my judicial philosophy.
And what is your understanding of the doctrine of separation of powers?
Separation of powers is a fundamental principle of our law in that it guarantees the executive, the legislative, and the judiciary their own spheres of influence and power. However, it is fundamental that each of these 3 balance each other. The place that this comes most to the fore, of course, is with the judiciary and the judicial oversight, and so that is where most of the friction seems to occur. But as long as judges follow the precepts of the Constitution and don't overstep the bounds, then the balance of that separation of powers ensures should be maintained.
Thank you. Commissioner Nyambi.
Thank you, ACJ. Afternoon, Advocate.
Good afternoon, Commissioner.
I will ask you just one question.
Yes.
As somebody available to be a judge in the Eastern Cape Division, any particular significant thing that you think it's a challenge in that division? Should you be appointed to assist JP and the entire division that you have experienced on your acting stints? Share with us.
A fundamental challenge that I've noticed is technological infrastructure. It is exceedingly difficult, and I don't know, frankly, who's to blame, if it's ESCOM or if it's service providers. But on occasion, internet resources won't be working. It's difficult to have a video link court if you don't have the facilities. That is important. I know that case lines is being well used in other divisions, and I think it would be a good idea to think about bringing it to the Eastern Cape. Those two are as far as technology goes. Insofar as other difficulties, and the JP, bless him, has done his best to ensure case flow management works to the best of his ability. But I think an enforcement of the rules of court would go a long way to making matters run on schedule and as quick as possible. If one just followed the rules, the DAs are prescribed and matters could come before court much quicker. And I'm sure that's what the JP is attempting to do with these case flow management processes.
You missed the part of what you will do yourself.
Well, I'll sit with the JP and talk to him about these things that I've experienced in other divisions and how they work. That's the best I can do. I think as a judge, one has very little power over the technological or electrical or public works difficulties that one encounters. One can only do what one can do with the resources one has, and I'll support the JP in anything that will help court flow more smoothly. But I mean, save in the three respects I've mentioned, I have nothing right now that I can think of.
Thank you, Advocate. Thank you, ACJ.
Thank you. I have Commissioner Mutolo Zepu coming next. After that, it will be Commissioner Moimang. And then I'll go to the commissioners on the virtual platform. And unless somebody feels strongly, okay, I will add one because she hasn't asked in a long time. So, but after that, that's Shabangu Ndawe. Thank you.
Okay, thank you, Acting CJ, and good afternoon, Advocate.
Good afternoon, Commissioner.
You know, what I just want clarity on is, you know, when we were doing the consultations for the legal sector code,
yes,
countrywide, and so, where our concern was that SCs don't do enough in the way of training, but don't do enough in training the pupils, and
yes,
we were informed by that SCs don't take pupils.
Yes.
But then they kept on saying the deviling is actually empowering young advocates.
Yes.
But the issue I have with it may be good. I want you to explain deviling for me to
Yes.
understand, so that when we finalize whatever we recommend that it be part and parcel of the SC's empowerment tool in the code.
Yes.
At least I understand it better, because in the Free State,
yes,
they discourage deviling. So I just want
Really?
to know how beneficial is it to this when in the Eastern Cape it's okay, but in the Free State it's not okay. Thank you.
Yes, I obviously can't speak to the Free State. My experience at the Port Elizabeth Bar, I've been very fortunate. It's not only the silks that allow deviling, but let me explain first what deviling is. There are two ways that juniors come on board in a matter. The first is being appointed as a junior counsel on brief, and the second is working behind the scenes without their name on the brief. This second way is deviling. So what it is, for example, if I were a junior, is I would be sitting in my chambers and I'd get a call from a more senior person saying, I need help researching, I don't have time, can you look something up for me? Then I would go and do that research for them and they would bill me out of their own pocket. So the client may or may not ever see that bill, depending on how the senior bills. And that is empowering in the sense that I may never have done research in that particular field, but for the senior, junior, or silk calling me in to help. What is also beneficial there is you can make a name for yourself with the more senior members of the profession without embarrassing yourself in front of the attorneys, or at least running the risk. I actually benefited a lot from that sort of work, and right up until the day I took silk, I was still deviling. It is helping out more senior people when they simply don't have the time or the capacity. I think it is fundamental to a junior's practice, and it is fundamental to more senior members, because one cannot always bring a junior on board. Sometimes the clients don't have money, the lay clients, and I still need the research done, but I can't bill out at my rate. So getting a junior who's charging a third or a quarter of my rate to do the research saves everybody money, and it gives that junior the ability to learn new things and to prove themselves. So it is fundamental in the practice of advocacy.
Thank you. Just to follow up, the issue I have with it is that the other person you bring in is not supposed to be seen by clients. So this is the problem that I have, because she can't be seen. How do we expose them to clients to say this is one advocate, black advocate, who actually did the work for me?
Yes. What does happen sometimes is it becomes apparent later on that the matter may in fact require more than one counsel. And if that's the case, what often happens is the devil is recommended as the junior because they've already done the work and they're up to speed. What also happens is if one does good work, so if one is able to prove oneself on that brief, the next time an attorney is looking for someone to do an unopposed motion or something less complicated, then that devil will be on the list of recommendations by the council because they know the quality of the work that the devil does. So it's a quality assurance process, but a training opportunity also.
Thank you.
May I remind commissioners, the agreement is one question, please. One question. And you remember we agreed I'm going to be stricter today. Commissioner Moiman.
Thank you, Acting Chief Justice. Good afternoon.
Good afternoon.
Okay. Just one aspect from myself on the matter that you have raised as your contribution to jurisprudence, the Bobet SA versus Nelson Mandela Bay. Can you just share with us what is the significance of this case, particularly with regard to the participatory democracy?
Yes.
The involvement of the communities in terms of the decision-making process of local council. Thank you.
Yes. What happened in the Borbet matter was there was an IDP and budget process an integrated development plan and budget process that was engaged in by the municipality in question. And what had happened was they had not involved the public in a manner that ensured that the public had sufficient say in both the budget and the IDP. And the court held that municipalities cannot accept a budget or an IDP without actively engaging constituent members of the municipality. You have to go to the people. The people are who the municipality is for. And by ignoring them or by minimizing their input, the municipality breached its constitutional and legislative responsibility to engage the members of the community in participatory democracy.
Thank you, Advocate. Thank you, Acting Chief Justice.
Thank you, Commissioner. And then Commissioner Shabangu Mdawe.
Thank you, NCJ. Good afternoon, Advocate.
Good afternoon, Commissioner.
Advocate, I'm raising this because I don't see it in your CV.
Yes.
We all know that mental wellness is a problem in our profession and as well as to our sisters on the bench.
Yes.
I just want you to share with the Commission what you are doing in the Eastern Cape with regard to mental wellness and the intention that we want to roll it out into all provinces.
Yes, what has happened is I was approached by the South African Women Lawyers Association, the East Cape branch, to participate in a series of workshops regarding mental health. This was identified as a particular difficulty for lawyers and for women lawyers. And a series of workshops were held. I spoke at the first one, which is evident on my CV, and then I hosted on Zoom the others, but engaged in discussion as well. SOLA would like to roll out the process, the workshops across South Africa, and I believe they're engaged in discussions with the SOLA National to effect this. But it isn't only SOLA that seeks to speak now about mental health issues. For a number of years, the bar in England and Wales have implemented mental health workshops, and we at the bar have in our training courses recognized that many advocates suffer not just stress and depression, but issues like anxiety or OCD, and struggle with coping mechanisms because of the nature of our practice. And so what has happened is we have started the National Advocacy Training Committee has started implementing lectures at their workshops as well regarding mental health. And it is a problem that is wider than we wish to admit, because many of us will suffer from diagnosable anxiety or depression, but we're too afraid to talk about it because we feel that we will be judged, that people will think that we are unable to do our jobs, when just as in the case of diabetes or HIV, if one is medicated and treated appropriately, then one can function as a normal human being and function at high levels. And that is evidenced by numerous counsel who suffer from exactly what I have, but won't come and tell the committee that, the commission that, or won't tell their friends that. And I know that from personal experience because I am open and honest about my diagnoses because I need the support of my friends and my colleagues. And so many juniors and even more senior people have come to me and are open and sharing, and I've been able to give them coping mechanisms and refer them to help when they need it.
Thank you, Advocate.
Thank you, Commissioner.
Thank you. Commissioners on the virtual platform.
Thank you, SCJ. It's Jenny Kane.
Yes.
May I give up my question?
Yes.
Thank you. Good afternoon, Advocate.
Good afternoon.
I see that you've chaired the tax board.
Yes.
If you were placed in the tax court
Yeah.
and the parties had not raised an issue in the Rule 31, 32, or 33 statement,
Yes.
but it became apparent on the facts that a section of the relevant tax legislation was applicable, how would you deal with that in your court?
Well, my goal in the tax board, and what would probably be the same as in the tax court, if parties can settle a matter, it is more beneficial to the parties than having an outcome on either side. And so what I've done in the tax board and what I would do in the tax court is I would raise the issues, and I would allow the parties to go away and discuss it amongst themselves. And if there was non-compliance, then and they weren't able to go back and settle the issue or seek remedial action without recourse to the court, then I would act in terms of the legislation. But my preference would be that the parties be given an opportunity to go away and attempt to achieve what had not yet been achieved.
Thank you for the answer. Thank you, CJ.
Thank you, Commissioner. I think we have come to the end of this interview. Thank you very much, Ms. Beneke.
Thank you so much, ACJ, and good luck with the rest of the interviews.
Thank you. You are excused. Next candidate. Commissioners, let us resume. Good afternoon, Professor Govinci.
Good afternoon, Acting Chief Justice.
Did I pronounce your surname correctly?
100% correct. Thank you.
No, thank you. Welcome to this interview session of the Commission, and thank you for availing yourself.
Thank you. It's
for consideration for appointment as a judge.
Thank you.
Of the Eastern Cape Division.
It's a tremendous privilege. Thank you, Acting Chief Justice.
Thank you. I see that you hold the degrees of BA, which you got from the university, from Rhodes University in 1998. Is that right?
Yes, that's correct.
And LLB, which you got from the same university in 2000.
Indeed.
And then you got your LLM from the University of Port Elizabeth, 2002. Now
Yes.
Nelson Mandela University.
Yes, that is so.
And your LLD, or you got your LLM cum laude, actually.
Yes.
And you did it in labor law.
Yes, I did.
Yes, and then you got your LLD from the same university, that is Nelson Mandela University, in 2005.
Indeed.
But I see that you also served articles and you were admitted as an attorney.
Yes.
Yes, was your admission in 2002?
Yes, that is so.
Yes, and you worked as an attorney until 2005, but you also started lecturing at the University of Port Elizabeth.
Yes, I received a full-time position in January 2003.
Oh, okay. Or I thought maybe you were part-time in lecturing between 2003 and 2005.
No, I was part-time in 2002, Acting Chief Justice, and then became permanent in January 2003.
Yeah, I think in your questionnaire, it gives the impression that between 2002 and 2005, you were a professional assistant at Sony Incorporated.
Yes.
And in 2003 to 2004, you were a lecturer.
I can explain that, Acting Chief
Yes.
Justice. The university allows academics to do a day per week of private work with permission.
Yes.
So I remained practicing as a professional associate for that one day per week, but I was permanently employed by the then University of Port Elizabeth from 2003.
Okay, okay. And then did you stop practicing at some stage and became full-time in lecturing?
No, Acting Chief Justice. What happened is that I continued to use the benefit of the one day per week, continued to be affiliated to the firm in Kleberg, formerly Port Elizabeth.
Yeah.
And then at some point used that time to serve the Commission for Conciliation, Mediation and Arbitration. So I continued to remain in practice in that capacity, subsequently as a senior commissioner, and remained so until 2016, I believe, when I then began working for Cliff Decker Hofmeyr on a similar basis, but only on a one day per month basis, because by then I was appointed as the Dean of the faculty, and then the one day per week shrinks to one day per month.
But that kind of practicing must be difficult, isn't it? One day a week.
What it involves, Acting Chief Justice, is that the award writing and the like would have happened over weekends.
Yes.
So what worked very well with the CCMA work was that I could give a day where I knew there were no lectures, then go and conciliate matters or arbitrate matters, knowing that I would then use my weekend time or evenings in order to write any awards that I carried from that particular day.
Yeah, no, I can understand how it would work if what you were doing is using the one day a week to, for example, have an arbitration hearing, and then you write the award either in the evenings or weekends. But I'm not sure how it would work if your one day a week meant do clients' cases in a law firm.
No, the work, once I became permanently employed by the university, Acting Chief Justice, the work for the law firms became very much of a consulting nature in the form of opinions and the like. I, for a few years, continued to wind down the practice that I had established at the firm on that same basis, but it wasn't in a sense anything more than being effectively a consultant for the bulk of that period.
Yes, yes. So, all in all, in terms of your practice experience, what kind of period would you say you have had exposure to the real practice of law as an attorney over the years?
Yes, it's a difficult question to answer. The best way I can describe it is that I had intensive practice during my articles. Immediately subsequent to the articles, developed my small practice. It was a small firm, and thereafter transitioned that to a consultancy role where I could then be approached by the firm for opinions. My time at Cliff Decker Hofmeyer, that has then been almost exclusively in the area of employment law. And again, that's in the form primarily of opinions, seminars, training for the partners and the directors who work in that field and the associates. So it's very much a part-time form of practice. My core responsibilities since 2003 have very much been rooted in academia.
And then you started, you have been given an opportunity to act in the High Court this year.
Yes, that is so. From January, I've completed the bulk of 3 terms acting Chief Justice.
And how did you find it?
It's been a phenomenal experience, an absolute career highlight. I've always said to my students that all students should aspire to serve the bench. We may not all get there, but that is the absolute pinnacle of the legal profession. And it's been an absolute career highlight. It's been hard work, but I think I've enjoyed the variety of the work in the High Court. It's been a steep learning curve, and I've worked hard in order to try to cope as best I can. I feel that I've done so, and I feel that it's been a very, very positive experience for me, and one that I would encourage others in my position to explore if that opportunity ever came along.
Yes. And during your acting stint from beginning of the year up to now, have you done both criminal and civil trials?
Yes, Acting Chief Justice. I've completed 3 criminal trials, 2 gang-related murder cases, as well as a rape case. I've handled, I believe, about half a dozen civil trials to completion, and I've had quite a few opposed motions where I've had to deliver judgments in a reasonably short period of time.
And you have done motion court as well?
Yes, I've had a few opportunities of motion court, 4 or 5 weeks, I believe.
Yes. And how did you find motion court?
Yes, it's been an interesting experience being the duty judge. I found that preparation, I'm very anxious on the Thursday or Friday to get the files for the following week so that that weekend of sacrifice can commence. But that, I believe the preparation has helped me, and it's also been fortunate that there have been some seasoned hands that I've been able to turn to when I felt that I needed some guidance. So again, a steep learning curve, but one that an experience that I've been grateful to have had the opportunity to undertake.
Judge President.
Thank you. Thank you, ACJ. Professor Coventry, good afternoon.
Afternoon, JP.
At pages 15 to 17 of the document, it's an indexed document, headed List of Judgments by Eastern Cape Candidates. Your setup will be found from pages 15 to 17.
I'm battling to access that, JP.
They will supply you with the relevant document.
Thank you. Yes, right in front of me. Thank you, JP. Yes.
Will you go to page 15?
Yes, I'm there.
So you acted from the 18th to the 26th of March, a full-blown term.
Yes, that is so.
And then once again, 12 April to 31 May.
Yes, indeed.
And then 17 July to 17 September, once again, a full-blown term.
Yes.
Then at page 17, you will find the summation. You've written 13 opposed application judgments.
Yes.
Then you've had 6 civil trials where you wrote judgment.
That is so.
You ran 3 criminal trials and you penned 3 judgments.
Yes.
Criminal appeals, 3, civil appeals, 3, criminal review, 2.
Yes, JP.
Which of those did you find challenging, if at all?
Yes, I found sentencing to be the most challenging, I think, from an emotional perspective. I found the burden of having to cast judgment on sentencing to be something that gave me a sleepless night on each occasion.
Yes. And I seem to recall that at some point you penned a judgment on tax law.
Yes, that is so.
Is it numbered somewhere here?
Yes, it would be. If you give
If
me...
I remember well, you handed down judgment almost on the same day.
Yes, I did. It's the matter of, I believe it's the matter of ICR utility management versus Headbush, which is on page 15.
Page 15.
I'm pretty sure it's that matter.
Yes.
Yes.
Thank you. And then, if you were to be appointed, what skills would you bring to the bench?
Judge President, I would like to think that the experience that I've had in academia, and some of the professional bodies have alluded to that, I would like to believe that has given me a set of skills that is not unlike what sitting judges possess, but perhaps comes from a slightly different angle. The art of publication and writing for publication, the research that underpins that, I found those aspects to be particularly useful in transitioning this year from full-time academia into an acting role. So I believe that, and I think I might be speaking for academia in general, to say that there's a thoroughness that comes with the research for publication process that would be beneficial and would hopefully serve the bench well.
Yes. At page 17, there's reference to a case you set together with me and another colleague, Minister of Police versus Page.
Yes.
Yes. I just want to place it on record that I was impressed with the manner in which you interacted with counsel who were arguing that matter.
Thank you, JP.
You were nominated by Senior Counsel Kroon of the Port Elizabeth Bar, who has also acted as a judge on some occasions.
Yes.
And then also by the Nelson Mandela University Vice Chancellor.
Yes, the university has been very supportive, JP.
And then also by the Deputy Vice Chancellor Academic, University of Johannesburg.
Yes, that is so.
And then I'd like you to tell me more about this nomination. It seems the name is Pumezo, but
yes, it's a former student who's a director at a
black or white
firm. Black. Was that your question?
The person who penned the letter is black.
Yes, Pumezo David. It's a black African.
One of your products.
Yes, indeed. A former student who has been director at Knowles Hussein Lindsay, but has now moved to another firm.
What are your views about case flow management?
JP, I've had the opportunity to undertake some case flow management activities myself when I was sitting in the Bishu High Court, and I feel it is a useful tool to help the courts to streamline the matters that deserve to come before it to be heard. So applied properly, it can really streamline the process and ensure that the right cases come forward at the right time. I, of course, would need to experience it a little bit more to see what some of the pitfalls may be and the manner and some of the techniques in which to circumvent those pitfalls. But in principle, I'm in favor of it.
Yes. And lastly, a concern has been expressed that you are new in the profession. When I say profession, particularly the bench, in the sense of not having been a practitioner yourself. Now, in light of the judgments that you've penned and the scholarly and qualitative nature of those judgments, how would you respond to that concern?
I can understand that on paper, if commissioners look at 3 terms and perhaps just at a glance, there might be that concern. The experience has been an immersive experience for me. It has been 3 complete terms. In fact, my own preparation for my first acting stint commenced in November last year as I started preparing for what was to come. And that is a discussion on its own in terms of how acting judges can be best prepared. I've been fortunate that during the course of the year, and I don't think it would work that way for all acting judges, where my cases have run, I've managed to run them to completion, I've managed to work hard to get the judgments out, not only quickly, but with the level of thoroughness that I believe the public and the parties and fellow judges would expect. So I would want to be judged by not just the number of weeks, whether it's 27 weeks or whatever the number of weeks is, or the 30 judgments, but I think the acid test really is the quality of those judgments.
What you produce.
Yes, my experience has been that this is a unique vocation where it's a combination of depth and pace, and it takes I think a lot of wisdom and a lot of asking the right people at the right time to know when is it appropriate to hand down a judgment in an opposed motion roll on the day, and when in fact is it appropriate just to pause because the costs order that you're about to deliver might be unfair to one of the parties. So I would want my term as an acting judge to be judged on what I've produced, the quality and depth of the judgments in addition to the quantity.
I must say, senior judges speak highly of you, Professor Kavenji.
I'm humbled to hear that. Thank you, Judge President.
Finally, from a legal education perspective, what would you bring to the bench?
This is really something that is an absolute passion of mine. I've had the privilege of serving the South African Judicial Education Institute for the past year as the South African Law Dean's elected representative on that body. I've also had the privilege of serving the Legal Practice Council and its Education Committee. But I am absolutely passionate about legal education for obvious reasons. My career has been steeped in that. And I really would want to, irrespective of what the outcome might be of this or any future processes, I would want to offer to assist the judiciary and SARJ to really do what it can to prepare aspirant judges, acting judges, as well as can be using technology. For example, you may know that I've created a shared Dropbox feature where I mentioned in November I'd started my preparation, and it took me quite a while to figure out what was going to be most useful. For example, the book published by LexisNexis by Southwood J has been an absolutely indispensable tool. I've relied on that for some run-of-the-mill matters, and I've lent on that, and it would appear in my judgments. But to piece together all of that, not that one would use a pro forma, but just to know how to set out a leave to appeal, all of those things, that's documentation, that sharing of that with other aspirant candidates can only be to the enhancement of the judiciary as a whole. And of course, I want to add to that finally that I think the bridge between academia and the bench is such a crucial one, and I have some ideas in that respect, because after all, even if academics aren't going to ascend to the bench, they are going to be producing the next generation of judges. They are sitting in those classrooms, or virtually, as the case may be right now. So there's a lot to be done on legal education, in my view, both on the part of the bench, but also in terms of how we integrate practice with academia in order to produce better future practitioners, which will then lead to better judgments on the part of the future judges.
Thank you, Judge President. MEC Gade, if you have got questions, I give you the chance to put questions to the candidate.
Thanks, Chief Justice. Just one question for me. Prof. Goveja, good afternoon.
Good afternoon, MEC.
If you given an opportunity, what could be your attitude or your contribution in ensuring that as general as government and as well as judicial, we live to the expectations of the call for ethical and developmental state, looking to the current environment that the country is confronted with? Because my sense is that judicial system is at the center of the turnaround strategy of what then the country is confronted with.
Yes.
So my interest is how best can we ensure that we live to that expectation, general as a nation, but of course at the center of that will be the judicial system.
Yes, I think it's not uncontroversial to suggest that the judiciary should sit at the center of that system. I'd place the Constitution at the center of that, and I'd consider that an approach in which, yes, the judiciary has a role to play, but likewise the executive, the legislature, state-owned enterprises, the civil society as well, but also the Chapter 9 institutions. I believe that strengthening each and every one of those dimensions is ultimately going to lead to the ethical conduct that you refer to, and to the fabric of our society then being what we wish it to be, and achieving the aspirational goals that the constitutional sets for us. So I would see the judiciary as an important role player, of course, interpreting the law, developing the law in line with the Constitution, but I would also see the strengthening of the other role players in fulfilling their constitutional mandate to be a key element in ensuring that society as a whole benefits from ethical leadership and conduct.
Thank you, MEC. President Meyer.
Thank you, Mr. Chair. Good afternoon, Prof.
Good afternoon, President.
You speak with such enthusiasm about judicial office, but I worry and seriously wonder if a man of your many legal talents won't be bored, if you are appointed by what you find when you have to spend the rest of your life in the institution. Anyway, I was just scouring through your extensive CV, looking for a recent publication, the Yearbook of South African Law, into which you wrote, Justice Madlang and I, but I can't find it. Can you tell us a bit about that?
It's probably an omission. I'm not an author to that publication or an editor. I serve alongside you and other colleagues as part of the advisory board. Yes.
All right. Well, you should have included in this CV.
Yes,
I did notice.
It's a grave omission. Yes.
Yeah. All right. Thanks, ACJ.
Commissioner Dodovo.
Thank you very much, ACJ. Good afternoon, Prof.
Good afternoon, Commissioner.
Yes. My question will center around municipal interventions. Many municipalities in the Eastern Cape have got a lot of problems
Yes.
which require some intervention by the provincial government, and it invokes Section 139 of the Constitution. Have you presided or handled or participated in any of such matters?
No, I haven't to date, Commissioner.
You haven't?
No, I haven't.
So if that is the case, then I'm not following up this, even if it was quite important. Thanks.
Thank you. Commissioner Moiman.
Thank you, Acting Chief Justice. Good afternoon.
Afternoon, Commissioner.
I just want to canvass the point that you raised earlier on around putting the Constitution at the center. The sense that I got is that you are downplaying the role of the judiciary in promoting a good governance. What happens where the executive or the legislature act in a manner that undermines the values of the Constitution?
No, indeed, Commissioner, let me be unequivocal. It's then the duty of the judiciary to ensure that conduct that is inconsistent with the Constitution is declared unlawful. What remedy is then to follow? That is another matter. I was seized with such a matter in a case involving an NGO coalition where the lack of consultation on the part of a state actor led to the court having to make a finding that conduct was unconstitutional and invalid. The remedy, of course, that was a separate discussion. But the judiciary has a key role. Section 2 of the Constitution makes it clear: any law or conduct inconsistent with the Constitution is invalid. When those matters come before the court, courts are obliged to fulfill their role in declaring such conduct to be invalid. And in addition to that, I'm not sure if that's what you were referring to, but of course the judicial ethics, which is part of, that's a part of it, but it goes way beyond that. That, of course, also needs to be upheld as judges fulfill their constitutional function. So the Constitution at the center, with the role players playing their role, and the judiciary having a key role in holding the other arms of government to account.
Thank you, Prof. Thank you, Acting Chief Justice.
Thank you. I have Commissioner Matonsela, Commissioner Matolo Zepu, and Commissioner Klaba. President Maya has twisted my arm because she didn't ask her question. She talked about other things to the candidate. But I don't propose to take more questions inside. After that, it would just be the commissioners on the virtual platform. Commissioner Matonsela.
Thank you, Acting Chief Justice. Good afternoon, Professor Govinji.
Good afternoon, Commissioner.
A survey of your CV gives me the sense that you are an academic in labor law, or you have some expertise, academic expertise or qualifications in labor law. And the question is, do you not see yourself more as a labor lawyer as opposed to a judge in the parochial courts?
Yes. No, thank you very much for that question. I've, of course, my background as a CCMA commissioner and a senior CCMA commissioner, and my role with CDH in Johannesburg has been employment law focused. But what happened to me, by a quirk of fate, my mentor at the university had captured the labor law market when it came to teaching, and I branched off at that point into the area of social security law, and through that developed a keen interest in equality law. And I've been fortunate to also work and promote a number of doctoral and master's candidates, and I've invested myself in their interest areas as well. So academically speaking, I would actually consider myself to be primarily a social security lawyer. My National Research Foundation rating would have been based primarily on my scholarship in the area of socioeconomic rights, but social security specifically. And I've been fortunate to have publications. For example, recently the Constitutional Court cited a co-authored piece in the area of hate speech in the Kwelani matter. So I've been fortunate to be able to write and engage in scholarship that goes way beyond labor law and actually is rooted in social justice and in searching for legal strategies to address the situation experienced by vulnerable communities. I've also worked in areas of disability law, for example, a co-authored piece in the South African Journal of Bioethics and Law with medical practitioners looking at the notions of disability from an integrated perspective, not just legal. So I would consider, I might have said 18 months ago, if you'd said to me, you know, we'd like to give you a chance to act, and labor law would appear to have been a soft landing. Having tasted the variety of work that has been thrown at me in the High Court, I would like to think that that I'm able to cope with the demands of the High Court, and that would now very much be my aspiration.
Thank you.
Thank you, Commissioner Motolo-Tlepu.
Thank you, Acting Chief Justice. Good afternoon, Prof.
Good afternoon.
I just want to declare that he's a member of the LPC, so that's why.
Yeah.
I just want to find out from you. You have been in the LPC, Education Committee. You were in academia. Now you want to jump to the judiciary. The complaints that we always have is that we need to change our syllabus of training advocates and attorneys. Do you think what we have done, because I know that there's a concern that the syllabus of advocates is just too packed for 6 months. Do you think is it okay, or we should, I acknowledge the concerns, but
Yes.
because you're part of that committee.
Yes.
Because the chairperson of the portfolio committee is here, just explain.
Yes. Yes, thank you. Thank you, Commissioner. I almost said chairperson, but that would have been a faux pas. No, I think you know, it resonates a little bit with the 4-year, 5-year debate that all the law schools have had to deal with as well. And I think you will get polarized opinions on that. From the one perspective, of course, the more the merrier. The more time one has in order to deal with education, the more notionally one can put into that. But I think one has to look at the, as you call it, the syllabus in connection with what's going to happen post-admission. So the amount of material that post the LLB needs to be digested for legal practitioners to attempt the examination set by the Legal Practice Council, whether they're going to be a trust account advocate or attorney, that's one part of it. But I think a number of practitioners fall into the trap of seeing that that LPC now examination as being the final hurdle after which education needs to cease. And I think it's very, very clear that with the wide breadth of areas of law, that I think one needs a system and an articulated system of continuing professional education that will ensure that there's continuous growth, so that practitioners who don't have the benefits of dealing with taxation matters or the like maintain those skills if they choose to do so, so that ultimately they can serve the profession in an even higher way.
Thank you.
Thank you.
Commissioner Tlaba.
Thank you very much, Acting CJ, and good afternoon, Prof.
Good afternoon, Commissioner.
Thank you very much. Prof, I've been in the public sector
Yes.
since 1994.
Yes.
And there's a perennial problem. I'm sure with your experience as a labor expert, you would help guide me on this one. Where people, you know, public servants resign before they are charged,
Yes.
or immediately after they are charged, only to emerge
Yes.
in another department or an organ of state.
Yes.
Have you experienced that as a problem? And if yes, where would you point that as a weakness
Yes.
in our labor legislation?
Yes, indeed, Commissioner, that is an issue, and there have been 2 or 3 different cases and that have come out dealing with that matter. So there've been decisions initially going in different directions. It is a problem. The present solution, as far as there can be a solution, would be to utilize the notice period and to conduct a disciplinary process during that period, even if the person indicates that they've resigned and doesn't intend to participate. And of course, the purpose for that would be to try to get some form of a record to avoid the type of hopping that you refer to.
Is it illegal? Is it legal to hold a person to a notice period?
Well, as I suggested, Commissioner, I believe there are different case authorities, but the most recent authority appears to suggest that that would be permissible. Yes.
Thank you so much. We'll do that.
President Mai, you are covered. Okay, all right. Commissioners on the virtual platform, is there anyone who has a question? No one has a question. Judge President Mlambo.
Thank you very much, Acting Chief Justice. Good afternoon, Mr. Govinji.
Good afternoon, JP.
You seem to have a lot of energy, and I'm just piggybacking on the question that President Maya asked you. The JP will forgive me if I'm wrong, but if you were to get the nod, would it be one of your projects to establish legal help desks at the courts to assist indigent, unrepresented litigants who are always summoned, especially by big banks, to come and defend themselves? If they exist, you can stop there. If they don't, I just want to check. You seem to be full of energy and ideas.
Yes. Thank you for raising that, JP. They do exist at both the CCMA level, where my own institution, the Faculty of Law, and through the colleague that I mentioned earlier, has been instrumental in providing that type of service through the university's Labour Law Clinic. That assists at the CCMA level. And then, of course, there's a SAS Law project which has assisted in providing that type of help desk in the labour court environment. It would be very interesting and I think appropriate to consider extending that to the type of assistance that could be provided at the High Court and the other courts as well. Yes.
Thank you for that. The last question is, have you told the BLA that you're a man?
Yes. No, I assume that they would take judicial notice of that fact once I entered the room, JP.
Thank you very much. We have come to the end of the interview. Thank you for availing yourself, Professor Coventry. Thank you very much. You are now excused.
Thank you, Acting Chief Justice, and thank you to all the commissioners. It's been a privilege to appear here today.
Thank you. Next candidate. Let us start. Good afternoon, Mr. Goff.
Good afternoon, Acting Chief Justice, members of the Commission.
How are you this afternoon?
To say I wasn't a little nervous would be to tell a fib, I think, Acting Chief Justice.
Now, relax. Relax. You are going to enjoy the interview. Thank you for coming to this session of the Commission's interviews, Mr. Goff, and thank you for making yourself available for consideration for appointment as a judge of the Eastern Cape Division of the High Court. I see that you hold a BA and LLB from, is it?
Rhodes University, Acting Chief Justice.
West University.
Rhodes.
What university?
Rhodes University, Acting Chief Justice.
Oh, yes, okay, thank you. And you got them in 1980 and 1982, respectively.
That is correct.
And you started your career in law as a prosecutor.
For a very brief period, Acting Chief Justice, it was a holding phase of my life. I prosecuted for 3 or 4 months at the beginning of 1984.
Yes, and thereafter you went to do articles.
Yes.
And you were admitted in 1986, is that correct?
August 1986.
Yes, and thereafter you practiced as an attorney for quite some time after that.
From 1986 until date, Acting Chief Justice.
And that makes it how many years?
37 years.
That's quite long. So you have a lot of experience.
I have been fortunate to have many years of experience acting Chief Justice.
Yes. Can you tell us what types of cases you have had to deal with in your practice over these years?
Acting Chief Justice, I've been very fortunate, and perhaps growing up in a city such as Port Elizabeth, where one can't afford the luxury of specialization, I've been exposed to almost all aspects of legal practice. As a young article clerk, as one is wont to do, you start off in debt recoveries. It teaches you how to stand on your feet and work your way forward. Recovery of damages, insurance claims, family law, professional negligence claims. And as my practice developed, I became more and more involved in commercial law matters and in public law and administrative law matters. But I've also had the privilege of being exposed to competition law matters. We will see from my curriculum vitae that I was involved in a large collusion matter in which I handled from right from the investigative stage through to an appeal to the Supreme Court of Appeals. I've been involved in liquidations, interrogations. I've had some exposure to interrogations under the Tax Administration Act. But principally over the last 20-odd years, I guess my practice has focused primarily on public administrative law, which has involved obviously constitutional issues, some constitutional challenges on legislation, and then also I've been involved in complex commercial matters. But aside from that, I've also, and I believe it's an important foundation in one's practice, I've been involved in commercial law. For instance, I was the in-house legal advisor essentially the in-house legal advisor from cradle to grave for the construction of the stadium in Port Elizabeth. I have been involved in the development of sustainable energy projects, all of which have stood me in good stead for my practice, which has largely been founded on commercial litigation and public law.
Yes, and I see that there's a long list of cases in which you have been involved that have been reported.
Yes, Acting Chief Justice.
Is that right? And there is one in the Constitutional Court, and there are quite a few in the Supreme Court of Appeal, and I say quite a few, maybe that's about 10, I'm not sure.
Yes, Acting Chief Justice.
And then in the High Court, you may be having about 12 or 15 or thereabout. Is that right? That's more or less right.
That is more or less correct, Acting Chief Justice.
Now, in your practice, did you actually do appearances yourself as in terms of arguing cases and doing trials, or did you always brief counsel for purposes of arguing those matters and conducting trials and attending inquiries? What was the position?
In the earlier stage of my practice, Acting Chief Justice, I personally appeared in criminal matters, civil matters, insolvency inquiries and the like. But as my practice evolved and the matters became more and more complex, I involved counsel more often. I've, for instance, personally argued matters in the Labour Court. But I don't believe that I could give justice to my client's needs and requirements by personally appearing, but at the same time doing the long, hard hours of preparing a case properly for trial.
Is that simply because you prefer to play that role as an attorney and have counsel rather than do both? Because obviously those attorneys who appear and present argument or conduct trials do both the preparation and the strategizing for a matter, for a trial, and actually the execution of the plan.
I think the nature, the way that my practice has evolved, Acting Chief Justice, I would never have been able to do justice with the size of the matters and to prepare and then spend 2 or 3 weeks in court, but at the same time still prepare and manage other matters.
Yes.
It's the way my practice evolved. It's not to say that I don't enjoy or did not enjoy when I did it, standing on my own 2 feet and strategizing and running the matters myself.
Yes. Would the position be that if it's a big trial, such as one that could take 2 weeks or 3 weeks, you would spend most of the time in your office because you have to manage other matters, and then get somebody else, maybe a junior attorney, to be with counsel in court, or a candidate attorney? Or would you also be with counsel throughout that kind of period?
It would typically depend on the nature of the matter, but if it was a significant matter, I would obviously prefer to be in court, because the use of counsel is not, you don't pass the buck the moment the trial starts. You have to develop your strategy and ensure that your counsel are doing what you've strategized over, to pick up the nuances of the court, to see, you're better positioned often to observe the responses of witnesses, and it's that type of first-hand knowledge which assists counsel during the tea adjournments or after hours when you're discussing the matter, and also in ensuring that when you give feedback to your client, you can tell them firsthand what has been happening.
And you've had a chance to act as a judge in the High Court as well?
Yes, Acting Chief Justice.
Yes, and how long have you acted?
It was a short stint. It was 6 weeks from October 2019 until the first 2 weeks in November of that year.
Yes. And how did you find it?
When the JP first approached me, Acting Chief Justice, I thought, what is this experience going to be? Will I be equipped for it? Will I be able to manage it? And I thought to myself, I must give myself an opportunity to experience life as a judge. So at first hand it seemed challenging, but from the moment that I walked into court, I realized that not only was it challenging, but it was also, for me, a new experience to learn and grow within myself, and to appreciate that, yes, you do have the skill sets to do the job.
Yes. And you did both civil trials and criminal trials and motion courts.
I wasn't exposed to criminal trials, but I did criminal appeals and I did a bail appeal in Bishu.
Yeah, and motion courts?
I was the duty judge for 3 of the weeks, 2 in Grahamstown and 1 in Bishu.
Yes, okay. Judge President.
Thank you, ACJ. Good afternoon, Mr. Gaff.
Good afternoon, JP.
I must say I was impressed when I read your CV. It is really attractive. And then you acted for 6 weeks, yet you were so productive that, according to what appears at pages 18 and 19, which is basically a grid setting out judgments that you penned, within that 6-week period, you were able to write 8 judgments in opposed applications. And I see one was from the unopposed court, one was an urgent application. You ran 2 civil trials and you penned a judgment, a criminal appeal, 2 civil appeals, 1 bail appeal, 2 applications for leave to appeal, and 1 criminal review. Would you confirm that as being the accurate state of play?
Yes, JP. I think in total there were 16 judgments that I wrote over the 6-week period that I sat.
You've been afforded the opportunity to act once again during the current term.
Yes, JP, and as I say, you graciously gave me two days off to attend this interview.
And thank you. Are you familiar with the concept case flow management?
Yes, JP.
Yes. Do you know why it took some time for case flow management to take root in Grahamstown and Port Elizabeth, and was embraced in Mthatha and East London, Bishop?
JP, I don't know the history as to why it took so long, but I don't understand the resistance to it. I think it's fundamental to ensuring that our courts are not bogged down by matters being put on the roll and then not being expediently dealt with. I believe the public is entitled to have their matters disposed of expediently, but I can't say that I'm aware of the reasons for the resistance to it.
But now that it has taken root, are there any regrets on the part of the practitioners, both in Grahamstown and Port Elizabeth?
I can't speak for.
You have not sensed that.
I can't speak for Grahamstown, but for me personally, in Gqeberha, what it means to me is that attorneys need to apply their minds to matters earlier. And if there's grumbling about that, well, so be it. If they've got to do a bit more work or a few more hard yards, then that's what's required of them.
Yes. Thank you very much, ACJ.
Thank you, Judge President. MEC Gade, if you have questions for the candidate, I give you a chance to ask him now.
Thanks, SJ. I don't have a question thus far.
Thank you very much. Any questions, commissioners? Commissioner Notetsi.
And Afternoon, Mr. Goff.
Good afternoon, Commissioner.
I see that in 1984 you were already.
Please speak up, Commissioner.
I see that as early as 1984 you were already an admitted attorney.
No, I was admitted in August 1986, but I was prior to that for a very brief period for the purposes of when I was a prosecutor admitted as an advocate for a very short period.
Now, since your admission, how many black practitioners or candidate attorneys have you afforded an opportunity, either in your previous firm or in your own office?
I haven't kept statistics, Commissioner, but I can say that we have our firm has employed any number of black candidates, and we started that practice from the late 80s into the early 90s. I can't give you the statistics, but I can say that our employment practices, certainly over the last 10 to 12 years, have meant that we have predominantly employed black candidates.
I'm saying in your name, you know, a candidate attorney is registered under a director. You as a director, who are the African attorneys that were registered under your name in a firm? Just if you do have.
I have not personally had any candidate attorneys registered in my own name since probably 1990, Commissioner. So I have had no black candidates myself registered in my name.
Let me simply put it this way. Since you were admitted, a director like myself, once I'm admitted, I should register at least a maximum of 3 candidate attorneys. That is part of entrance to the profession. I'm saying you, as a person, have you ever registered a single African?
I've already answered that, Mr. Commissioner. My answer was no.
Yes. Then that would have been your contribution in terms of transformation. That would be a direct contribution. Put aside that one of briefing black advocate, but just to have an African who have been so excluded for so many years, just register. When you look back on that, would you regard yourself to having contributed in the transformation of within the profession?
Yes, Commissioner. I don't believe that the registration of candidates in your personal name, in your own name, is a measure of your contribution towards transformation. The fact that I have not had candidate attorneys, whether they were black or white, registered in my name since then is I don't see that as being a basis on which to conclude that I have not contributed towards transformation.
My problem is that once we say black or white, I'm not talking about black or white. I'm concentrating myself on Africans who have been so excluded, particularly in areas such as the area where you come from. Very few firms run by African practitioners. Would you not say, when you look back, you sit here, say, as little that I could have done would be this, that is, allow some access to the profession by this way, because that's what the legislation allows you to do. That's the emphasis, that you can take at least a minimum at a time in a period of 2 years. That's 3, only 3, under your own name as a director.
I don't know that I can take the answer any further than I have, Mr. Commissioner.
Okay.
But I freely recognize the hardships and the imbalances and the prejudices that in particular Africans have been through. But I don't believe that that the fact that I personally, as opposed to my firm, have not employed black candidate attorneys is reflective of my commitment to transformation.
I may have missed something earlier on, Mr. Gulf. Is the position that over the 37 years that you have been in practice, you have never taken an African or black candidate attorney under your wing and registered them, but the law firm has done that, but not attached to you personally? Is that the position?
Acting Chief Justice, if I can maybe explain it this way, is that the registration of a candidate attorney in the name of one of our directors or one of our professional assistants is not reflective of how we manage or run our practice.
Yeah, no.
So the question, the
I
answer
want
to
to
the
get
question
the facts right first.
Yes.
I want to get the facts right.
Yes, as I've said, I have not myself personally had a black and in particular African candidate registered in my name.
Have you had a candidate attorney who is not black registered in your name or in the 37 years?
As I've said, Acting Chief Justice, I have not had candidate attorneys registered in my name since the early 1990s. It's not the way that the practice has evolved. So prior to that, the answer is I don't recall offhand, but probably not. I don't know. I have not kept records.
You started practicing from, was it 1986?
1986.
86. So the period that you are sure about, that you never had a candidate attorney of whatever color registered in your name, is from 1990 up to now.
I would say that that's an approximation. As I've said,
Yeah,
I
more or
have not
less,
kept
more or
records.
less.
Yes.
But before 1990, you think maybe you did. But
I
it would not have
I
been a
have-
black or African if it happened.
I can't say with any certainty, Acting Chief Justice. It's not something that I've kept records or been particularly mindful of.
Yeah, no. If from 1990 up to now, you never took any candidate attorney under your name, whether black or white, there is no way you would not remember the candidate attorney that you would have taken between 1986 or 87 to 1990. You would know the only candidate attorney you ever took was so and so, because it would be one or two.
As I say to you, Acting Chief Justice, as I said to you, in all probability not, but I can't say with absolute certainty because I have no record.
But if the law is still the same, when I was in practice, you, as an attorney, you were not allowed to take an article clerk until you had completed at least 3 years of practice. So if you were if you were admitted in 1987, you would only have qualified to take an article clerk in about 3 years later, around 1990. If you say you are certain that more or less from 1990 up to now, you have never taken an article clerk or candidate attorney, whether black or white, it probably means you have never taken
as I've said to you, as I've said to you, Acting Chief Justice, that is indeed so.
Yeah, it's quite extraordinary. Yes. Do you want to follow
just
up?
a follow-up.
Okay.
Sorry, with your leave. Now,
Okay.
in the matters that you have, for instance, the one that went to Constitutional Court, or 10 that were in the SA, 10 matters in the SA, you mentioned, who were the African advocates that you briefed? Just name one.
There were none involved in the Constitutional Court matter.
in the SA 10 matters?
No, we did not use.
Now, I'm asking you these questions simply because the preamble to our constitution dictates that we must heal the division of the past, and among the other instructions is that we must free the potential of every citizen. Would you regard yourself as having been committed to this constitutional undertaking or value, founding value of our constitution? Are you committed to the constitution?
Yes.
But you just yourself admittedly, in your own practice, something that would allow access by those that were previously disadvantaged, you take no steps. In your matters that you brief, you just brief none. Thank you very much.
Thank you. Just to make sure, at least I understand the position, we referred earlier on, Mr. Gaff, to the many reported cases that you have listed in the questionnaire in which you were involved, some in the High Court, others in the Supreme Court of Appeal, and one in the Constitutional Court. Is the position that in none of those cases did you ever brief a black counsel, or in particular an African?
I believe that is probably the position, is Acting Chief Justice.
Yes. Okay, all right. Commissioner Mpofu.
Thank you. Good afternoon.
Yes.
He's here.
Thanks. This side.
Yes.
Thank you. Yes. No, just out of interest, when you served in the South African Defence Force in 1982 to 1983, what kind of duties did you perform?
I was a military law advisor.
Where? Based where?
Where?
No, I'm just saying based where, just in case maybe we met by accident.
No. I spent 6 months in then Southwest Africa, and 6 months in Grahamstown.
Okay, thank you.
I must mention this, Mr. Gaff, just so that we don't have a situation where I take your answer that you have given to my question arising out of the questions from Mr. Nojesi in a certain way, and I make a certain inference without giving you a chance to say, to understand and maybe say why I shouldn't make that inference.
I think, Acting Chief Justice, it is indeed so that on the face of it, the briefing patterns may seem and are skewed, but it also doesn't take
Allow me to tell you what I want to put to you. Then you'll get a chance to say whether I should see it that way. You have in the country white advocates, you have got black advocates that you could use over 37 years of practice, and you only used white advocates and never used black advocates over so many years. Is it because you did not have confidence that black advocates could do the job?
Well, firstly, Acting Chief Justice, it's not correct that I have not used black advocates. They might not reflect in the reported judgments.
Yes. Have you used them in matters other than those that are reported? Because I thought Mr. Nojesi gave you a chance to indicate even just one.
No, I understood his question to be talking. He specifically said in the Constitutional Court and and the reported matters. So
Yeah,
the answer is yes.
Yeah. Yes, you have used them.
I have briefed black advocates and, in particular, African advocates in matters.
Yes, are you able to give us their names, or some of them at least?
Yes, Advocate Nkatuba, Advocate Pango, Advocate Nati Gaisa, Advocate Kamana. I don't recall offhand the names of others, but I have made use in the same. I have made use of Black Council. Yes.
And would you have made use of them in matters that went to court, or only in regard to opinions?
No, they've been used as juniors in trial litigation and in arbitrations. They've been involved in the drafting of papers. They've been involved in all aspects of the matters that I've been involved in. Now it springs to mind. I've briefed Advocate Bevan Boswell, Advocate Katesh Gadjar, to name a few. I have. But it's not a confidence issue at all, Acting Chief Justice.
Yes, okay. Is the position that they were used as junior counsel and were led most of the time or all the time, or it was a mix? Sometimes they were not led, they were the lead counsel.
I would say the significant majority of the matters that I've been involved in over the last years have involved senior counsel.
Yes.
So they have been led by seniors.
Yes. Okay, all right.
But I've also used junior counsel themselves for matters.
Yeah. Okay, all right. Thank you. Commissioners on the virtual platform. Any questions?
Well, yes.
Yes,
Justice.
Commissioner Barnard.
Thank you. Good afternoon, Acting Justice.
Yes, good afternoon, Commissioner.
My concern goes to a concern raised by the LSSA about cost orders. You know, the fact that judicial discretion is quite an important discretion, and there's some question marks raised about cost orders. If you want to, you can comment on any of those that they refer to, but I want to refer specifically to limit the question just to one matter, and that is the matter on page 113 of the bundle, which is a matter where the successful litigant who acted on behalf of a 3-year-old minor was ordered, was penalized with a cost order. So basically, if one takes it on that basis, that no costs were awarded in a successful claim, which ultimately means that the 3-year-old would have borne the brunt of the costs in that matter. It's not that you made a cost order against the erring practitioners or specifically against the litigant. And the point is made that is quite a harsh exercise of discretion.
Yes, sir.
Considers an injured 3-year-old child.
Yes, I've reflected on that, and I've taken I've made a note of that comment, and I've also thought myself back into the position in that particular matter. I was not privy in that matter to the discussions between the plaintiff and the guardian and the plaintiff. I was not. The matter should never ever have been commenced in the High Court. The matter was ultimately resolved on an undertaking given for, I think, with a value of some 10 or 15 odd thousand rand. The matter was run right up to the doors of court. The matter, when it was argued in front of me, the significant majority of the costs would have been incurred in arguing the costs themselves, and in that particular instance, the counsel appearing for the plaintiff in that matter was acting pro amico. So the only costs that the plaintiff did not secure were very limited party and party costs on the magistrate's court, which would have been all but insignificant, and I was not aware of the relationship or how that matter had evolved. It was also only through my assessment of the matter that I put myself into a position to challenge the role which the road accident funds had played in that matter, in not accepting in the matter earlier, and in also not themselves qualifying experts at an earlier stage. But again, at the time and in the moment, I considered that to be a fair reflection, and I don't know what ultimately happened as between the plaintiff and the guardian of the minor, but I don't know. I can't comment. As regards the other two matters, the one matter was where a judicial officer had taken on review belatedly a decision taken by a colleague, and had made fairly defamatory remarks not only about the colleague, but also had impugned the office that she sat in, and it was felt, I was of the view that it was worthy of a punitive costs order, and a very senior judge sitting with me in the matter agreed with that conclusion. As regards the other matter where I ordered costs on an attorney-client scale, well, that's precisely what the contract provided.
Thank you, Acting Justice. Thank you, Acting CJ.
Thank you very much. I think we have reached the end of this interview. Thank you very much, Mr. Kaff, for availing yourself.
Thank you.
Thank you very much, and you are now excused.
Thank you, Acting Chief Justice, members of the Commission.
Thank you very much. Next candidate. Okay, let us start. Good afternoon, Mr. Line.
Good afternoon, Acting Chief Justice.
Did I pronounce your surname correctly?
Yes.
Is it Lang or Lang?
Lang, but
Lang.
as you pronounced it.
Oh, okay, all right. Welcome to this session of the interviews, and thank you for making yourself available for consideration for appointment as a judge of the Eastern Cape Division of the High Court.
Thank you, Acting Chief Justice. It's a real honor to be here.
Yes. I see that you hold quite a few degrees. You got a BA degree in 1992, and you got that was from the University of Cape Town. Is that right?
Yes, that's correct.
And you got your LLB from the same university in 1994.
Yes.
And you then did a BA honors and obtained it from UNISA in 2002.
That's correct, yes.
And you got your LLM from the University of Nottingham in 2012.
Yes, Acting Chief Justice.
Yes. And you are a director in a firm called Clark Lang Incorporated. That's your firm.
That's my firm.
Yes. Prior to your firm, did you practice earlier than that in another firm?
Yes, I practiced previously at a firm called Smith Tabata Incorporated.
Yes.
Also in East London.
Yes.
And that is for a period of 16 years.
Over 16 years?
16 years.
Yes. Okay. And you continue to practice in your firm at the moment?
I do, Acting Chief Justice.
So all in all, you have been in practice for about 25 years?
I think about 24 years, well, post-qualification experience. So I was admitted in 1997.
Yeah.
So that it would take me to about 24 years.
Yes. Okay. In your practice and before you had your own law firm, did you do trial work in which you conducted the trials yourself in the courts, or did you not get involved? You'd always just be the instructing attorney and you brief counsel?
No, I was privileged to have been able to conduct trials, both civil and criminal trials, during my period of articles. And that was a mix of as I say, civil and criminal trials, but also with opposed applications and the usual motion court activities. And that period of my professional life fell over my articles and extended some way into my years as a junior associate when at Smith Tabata.
So you only did trials yourself, either when you were serving your articles or soon after your admission, those years when you were junior attorney?
Yes, Acting Chief Justice, those trials I did myself.
Yeah.
And dealt with them directly.
Yes.
But then progressively, as I gained experience in high court litigation, I preferred working in a team, and that's when I would brief counsel.
Yeah.
To work on trials.
Yes. So you were involved in trials, but only as an instructing attorney after that stage?
Yes.
Yes. And did they involve criminal and civil trials, or mainly, or only civil trials at that level?
No, again, a mix of civil and criminal trials.
Yes.
I will admit not many, My work involved, or has involved, mainly opposed applications and that type of thing. But certainly, I have been involved in both criminal and civil trials with counsel previously.
And does your practice have a lot of motion court work?
Yes, Acting Chief Justice, a fair amount. We're a relatively young and a relatively small practice, so maybe not quite as much as what we would like, but I'm sure as we grow, that particular area will expand as well.
And what branches of law has your practice exposed you to? When I say practice, including before you had your own law firm?
Predominantly administrative law. That's really my main area of work, with a particular interest in public procurement issues. But in addition to that, I have had exposure to contract law, a little bit of commercial law. Constitutional law, of course, informs most of well, if all the areas of law, but certainly by far the majority of my work has been in the field of administrative law.
And you have also acted in the High Court?
Yes, I have.
For how long have you acted?
I have performed 5 acting stints, and if you add up the sum of the duration of each of them, if I calculated correctly, came to about 23 weeks. But if you add the time spent dealing with part-heard matters, I think it takes it closer to about 35 weeks.
Yes. And how did you enjoy acting?
Very much, thank you. It was a real honor to have been asked to act, and I found it immensely satisfying.
Yes.
I think at some stage the penny dropped, as it were, and I realized that this is what I wanted to do, and this is how I wanted to serve.
Yes.
So it's a deep and a wonderfully meaningful experience. Yes.
Yes. And as an acting judge, how do you find motion court, particularly, motion court?
I enjoy it. I actually enjoy I suppose I enjoy the activity and the variety that comes through in motion court. There's always something different. There's always something new. The pace at which motion court moves as well has, I suppose, it's taught me to think a lot better on my feet. Not that I've necessarily mastered that, but I particularly enjoy motion court.
Yes. And I see that you have a number of judgments that you have listed, in which you were the instructing attorney. Is that right?
Yes.
And they include some that have been reported in the law reports. Is that correct?
Yes, Acting Chief Justice.
Maybe those that have been reported in the usual law reports that I see here, page 16 and 17, are about 3. But are there much more than that?
I think 3 sounds about right.
Yes.
Acting Chief Justice.
Yes. Okay. Judge President.
Thank you, ACJ. Good afternoon, Mr. Lane.
Good afternoon, Judge President.
It behoves me to make disclosures. The first one being that whilst you were at Smith Tabata Incorporated, you briefed me initially as junior to then Advocate Madlanga, now Justice Madlanga. And then upon his elevation to the bench, you continued briefing me even whilst at Smith Tabata. And in fact, after you had set up your own firm, I started receiving work from that firm, from, I would say, colored folks in particular, something I'd never received before. And then I also wish to place it on record that my daughter was a candidate attorney at your firm, and quite recently a professional assistant before he took up another appointment elsewhere. You confirm those two?
Yes, Judge President, I do confirm that.
Then finally, your firm, now your firm, the current firm, previously championed my cause when I sought to recover a debt I had been owed by a recalcitrant lessee. You know that as well.
Yes.
And that was resolved without any form of litigation. In other words, we didn't have to go to court.
No, but that is correct, Judge President.
Thank you. Now, having said all that, you acted more. In fact, your acting stints date as far back as the time when Sangoni JP was JP in the Eastern Cape.
Yes, that is so,
You've got more stints during the Sangoni era than my era. If I look at it, 28 January to 1 March, Eastern Cape, that was prior to my era. 28 July 19 September to 19 September, which was a full term, that was during Sangoni JP's era. 9 October to 27 October, Eastern Cape. That was Judge Sangoni's era as JP. I'm just placing this on the record, basically.
Yes, Judge President.
You've had stints during my era as JP, 2 of them, and they are specified at page 20, the document appearing at page 20. And during that period, you penned 10 judgments in opposed applications, and then 2 judgments in civil trials, 2 criminal trials, 1 criminal appeal, 4 applications for leave to appeal, 1 criminal review, and 1 exception. Would you confirm this information as correct?
Yes, Judge President, I confirm that's correct for the stints post-November 2017.
Independently of what I said about myself, what has your firm done, or how has it contributed towards the transformation agenda? Independently of what I said about myself.
Judge President, if I may answer that, my firm in particular, Clark Lang now, has adopted a practice that was adopted at Smith Tabata when I was there, and that was the practice of briefing mainly black counsel, not exclusively. We do brief white counsel, but predominantly we strive to brief black counsel, and have been fortunate enough to have developed a real appreciation and recognition of the benefits that a diverse range of perspectives and insights bring to a particular legal problem, so that the legal solution that comes through is so much richer and so much ultimately more effective. So that is the approach that we have taken at Clark Lang, and that it simply really comes as a consequence of my experience during my years at Smith Tabata, where the same practice was employed Again, not exclusively black counsel, but in the main black counsel. And that's the approach that we've attempted to take.
Yes. Would you mention, counsel, that maybe could spring to mind at this forum?
Yes. By name, Judge President?
Yes.
Yes.
I will disclose. I will make a disclosure as well.
You were briefed. Yes.
Yes. Yes, Commissioner Madonsela, we have an acquaintance previously, but in addition to that, the firm has briefed advocates. Sorry, this is where my mind starts to go blank. I'm going to need to refer to some of my notes. But certainly while at Smith Tabata, we briefed Advocate Viwen Noche, Advocate Deva Pillay, SC is the late Advocate Deva Pillay, and then a number of the members of the current bench in the Eastern Cape Division, Justice Bloem, Justice Silva, and then Advocate Amelia de Silva, whom we brief at Clark Lang as well, and Advocate Mapoma is another person. There are a number of black counsel whom we brief. I should perhaps also mention Advocate Jerome Brawns, SC. And then amongst the junior counsel, we have briefed at Clark Lang, Advocate Fabian Pretorius, Advocate Devin Young, Advocate Leslie Brawns, Advocate Lucy Berger, Advocate Tingashe Tabata. We've briefed a number, yes.
Thank you. There is what is known as case flow management. Are you familiar with that notion?
Yes, Judge President.
Briefly, what can you share when it comes to that at this forum? Or let me say, what is your understanding of case flow management?
My understanding is that it's a mechanism to ensure a more efficient and a more effective administration of justice within the courts. And it allows the court, it allows the judge to intervene at an early stage in the life of a dispute, the life of a matter. From personal experience, I've seen how it reduces the extent of skirmishing or point taking to some degree. And I think that if managed correctly, it certainly does speed up the life of a case and brings it to trial a lot quicker than without case flow management.
Yes. And then there's been reference to the word lucrative work. I'm not sure which association has mentioned that, but I think you did come across that.
Yes.
What I want to know from you, does your firm a recipient of lucrative work? I'm talking to your firm at present.
I'm sorry, Judge President.
Would you say you are recipients of lucrative work? I'm saying this in the context that there was a criticism leveled against you that in spite of the fact that you've got lucrative work, but you have not briefed in keeping with the transformation agenda, something that you've now dealt with, but I want to check whether you've got lucrative work.
Yes.
Because that too must go on record.
Yes. Judge President, we certainly have benefited. We've been very fortunate to have benefited from appointments to panels of a number of municipalities, parastatals, and so on. And certainly they've been a source of income for our practice. We've been very fortunate in that regard.
Yes, finally, and maybe in passing, I wish to place it on record that you were one of those attorneys whose drafting skills I admired. So much so that when I got busier, I took the stance that you would do the drafting and bring the papers to me so that I could settle the notice of motion and any certificate of urgency that had to be filed. Thank you.
Thank
no
you,
further
Judge
questions, ACJ.
Thank you, Judge President. MEC Gade, if you have any question, I give you this opportunity to ask the candidate.
Thank you once more, CJ, and good afternoon to the candidate and good afternoon to the panelists and commissioners. Just one question for me, CJ. Flowing from the questions that have been raised by Judge President and also the CB before us, I would want to check whether have we been exposed to a situation where you have to rule against a piece of a legislation and probably declare it as unconstitutional based on the merits and of the case before you. Because I have observed and also looked into the magnitude of the work that he has done, you have done, and hence the Judge President alluded that you have been given that opportunity earlier on. So surely there could be some of those experiences within the ambit of the law. So I just wanted to check on that one.
Yes, Commissioner, if I understand your question correctly, are you saying that, or asking rather, whether I've had an opportunity to pronounce upon the constitutional validity of any legislation?
Yes.
As far as I can recall, not directly in any of the times that I've performed acting stints. I have interpreted legislation or attempted to interpret legislation against the Constitution, or maybe not against the Constitution, but in such a way as to promote the constitutional values. So, for example, in interpreting the Institution of Legal Proceedings Against Certain Organs of State Act, or the promotion of access to information, I've attempted to provide an interpretation that is in alignment with the values coming through in the Constitution. But to deal with your question directly, I don't recall having made any order to the effect that any legislation is unconstitutional.
Thank you, MEC Gade. I guess, Mr. Lang, when you say you have had the chance to, or you have attempted to interpret against the Constitution, you mean in line with the Constitution?
Yes, yes. That'd be a better term.
Is that correct?
That's correct.
Okay, all right. Mr. Commissioner Nojesi?
I think this one has some form of confession on my part. One of the things when I went to act Chief Justice I found is the difficulty in writing judgment. I had an introduction that I have to cancel 25 times. It was wrong each time I look on it. I want to find out from you, when you first acted there, did you experience the same thing, or how did you cope?
Yes, Commissioner, I definitely, I've experienced the same thing. It was quite a novel experience to have to adapt to writing a judgment, perhaps not entirely novel in as much as a fairly significant portion or proportion of my practice involves opinion writing. And I think I followed the same principles until a colleague, I think one of the permanent judges, very kindly pointed out an acronym in how to structure a judgment, beginning with an introduction, going on to the facts, dealing with the issues, discussing the legal framework, and then going on to apply that to the facts, rounding up with the relief to be granted, and finally the order. But yes, in a nutshell, it wasn't instant coffee. It came over time.
Yeah, I also had an opportunity of.
One question
This
at
the
a
last.
time.
This is a very last one. I had an opportunity to appear before you in court. Very impressive, the manner in which you conduct your court, not rude, allowing of what can you say? It's just I want your comment on this, the importance of allowing parties that appear before you to freely express themselves, especially the young practitioners that appear, which you have been doing. What can you comment on?
Thank you, Commissioner, and I really appreciate your comments. I think that what I've had to maybe learn more in time is really to listen to others and to listen to practitioners in particular. Law is not straightforward. It's complicated. It involves a real mix of competing interests, and I've been privileged to have worked with more senior professionals from a diverse range of backgrounds, as I mentioned earlier on, who've helped me to just appreciate the value of approaching a matter with an open mind. And not coming to any conclusion until I'd heard the full story. Every story has a particular shade or tone when it's first presented, and it appears to be this until the other counsel stands up and says, well, no, not really, it's actually like that. And that has helped me just to maybe pause a bit. And to really try and listen carefully.
Thank you. Commissioner Teodoro.
Thank you very much, ACJ. Good afternoon, sir.
Good afternoon, Commissioner.
From what the JP was saying, and from what we see here, it is quite clear that you support and embrace the transformation of the judiciary. But we have a predicament here. You are male, you are white, and in that sense, in your view, how will your elevation to the bench advance the transformation of the judiciary?
Thank you, Commissioner. I think right at the outset, I would have to concede immediately that as a white male, that on its own doesn't advance transformation. It simply is not in alignment, to use an expression mentioned earlier on, with the constitutional imperative. And I think on reflection, I would simply want to say that if the Commission has regard to the number of years of professional experience that I've been fortunate to have enjoyed, as well as the exposure to a diverse variety of professionals, as well as if the Commission has regard to the nature of my judgments, where I hope that an appreciation and a recognition of constitutional values comes through, then the Commission would possibly consider my skill set and experience to be of some value. The only other thing that maybe I could add to that is to mention how important to me, and I think this possibly attaches itself to Commissioner Nortiesi's question too, how important to me the constitutional value of human dignity is. The need to respect and value the other person for who they are, to recognize and appreciate the road they've traveled to be where they are, maybe simply to recognize the humanity in the other person, and that sense of human dignity and that respect for human dignity, it informs the way in which I interact professionally, it informs the way in which I interact personally, and I hope that's come through in the way in which I've conducted my judicial duties.
Just a small addition, CJ. Don't you think that if you are considered positively, why don't you think that to continue to support, to train, especially young legal practitioners, can make an indelible contribution in that respect?
Yes, most definitely. It most certainly would. At my firm now, we have attempted to continue the practice that I mentioned earlier of focusing on employing black candidate attorneys and young associates, and I think that's a vital part that can be played in for the sake of transformation of the profession.
Thank you very much, CJ.
Thank you, Commissioner Shabang.
Thank you, CJ. Good afternoon, Mr. Lane.
Good afternoon, Commissioner.
I want to take from the questions, from the answers that you gave the JP, where you said in your firm you adopted the culture of briefing black counsellors. Out of those black counsellors, is there women counsellors? And if it's there women counsellors, how many are they? You can give the percentage. If the percentage of black women counsellors that you are briefing are less than male, are you intending to increase the percentage? And also, since it's a law firm, I heard when you are responding to Councillor Tutov that you are intending to employ more black attorneys. Have you already started to employ, to have women attorneys that you are grooming? If you do, what is the percentage? Thank you.
Thank you, Commissioner. The precise percentage I wouldn't be able to give to you, but in relation to, it may help if I indicate to you in terms of my current matters. There are 8 counsel currently on brief, of whom 5 are black, and of the total of those 8, I would say there are 3 who are women. In relation to the employment of female attorneys, we to date have only employed black female candidate attorneys, and would want to continue that. In all honesty, I don't think that we've done enough to promote black women, but we would certainly want to focus, continue to focus on that in the way going forward.
Thank you for the undertaking, Mr. Lynn. Thank you, ACJ.
Thank you, Commissioner Madonsela.
Thank you, ACJ, and good morning, Mr. Lane.
Good afternoon.
Morning.
Good afternoon. I've lost. Been living here at 1 o'clock in the morning, 3 o'clock in the morning. Yes. First thing, you make me feel bad because I looked at your CV and I realized you were born on the 13th of August, 1970, exactly my birthday.
The same day and year.
Same day and year.
Wow.
So I think I must actually now start thinking about what you are doing. Secondly, I want to make
that's good news.
Secondly, I want to make a confession, no, a testimony. You really indeed briefed me in a very big matter, which was very critical for your client, and you briefed me to lead a female black junior who was briefed with me in a matter, and I did not do that matter non-lucrative cause. So I just want to give testimony to that and just put it aside.
Thank you, Commissioner.
My question to you is that I think you're not bragging enough. That matter involved procurement law, critical issue which was new, and I see in your CV you're not making the point that I discovered when I consulted you in that matter, that you have actually not only done matters in procurement law, but you have even written academically on that subject matter. And I would like you to talk about that and tell these commissioners what your broad breadth of knowledge is on that topic.
Thank you, Commissioner. Yes, I have engaged with the subject academically. I was very fortunate to have been able to have completed my LLM, my master's degree in public procurement law and policy through the University of Nottingham, especially through the Public Procurement Research Group, which is regarded as a global leader in this particular field. And through that experience, I was privileged to have been able to have been invited to a number of conferences hosted by the Public Procurement Unit at the University of Stellenbosch, and presented papers at both those conferences that I attended. And those papers in turn, I was most pleased to have been able to have been invited to use the papers as the basis for academic articles that appeared in various publications. The first of those articles was, was to do with the lack of sufficient regulatory guidance, or not guidance, more of a framework that exists with regard to the deviations from official public procurement processes, and how this led to a very mixed and inconsistent approach by organs of state in deciding when and how to deviate from official procurement processes. So that's the first of the articles, and the second article dealt specifically with a concept known as the standstill period, which in a nutshell is a mechanism to allow an unhappy bidder an opportunity to challenge the award of a tender before the actual implementation of the tender. And that concept features in the Public Procurement Bill. It in fact features quite prominently in the European Union models of public procurement. It's not straightforward. It has certain disadvantages, and I'd hope to be able to have maybe explored the pros and the cons of that mechanism in the articles.
Thank you. It may very well be your lucky day, because you're not only sharing the birthday and month and the year with me, but also with one of the commissioners seated next to me.
Commissioners on the virtual platform, any question? No question for the candidates. I think we have reached the end of this interview. Thank you very much, Mr. Lane. We appreciate that you made yourself available. You are now excused.
Thank you, Acting Chief Justice. It's been a real honor to have been here.
Thank you. Thank you. Next candidate. I think we'll take a break after this next current candidate.
To stretch our legs, please.
Candidate, but if we think let's do it now, we can do it.
A lot of people have gone outside.
Oh, okay. Let's take a 5 minutes comfort break. Yeah, 5 minutes comfort break. Good afternoon, Ms. Mfenyana.
Good afternoon, ICJ.
How are you this afternoon?
I'm very well, ICJ. Thank you. How are you?
No, we are all right.
Thank you.
I answer on behalf of everybody. We are all right. Welcome to this session of the interviews of the Commission. Thank you for availing yourself to be considered for appointment as a judge of the Eastern Cape Division of the High Court. I see that you hold the degrees B. Juris, LLB, and LLM. And then in addition to that, you have a certificate of legal aspects of e-commerce, certificate of energy law, in energy law, certificate in air, space, and telecommunications law. Is that correct?
That is correct, ICJ.
And you got the B. Juris from the University of Durban, Westville, which is now UKZN.
Indeed.
Is that right?
Yes, yes.
And then you got your LLB from the University of Pretoria.
No, ICJ, the B. Juris and the LLB are both from the University of Durban, Westville.
Oh, okay. And then it was the LLM that you got from the University of Pretoria.
That's correct, ICJ.
And then the certificates you got from, one of them you got from UNISA and the other one from the University of Witwatersrand, is that right?
That is correct, ICJ.
Yes. I like this, the diversity in the certificates that you acquired. It's an unusual diversity and it's quite an important one. When you chose to do those certificates, did you have a particular objective in mind? How did it come about? A certificate in energy law, a certificate in telecommunications law, a certificate in air, or certificate in air, space and telecommunications law, and a certificate in energy law, certificate in legal aspects of e-commerce. How did you decide upon those certificates? That's what you wanted to do, that diversity of programs.
Well, the reason for each of them is different, but the commonality is my curiosity. If I am dealing with a matter that involves energy law, naturally what I want to do is to get more in-depth information on that aspect. And I find myself, studying on that aspect. Mm-hmm. And I think the other reason is to support my clients. You get an instruction in energy law or aviation law, for example. And you're very limited because as a lawyer, you cannot confine yourself to a specific thing. I mean, litigation is in pretty much everything. And you prejudice not only your client, but yourself as well, because you're limited in the offering that you can give to your client. So that was, those were the reasons, pretty much.
And you were admitted as an attorney in 1998, is that right?
That is correct, ACJ.
Yes, and you worked in the Human Rights Commission as a legal officer, and later you worked as a research fellow at CSVR. What is CSVR?
It's the Center for Study of Violence and Reconciliation.
Yes, okay. And do you practice as an attorney at the moment?
Indeed, I am practicing as an attorney, ACJ.
Yes. So how long have you practiced as an attorney?
I have practiced for about 14 years.
Yes.
On my own, it has been 12 years.
Yes.
Since I started, but that excludes my other work apart from practicing as an attorney. So practice, it's been 14 years.
Yes. And I see that you appear in various, you say you appear in various courts with regard to a variety of civil litigation matters.
Yes, ACJ, when you are the magic in your office, when you're a sole proprietor, you appear in each and every court where there is a matter, yes, to be attended to.
Yes. I see that you mentioned magistrates' courts that you appear in. You mention in and around Pretoria, Randburg, Johannesburg, Roodepoort, Boksburg, Kempton Park. And you say you appear also in the High Courts in Pretoria and Johannesburg, as well as in the Labour Court in Johannesburg. Is that right?
Yes, I have.
You have?
Yes, ACJ.
Yes. And you say sometimes you appear alone in those courts and do matters without counsel. Sometimes you brief counsel.
Indeed.
Is that right?
Yes, ACJ.
So that means that, does it mean that you have actually argued cases, some cases on your own in the High Court, in the High Courts and in the Labour Court, quite apart from Magistrates' Court?
Particularly in the High Court, the Labour Court not so much, because my practice is not predominantly a labour practice.
Yes.
So it would be one or two in the Labour Court, but in the High Court it would be more than that, even though I haven't appeared in the High Court enough.
Yes.
With the practice to attend to as well. But I have appeared in the High Court with or without counsel.
Well, I very much like the idea that you appear in the High Court as an attorney on your own sometimes, and you do matters yourself. You argue them before judges. You argue them. It would follow against advocates, and you're not intimidated by anybody. Is that right?
Not necessarily, ACJ. I mean, what is more intimidating is the matter itself.
Yes.
Otherwise, when you deal with people, you deal with people. You just take it in your stride. But the key is the preparation.
Yes.
And you either successful or not successful in the matter, and that's that.
Yes. And have you also argued appeals, whether criminal or civil, in the High Court?
No, I have not.
Appeals.
I have not.
But you have done trials?
I've done trials. I've
motion
appeared
court
in motion
as well?
court. Yeah,
Yes.
That's where I've appeared the most.
Yes. I see that you say your practice doesn't have criminal work. You say zero criminal work, but you say it's got 30% administrative law. Is that right?
That would be correct. That's more or less that.
And 20% labor law.
Yeah, more or less that would be correct.
And you say 50% of your litigation work relates to property disputes, forensic investigations, matrimonial agreements, divorces, commercial and corporate law, opinions, and debt collections. Is that correct?
That's correct, ACJ.
Yes. And you set out in paragraph 6.3 some of the cases that you regard as quite important that you have done. Now, have you had a chance to act in the High Court?
Yes, I have, ACJ.
Yes. For how long have you acted?
I've counted a total of 34 weeks.
Yes. And how did you find it?
I found it to be a lot of work. But I think the key thing is that it is worthwhile.
Yes.
It is the time where I learned the most in my entire practice.
Yes. Okay. And when you were acting as a judge in the High Court, seeing that you said you are a sole practitioner, did you get somebody or some attorney to look after your practice, or you did have an attorney within the law firm whom you had employed who was working in the firm anyway?
I do have people that I work with, and I think from a managerial point of view, I do have a practice manager.
Yeah.
Who is somebody that I had been working for, I think, for a period of about 8 years.
Yes.
So, who is also legally qualified, although not a practicing attorney. So that sort of made things a little easier for me. And she would oversee things, but then the attorney would bear responsibility for the technical issues of the firm.
So, have you actually been in practice for about 20 years, 22 years? How long, from the date of your admission?
Not practice, but the legal experience, but practice, I've been in practice for about 14 years.
14,
but I have been, yes, I've been like employed for about 22 years.
Okay, no, that's fine. Judge President.
Thank you, ACJ. Good afternoon, Ms. Mfenyana.
Good afternoon, JP.
We have not met in a long time.
In a long time, yes, JP.
Yes.
It's good to see you again.
Same here. You were actually recommended for an acting stint by an advocate practicing in Joburg. And I told you as much.
Yes, you did.
My philosophy being that you become a bit suspicious when people approach you applying for themselves to become acting judges in your division. I'm not in the least suggesting that when I receive these requests, I am stubbornly of the view that you can't appoint somebody who has approached you. But in your case, somebody else that you apparently had been briefing saw it fit to point a finger at you, reposing his trust in you. I thought I should mention that.
I appreciate that, JP.
And at page 22 of the document headed List of Judgments by Eastern Cape Candidates, JSC, October 2021. You see that document?
Not quite. Is it any one? This one? Page.
Yes, at pages 22 to 25,
yes,
the document embodies what you produced. I must say, you acted for quite a long time in my division, and that is borne out also by what we see here. Your pen did not run dry. You produced quite a number of judgments. I remember that we sat together in Center for Child Law versus Minister of Basic Education, a judgment that has subsequently been reported. Are you aware of that?
I am aware of it, JP, but when I was completing the questionnaire, it sort of slipped my mind and I did not indicate it.
Yes, I thought I should mention in your favor that that you sat with me and that team produced a judgment that ended up being reported dealing with profound constitutional issues. What is your take on case flow management? In particular, maybe let me put it like this. In your view, is it possible to implement case flow management in the context of opposed motions?
It should be.
How would you do that?
I'm really thinking on my feet here, JP, but just like with civil matters in which case flow management is currently used,
Yes.
opposed motions, run a course before the matter is actually heard. And it is not all the time that a matter, an opposed matter, would run from end to finish without any hurdles. And the tool of case flow management is instrumental in that respect. So I do think that, as an administrative tool, it would assist, practitioners and particularly judges and the court ultimately to always perhaps have a bird's eye view of the matter and to direct the litigation or the course of that particular matter. So I do think that it shouldn't be any different from trial matters.
Yes.
It's just a matter of time.
Yes. You may not have read a judgment that I penned, which has been reported in a matter of Bobotyana. You probably have not read that as yet.
I haven't read it. I saw that matter, yes. Probably browsed through it, but I didn't read it.
Yes. It drives the point home that case flow management is applicable in motion proceedings. And it demonstrates that as soon as we implemented that in Grahamstown, there was an improvement on the finalization rate of opposed motions. I just thought I should mention that. You may not have read the judgment.
I have not.
Thank you. There are 16 opposed application judgments that you penned, according to the grid.
I counted as much as well.
Yes. And then you featured in civil trials as well. I see you penned 15 judgments.
Oh, I didn't count the judgments then, but I will take your word for it, JP.
Thank you. Anyway, it's at page 25, at the bottom of page 25. The summary is set out there. There are 11 applications for leave to appeal against your judgments. Do you know what eventually became of those applications?
JP, do you want me to go through
Well,
them one by one?
let me take you to page 25.
From page 24.
Yeah, have a look at page 25. You will see there's a summary of your output. Page 25.
Yes, JP.
Yes, you see it lists judgments that you penned. In fact, it's a summary of what is contained in the grid itself.
Yes.
And then it mentions that there are 11 applications for leave to appeal against your judgments. I take it that 11 of the judgments that you penned. So my question is, have you got an idea of what became of those applications?
At a rough idea, I do know, I have become aware of 2 matters that were taken up to the SCA that were dismissed, and that would be Bason versus Bason and the matter of Makana Youth League versus Makana Municipality. I do know of another one the matter of Lottering versus MEC for Health, Eastern Cape. In that matter, I was overturned. There would be the matter of ZD. I think it's a criminal matter. Oh, no, there's no, I don't see it here on leave to appeal, but then that matter was indeed appealed and it was dismissed. The appeal was dismissed. With regards to the rest, I have no idea
Yes.
what has happened to the matters, JP.
Yes, I may have pounced on you on this, but also sitting where you are this afternoon,
Yes.
you can't be in a position to say so many of these applications for leave to appeal were refused, and then petitions were pursued, and then the SCA either granted leave or did not grant leave. You have not engaged in that exercise.
Not to interrupt you, JP, I am aware in the Person matter that there was a petition brought and that was also turned down.
Yes.
That is about the only matter that I am aware of.
Yes, of the 11 matters, you can't account for all of them.
For all of them, no, I cannot,
Yes,
JP.
yes. Thank you very much, ACJ.
Thank you, Judge President. MEC Gade, if you have questions for the candidate, you may go ahead and ask your questions.
No, thanks, CJ. I don't have a question for the candidate yet.
Thank you. Commissioners. Commissioners on the virtual platform, any questions? No questions from the commissioners on the virtual platform. Let me start with Commissioner Nyambi.
Thank you, ACJ.
Okay.
Afternoon, ma'am.
Good afternoon, Daddy.
If you can share with us your understanding of judicial accountability.
Judicial accountability, I would suppose that the judiciary as an arm of the state that adjudicates matters on behalf of the entire population of the country bears its responsibility and accountability to the citizens of the country. And that to me would be what I would call the sum total of judicial accountability. That in all decisions that judges make, the judiciary always has to be mindful of the public impact of the decisions that they make. That for me would be the sum total of judicial accountability.
Thanks, Ms. Fenyane. I'm leading by example, ACJ, one question.
Thank you, sir.
Thank you. Commissioner Nojesi.
Following to that question by Mr. Nyambi,
yes,
if there are 11 applications for leave to appeal against your judgment, you don't know anything about them, how does that impact on that accountability?
The information pertaining to when matters went on appeal, that is to a higher court, is an administrative function that is performed outside of the judicial function itself. So that I would attribute to the flow of information either from the registrars to the judges or the system that is being used, and not to judicial accountability itself. Judicial accountability, from what I've explained to Commissioner Nyambi, would, to me, be the responsibility of the judicial officer to the public and taking into account the impact of the decision that has been made in discharging the duties of a judge.
Thank you. Commissioner Schlemmer.
Thank you, ACJ. Good afternoon, ma'am.
Good afternoon,
Also,
Commissioner.
I just also have a question for you on the 11 applications for appeal. They seem to be quite a lot. Should we read something into that? The fact that so many of your judgments have been appealed against?
Yes and no, Commissioner. To the extent that a party that is not successful is entitled to bring an application for leave to appeal, I would say no, because in any judgment, you're going to go either way, and one party may be satisfied and the other party not. But if both parties are satisfied, like with the rest of the other judgments, all the better. I would also add that if you take the sum total of the judgments that I have penned, which I have counted to about 50, I would say relatively 11 applications for leave to appeal, also minus the 2 that were overturned, 3 that were overturned on appeal, leaving a total of about 8 is perhaps not too bad.
Thank you, CJ.
Thank you, Commissioner Schlemmer. Minister.
Thank you and good afternoon.
Good afternoon, Minister.
Yes, mine relates to, I see that you have been a sole practitioner for a very long time. Wherever I go across the country, female practitioners in particular, they decry the lack of support, either as an attorney or as a junior advocate. How did you keep it for so long?
Blood, sweat, and tears. That's how I can sum it up. It's pushing through. My strategy in maintaining my practice is not to have a lot of instructions at a go. So thanks to initiatives that are there that we can, as attorneys, tender for legal services, I've taken advantage of the tendering process quite a lot. And if I can get 1 out of 10 applications that I have made, that's good enough for me to some extent, because then I sort of hold on to that yes, and I knock at doors, literally knock at doors and say, you have accepted me, I just wanted to have a word with you, this is who we are. And generally, that's how I have been able to sustain my practice. I say, you only need to give me 1 instruction. And naturally, I'm an overthinker, very melancholic in personality. So I overthink this thing, and I would sit with that instruction and make sure and just try and close all gaps to the best that I can. And in so doing, I think I, sort of zone you in as a client, and it sort of then moves to the next. But it hasn't been easy. It's difficult, and I must say also, support from other colleagues who are in the same boat as me. We talk among each other, and we share ideas. We even share instructions. If you don't have the capacity to do something, give it to somebody who can.
Thank you.
Thank you, Minister.
Thank you, Minister. Was your hand up? Yes, please go ahead, Commissioner Mtolo.
Thank you, ACJ, and good afternoon, Ms. Mfanyana.
Good afternoon, Commissioner Madoro Lepu.
I'm actually so jealous that you have applied to the bench.
Please speak up a bit.
I'm saying I'm very jealous that you have applied to the bench, I must confess. You know, Ms. Mfanyana really trains young women attorneys. She's a member of SAULA. She's always available. I just wanted to commend you for that. She's one of the most active members in South African Women Lawyers. Thank you.
Thank you, Commissioner. I appreciate that.
Can I add?
Yes. Yeah, okay. It looks like we have come to the end of this interview. Thank you very much, Ms. Mfanyane, for availing yourself. Thank you very much. You are now excused.
Thank you very much, ACJ, and thank you very much, Commissioners.
Thank you.
Okay. All right. Thank you so much. Okay. And then my application is where? So that one. Okay.
Good afternoon, Ms. Norman.
Good afternoon, Acting Chief Justice.
How are you this afternoon?
I'm very well, thank you. How are you?
All right.
Yes, thank you.
It's so good to see you here.
I'm a wreck.
And I'm just so glad that you only came here after helping me in the commission.
Thank you, Chief Justice, thank you. Yes.
But it's also interesting because in 2017, I was sitting there and you were sitting here.
So the tables have turned now.
Well, good afternoon and welcome to this session.
Yes, thank you.
We appreciate that you have made yourself available. I'm sure that there are many who, for some time, were saying to you, when are you going to make yourself available?
Yes. Yes, they have been. Yes.
Yes, no, thank you very much for availing yourself for consideration for appointment to the Eastern Cape Division of the High Court.
Thank you.
Thank you. I see that you hold the degrees of B. Juris and LLB and a certificate in shipping, a certificate in, and a certificate in project management. Is that correct?
That is correct. Sorry.
Yes, and you got your B. Juris and LLB at the University of Transkei then.
That is correct, yes.
Yes, and your certificate in shipping at the Durban Ship Brokers, is that right?
That is correct, yes.
Yes, and then you got your certificate in project management at the University of Cape Town.
That's correct, yes.
Yes. You started your legal career with the Department of Justice as a public prosecutor in 1988, is that right?
Yes, I did. I think Chief Justice.
Yes, and then from 1992 to 1995, you were a state advocate, is that right?
That is correct, yes.
And 1995 to July 1996, you were a senior legal administrative officer in Bishop.
Yes, that was, excuse me, at the inception of the new government.
Yes.
Yes, thank you.
And you then did your pupillage in, started your pupillage in 96.
That is correct, yes.
And you started practicing as an advocate at the beginning of 97?
That is correct.
Yes. And you have been practicing as an advocate without interruption up to now?
Up to now, thank you.
Yes. And that makes it about how many years?
About 25 years.
About 25 years. Yes. That's quite a long time.
Yes.
Would you please share with the commissioners what types of cases you have been handling in your practice over the 25 years, generally speaking, in terms of branches of different branches of law?
I've handled acting Chief Justice matters in tax law related matters, maritime matters. I've done land claims matters, administrative law related matters, constitutional law related matters. I did a bit of labor when I was starting up.
Yes.
But then the practice grew in such a way that it was difficult because the labor processes, sometimes they need one to really focus on most of the things, yes. So, and I think I've done basically most, except for land claims and maritime and labor. Yes, basically those are the areas that, that I've been practicing in these things.
So it was a diverse practice.
Very diverse, yes, thank you.
Well, I like the fact that it also had branches of law that a lot of black lawyers don't get exposed to, in terms of like tax and so on.
Yes, yes.
And shipping.
And shipping. In fact, one of the reasons I moved to Durban is because I had an interest in shipping.
Yeah.
And then, as my CV shows, then I
did a certificate.
Then had a certificate in it, but then also went to New York, and I was placed with a law firm, Holland and Knight, there, as an it was a program that the shipping industry had, that for practitioners in South Africa, they would go there for a few months to observe and go to court and observe how things were done there. So I did that, and I think for about 4 months, and came back. That was in 2004.
Yeah.
Then one got work in shipping until such time that the head office, I think it was called Portnet at the time, moved to Johannesburg. Then that tap then dried. Then one would get opinions, but the kind of work that one was doing initially, it dried up. Thank you.
Okay, but that means that you have got experience on various branches of law.
Yes, I do. Thank you.
Yes, yes. And obviously you have been doing trials, civil trials, you have been doing motion court, and probably you haven't done a lot of criminal work
No.
because of your seniority.
Yes, I
But you
did.
would have done it much earlier, I would imagine.
I did. Much
Yeah.
earlier I did, that is correct. In fact,
Yes.
we started at the time because when we started out, there was still what was called pro deo
Yes,
defense.
yes.
Money was good, especially with the experience that one had as a public prosecutor. And I remember that you would go to the registrar's office on Friday and you'd get
Yes.
paid 25,000 rand. And it was a
Yes.
lot of money.
Yes.
But then that system changed into the legal aid system that we have now.
Yes,
But then also one, as you've correctly pointed out, started having interest and having work in other areas of the law.
Yes. Well, I referred earlier on to the fact that I was happy that you started by helping me in the commission before making yourself available.
Yes.
But I must, so to speak, declare that you were one of the members of the legal team who started the commission with me.
Yes.
And you stayed. We started I think the legal team came together around
March.
mid-June.
Yes.
Or was it about March?
Well,
March.
I think you started appointing us around March.
Around March
But
2018.
yes, 2018. I think,
Yes.
I think.
And you were with the commission until about what?
And then I left June 2020.
June 2020.
Yes, but then I was left to do the summaries thereafter.
Yes. Yeah, you have continued to do.
I've continued to do those.
To help tie the loose ends.
Yes, that's correct.
Yes. And is it true that you left because you wanted to go back to your practice? I didn't do anything.
No. You remember, acting chief justice, the commission was going to be 6 months.
Yes.
And 6 months became a year.
Yes.
And I had left my family in Durban. So
Yes.
because I was really living in Johannesburg.
Yes,
So it became
yes.
2.5 years. It was too
Away.
much then for my family. So I had to go back.
Yes. No, thank you. And I see that in the questionnaire, you have also indicated a number of reported cases in which you have appeared.
Yes.
Yeah. And you have acted as a judge in the High Court on a number of occasions.
That is correct.
Yes, and you have enjoyed acting.
I have, at all times. Thank
Otherwise,
you.
you would not be making yourself available.
Yes, thank you.
Yes. Okay, no, that's fine. Judge President.
Thank you, SCJ. Advocate Norman, good evening.
Good evening, Judge President.
May peace between you and I prevail. For having persuaded you to avail yourself against the background that you've been running a very lucrative practice.
I don't hold grudges, Judge President.
Thank you very much.
Well, we note that there is no denial of the allegation that there was a lucrative practice.
Maybe I should mention that you took over from me and became lead counsel in that matter involving the Constitutional Court justices.
That is correct.
I was lead team before you did.
That is correct, Judge President. In fact, I think, didn't I take over from the judge? Yes, Judge Dokota.
Dokota was
Preceded
with
you?
me. No,
Oh.
he was with me.
Oh,
So we both left and joined the bench. Anyway, that's just by the way.
Yeah.
I see you acted on many occasions before acting during my judge presidency.
That's correct, Judge President.
And that is reflected at page 26 of the
Yes.
document serving before you.
That's correct.
And then the summary of what you produced is set out at page 27 and it speaks for itself.
Yes.
Yes.
Yes. Yeah, that is correct, Judge President. That's from 26 and 27.
Yes. I just have one question to pose.
Yes.
Would you say the pace of gender transformation in the judiciary is to be applauded? Or are we moving at a snail's pace? If the answer is in the negative, how can we improve the situation?
It is, well, one would say it is moving, but I think the challenge really with the transformation agenda, especially when it comes to preparing candidates for the bench is that it doesn't simply start at the time when one has to be approached and to make one available for the position. It has to start right at the time when the person leaves university. Because that's the crucial time as to where the person does one's articles and what is the sort of exposure do they get when they are doing articles. Because when you miss it from that time, by the time a person has gone through that process, which was really ineffective, and the person is ready to, willing to become a judge, you find that the basics are missing. So for me, it has to start from that level. What we used to do, I remember the University of KwaZulu-Natal had a program where every time from the moot court processes that they had, then it was easy for us. You go and you sit there and you adjudicate as a judge, although you are counsel. And then it was easy to identify those 3 or 4 students that you say, you've got to watch out for these ones. They are very good. You've got to make sure that you nurture them. Then that process didn't end there because you're doing it with the lecturers. Then they would make sure that where they get their articles, they get exposed to a lot of work. So by the time a person qualifies as an attorney or qualifies as an advocate, they have all the basics. They understand all the rules and the basics. By the time then they're ready to become judges, there isn't too much of an effort. But having said that, there is also the issue of the practice has to be lucrative, because it's going to be difficult for somebody who has difficulty in maintaining one's practice to avail themselves for acting stints from time to time. So I think for me, those things, they all go hand in hand, that the empowerment shouldn't just be about empowerment in terms of making sure that people come to the bench, but they need to be empowered in terms of them getting work that is going to yield positive financial results for them.
Yes. In other words, you espouse, your view actually is that there must be a structured way of transforming the bench.
That is correct.
It should not be done haphazardly.
No, not at all, not at all.
Thank you, ACJ.
Yes, thank you.
Thank you, Judge President. MEC Gade, if you have any questions for the candidate, I give you a chance to ask questions now.
Thanks, CJ. Good evening, Advocate Norman.
Good evening, MEC.
Not just one question for me, CJ. I would want to be schooled or to know from Advocate Norman, to what extent does the language hampers the judicial process? For example, the sign language and its own constitutional implications as part of the deficiencies that I've observed by virtue of being an MEC in education. I've seen that within the sector itself. Now, I was just trying to look how do you deal with that deficiency when it comes to court processes?
Yes.
Because it's part of one of those issues that I feel that strong that would need some attention generally as a country.
Yes.
In particular, the sign language.
Yes.
Language as part of yes.
Thank you. MEC, sign language is I know that I was involved in a case a couple of years ago where there was an organization that applied to have the Department of Education actually pronounce on sign language. The difficulty that was encountered, I represented the department in the matter, was that sign language differs according to the way people exhibit it, depending on the language that they speak. So that became a big problem, because a person would say, if a person says walk away, would use a different sign for saying, and another person would use a different sign. So there was no structured method of ensuring that when it actually becomes a language, as that organization was demanding, then there will be no confusion. That was the first problem. And then the second problem then was that in terms of the curriculum, I'm not sure whether the schools, because you'll find that there is a FATA, for example, in the Eastern Cape that I know of, and there will be another school in Durban. It didn't appear that there was a uniformity in the methods that they were employing in teaching sign language. So those were, at the time, those were the difficulties. But I do not know whether those difficulties has since been resolved. But it is an area that requires attention, because you hardly really find, when there's court proceedings that are being broadcast, you hardly find a person translating in sign language, so that those who cannot hear or speak are able at least to follow the proceedings. So I understand the concern there. The other issue is the language issue, the English language, as being a medium that's being used by the courts. You know, I think it's easy for me sitting here and maybe criticizing that English ought not to be the main language. Maybe it's easy because I don't know the logistics. But the truth of the matter is that people need to understand what they are being confronted with in a language that they can clearly understand. It's one thing to have a language practitioner that is going to translate in court, but it's another when something that is being said by the judge, a person is able to absorb it directly from the judge's mouth, you know, where there is no missing interpretation or some missing words left out in the interpretation. So that's a very critical issue. Maybe if I can just make an example. In the Eastern Cape, after 1994, I was appointed by the late Premier Raymond Mhlaba to go around the courts together with Mr. Mkuseli Jack and one magistrate from Port Elizabeth, Mr. Nodier. And the purpose was this, that people didn't trust the courts after 1994 because the old system of how the magistrates were doing things, people did not trust that system. So we needed to have a system where people are going to be able to say, a judge, a magistrate does this, an interpreter does this, and a prosecutor does that. But before that time, as you all know, you would find in the olden days that if a prosecutor is not at work, a court orderly, who's a policeman, would lead evidence. So you needed then to rationalize that and make sure that the progression of the judicial processes do not leave your ordinary men in the street behind. So what then we were mandated to do was to have lay assessors in the courts. So we went around, I mean, throughout the country, especially in the Eastern Cape, because that's where the major problems were, not necessarily the Ciskei, but the area that was used to be the old border area, which would involve our towns, Darkestad, Kraddock, and all that. So you would go around, and then you would teach people what a magistrate does, what a prosecutor does, what an interpreter does, and then not only that, but they will have a lay person from the community, a person that is held in high esteem by the community, to sit on most of the cases that involve the members of the community, sit with the magistrate as an assessor. And that program proved to be working quite fine and well, but I heard recently that it was discontinued a while ago. So I don't know what the reason was, because it went back to this very issue of language. Because when people know that whatever the magistrate is saying, the person sitting next to him or her understands the language, then they know that I can trust this system. I can feel comfortable that my interests are going to be protected. So yes, I agree with you. More needs to be done by the courts insofar as language is concerned. Thank you.
Thank you, President Meyer.
Thank you, ACJ. Good afternoon, Ms. Norman.
Good afternoon, President.
I joined the ACJ in thanking you for finally making yourself available for judicial office.
Thank you. Thank you, President.
Especially in a division that was in the doldrums for the longest time. I'm sure you and those of us in this room remember a time not so long ago when we used to tear our hair out in frustration because of the quality of candidates for that division that would come here.
Yeah.
So we are happy to see first to the JP, the reconstruction, the major reconstruction that is happening down there. And we're thankful for people like you, for answering the call and making themselves available.
Thank you, President.
Now, I don't really have a question for you. I just want to ask you to explain a strange comment made by your organization of what, 25 years, the
Yes,
PLA?
the PLA, yes.
That seems to think that you still need more time to act.
Yes,
Do you
yes.
have anything to say about that?
I think in fairness to them, President, if you were to look at the application form, I only put in a few dates there because those are the only bench books that I had at my disposal at the time. Then I had to ask the Department of Justice then to give me the printout that's got the full number of acting stints. So then that only came, I think, after then the bodies had commented. I thought it was a fair comment, given the fact that they only had regard to the 4 stints that I had.
I don't accept that defense. You've
Nor
been
do
their
I.
member since 1996. They should know exactly who you
They
are.
know you.
But thanks anyway.
Thank you.
ECJ.
Thank you, Commissioner Matonsela.
Yes, as a member of the JSC, I did not attend the PLA meeting.
You
Discuss
distance yourself.
So I want to distance myself.
Yes.
I just want to say that by protocol in the profession, you normally give an opportunity the seniors to take leadership in the profession. When it was the time to become the chair of the bar,
yes,
you forgo that, and then you asked me, directed me, and ordered me to take over your position as the chair.
And it worked well, Commissioner. Yes.
So I just want to make mention of that. I have a problem with the application, and I want to give you an opportunity to address the issue because
yes,
I might raise it during the deliberations. You are in Durban.
Yes.
You spend lunches with me now, day in, day out. You don't tell me you're applying in the Eastern Cape. Why are you making yourself in the Eastern Cape instead of KZN?
Because I gave my youth to KZN, and I think in old age now I must give that contribution to the Eastern Cape.
I give up.
Commissioner Nyambi.
Thank you, ACJ. Afternoon, Advocate Nomet.
I just want to say I've got about 5 more, and I don't propose to take any more. Yeah, okay. No, you are not listed. Yeah?
She's lucky.
You backing me? Okay. Okay. I will grant him.
Thanks, ACJ. Afternoon, Advocate Norman.
Good afternoon, Commissioner Nyambi.
It will also be unfair of me, ACJ, if many a times as people wait for people not to be part of planet Earth to praise them, and sometimes write about them when they can't hear us.
Yeah.
I was so fortunate when I joined the commission. I served with Nsebenza, Semenya, Thomas. After they left, where they left off, she came and joined us. It's one of the people that contributed and simplified to politicians the importance of us reading the documents when we come to this important body. So I want to commend you for what you have done today. We look more relevant when we ask questions. It's because of those sleepless nights when you were so passionate to assist us.
Thank you.
My interest for you to comment is not necessarily a question, but as somebody who was part of this body, and of course, SCJ indicated you were part of us when we interviewed him, and now we are on the other side. What is it like? What is it that you took from the commission that is assisting as we are sitting there today? But I commend you a million times for the role that you have played to us.
I think the diversity of the commission, that is this body, is a very important aspect in making sure that whoever makes it out of the candidates, at least that person has gone through the rigorous process that the commission subjects the candidates to. And also the fairness and the manner in which candidates are handled and made to feel comfortable. That on its own, because I always say that it's one thing to be strict and enforce the rules and everything else, but if you're not doing that with a kind heart, the result is different. So when people are handled well, even if I don't perform well, I will walk away knowing that at least I got the kind of treatment that I'm comfortable with, and if you do not make it, you walk away not feeling bad about the process. But I think the fact that this body is so diverse, the fact that it involves, because the politicians are the people that represent the people, the ordinary people from the street. Those people are not represented by the lawyers and the judges on this body, but they are represented by the politicians. So they play a major role because they speak to the constituencies. They know what's happening on the ground. So that's an element that cannot be overlooked. Yes, thank you.
How I wish it was possible for me to take you to the most beautiful province in South Africa instead of Eastern Cape. Thank you, Advocate Nomet. Thank you, SJ.
Thank you.
Okay, thank you. Minister?
Yeah, no, thank you, CJ. I'm attracted to the proposition that you have made to the JP on the transformation of the attorney's profession, the legal profession as a whole, including the judiciary, that mentoring and identification. I just want you to speak a bit on it further and to also state if there is any documentation that you have
thank you.
crafted in this regard.
Thank you. Good afternoon, Minister. Yes. At the time when the former Director General, Mr. Advocate Menzi Simelane, was the Director General, I had submitted a proposal to him. And as to how I thought that the legal profession could be transformed and how I thought that the junior advocates, I was speaking for junior advocates at the time, but I think the same methodology that I proposed would apply even to the attorneys, because in any event, they've got a right of appearance and they have all the benefits and the chances that were given to advocates, they have all of those. So there is no reason to separate the two. What I had proposed was this, I do a lot of work for the state, and I'm very fortunate in that regard, and it's something that I don't take lightly. But what I realized was that the state can give you 100 briefs, and you find that somebody is drowning, somebody is not coping. And then it defeats the whole purpose of one saying that I am actually empowering this person. And I said, because I had spoken to people before I crafted that document, like people like, I think at the time, it was Chris Manewick, who told us how the former government, the apartheid state, was doing it. That you would have an advocate that you are going to have who's going to specialize in defense force matters. And that advocate and a junior, or maybe 2 or 3 advocates who specialize in that. You do the same with customs and excise. We do the same with tax. That way, you know that you only have 2 or 3 silks that specialize in tax, and these silks will attract as many juniors as they want, and they impart the skill. So that is the proposal that I had, that it really doesn't help to get one person to do 100 matters in different spheres of the law. Because what you really want to produce at the end of the day, you want to produce experts. And not only that, you want to make sure that those that are starting out learn from the ones that know best. So I think I see that is what is lacking. I've tried to do it in administrative law. I've tried to use juniors, making sure that I use a junior 3 times. And then once I see that that junior understands the basics, then I move on to engage another junior. So it's a structure that we need to create. And that structure is going to work well as long as we make sure that at the top, your silks, you know that if I have a customs and excise matter, that silk is going to do it. And that silk is going to work with the juniors doing it. That is the first thing. And then the second thing, of course, is this, that
maybe advocate, so that we don't waste the commission's time.
Yes.
We will be in touch with you, and hopefully the LPC will also
thank you.
Get that we can
Yes.
take the discussion.
Thank you.
further.
Thank you very much.
Thank you.
Thank you.
Thank you, Minister. Commissioner Lucas.
Thank you very much, ICJ. Good afternoon.
Good afternoon, Commissioner Lucas.
In actual fact, many of the things that I wanted to ask you about is in a way being responded to in the way
Yes.
you responded. But I still want, particularly in the light of the fact that there was kind of objections against your appointment, and we can see that you are a very capable person. So can you actually, just in a very nutshell, tell us what, particularly with your experience, even now with the commission, you are bringing to the bench? And I like the idea that you are actually proposing that we build specialists and that everyone should not just be a generalist, but that we
Yes.
should rather have specialists in the areas where we want to see actually, for instance, like defense is a very good example.
Yes.
But I really just want you to, a little bit, particularly with the commission that they've just now, you have made a very major contribution.
Yes.
But also in terms of planning, because
Yes.
I want you to touch on the issues of planning in what you are bringing to the judiciary.
Yes.
Thank you.
Thank you, Commissioner. I bring to the judiciary, I think, kindness. I'm a very kind person. And I believe that the things that I've achieved in life have been preceded by that. It's a value that I have in me, and it's a value that I want to impart when I sit on the bench. I want everybody who comes before me to be comfortable with me, the way I treat them, the way, because, you know, I always make this example. When I first started out, sorry, Acting Chief Justice, I hope I'm not going to take too much of your time.
Yes.
The first 4 matters I did after I finished pupillage in Durban, as you may be aware, I was the first senior counsel, African female in Durban, and there were very few Africans at the time when I finished in 1996. So I had these 4 divorce matters, and I went into court. I was the only African that was there in court, and the court was full. The first bench in Durban, as we all know, gets occupied by silks. And the courtroom was quiet, but I had a good judge who treated me well, and I went through that process. And that, for me, is the process that each and every junior counsel that comes to court must experience. They're going to fumble, they're going to tumble, they do all sorts of things, but what is important is knowing that the judge is going to listen to me and the judge is going to give me an opportunity. So that is just about the only, as a puny judge, you really don't get involved in the planning because the judge president and the deputy judge president are there to plan the running of the court. As a puny judge, what you do is to make sure that you grow the judiciary in terms of how it becomes accessible to the ordinary man in the street. I mean, people come to court without representation, and you don't just throw them out. You explain to them, what is the interdict? What does it mean? What are you expected to do? You know, and in the end, you would say, go to the Legal Aid Board. They will assist you. So I would want to say that that's basically really what I will be bringing to the bench. Thank you.
Thank you. Commissioner Schlemmer.
Thank you, ACJ.
Good afternoon. Good evening, Professor. Yes.
I have perhaps a strange question for you.
Yes.
But when I looked or went through your documentation,
Yes.
the case, let me just get to it. It is on page 32 of the bundle, the paginated page. If you look at the title of that case, it contains the identity numbers of the parties. Do you think it's wise in the light of the Protection of Personal Information Act that we still see identity numbers of parties in case names?
Oh, well, you're quite correct, but unfortunately, this is the case that I had it as an urgent application, and it was typed that because I gave judgment the very next day, this one, securitization, and this is how it was cited in the public documents that are at court. But I hear you, maybe in a judgment, one could have omitted the ID numbers.
Yeah,
Yes.
it's perhaps something that all of us should be thinking of.
Thank you
going
very much.
forward.
Thank you for pointing that out. It's a fair question. Thank you.
Thank you. Commissioner Shabang Omdara.
Thank you, ACJ. I'm looking at the time. Good evening, Advocate.
Good evening, Commissioner Mdau.
I just want to thank you for being a good role model for all women lawyers out there. The
Thank
question
you.
that I had, the minister took it and you answered it. But what I can take further is, should you be considered, will you still be available in the activities of empowering women?
Oh yes, by all means.
And also I want to take you from Commissioner Nyambi to
Yes.
say how I wish we took you to the beautiful province.
Thank you very much. Thank you.
Hey, it looks like different provinces want you for themselves. Commissioner Mpofu.
Thank you. Good evening. I almost said Commissioner Advocate Norman.
Good evening, Commissioner Mpofu. Yes.
Thank you. I just wanted to echo what the other commissioners have said, particularly about, and I want to link this to what you bring to what you will bring to the judiciary if you are selected here.
Yes.
In my own experience in the commission, you epitomized what Commissioner Nyambi is talking about, which is preparation. I don't think I've ever seen a commissioner more prepared than you.
Thank you.
And I want to also concur that you would bring an attribute that is underrated, which is kindness. And in your case, that kindness, I want to warn those counsel who will appear before you, because that kindness comes in the form of tough love. And I just wanted to comment about that, the importance, a person in your position being a female silk, the kind of burdens and expectations that are on somebody like you. And if you do go to the bench, what message you would send around issues such as that? Preparation, people not expecting that because there's a judge who understands my language, therefore I'm now suddenly going to cut around corners,
Yes.
because I think they will come short
Yes.
in your case.
Yes.
What lessons have you learned around that issue of having to open the door for other young women and men who might feel lost at the bar?
Yes.
And how will you make sure that is extended to you, even though you might now be on the bench and they are at the bar, to make sure
Yes.
that they do feel comfortable and are allowed to make mistakes and
Yes.
all that? Yeah.
Thank you very much for your kind words, Commissioner Mpofu. I think everybody that has, at least every junior that has worked with me, male or female, they got to understand how I work. First of all, I always tell them that you make money in this profession. You make a lot of it, and you don't have to be greedy. You must be able to say, no, I've had enough now. I can't take this matter, can't take more work. My hands are full. And I teach them that.
I must leave politics.
No, sir.
No, you make more money in politics these days.
So, and then you teach them to know when to say no. Because once people get overburdened, they don't perform well. So I teach every person that works with me that. And secondly, preparation, there is no question about it. That when you are asked, when you go to court, when the judges ask you questions, I mean, in all the years that I've been in practice, I can proudly say that there's never been a single occasion where a judge said, you know what, we'll stand this matter down, Ms. Norman, we think we don't understand the issues. Because preparation is key. You just have to prepare. There's no shortchanging that aspect. And thirdly, you've got to understand your junior. I don't work with people without knowing their background. I will work with you. You'll get a brief with me. The first time we meet, I need to know who you are, where you come from. What are your challenges? Because it makes no sense to me that because I've worked with male advocates, senior advocates, Muharane SC, Poswa SC before he became a judge, these were seniors who understood what my challenges were. They know that you are a mother. At a certain time, consultations cannot be held at 5 o'clock because you are a mother. So those are the kind of things that actually build that whole community of advocates, where you know that you respect people's commitments, and not only that, you make sure that where you know they need help, you are able to come in, but not just giving people money, but people working for it and earning it. And the other thing that's major, which I always complain about, overcharging. If there's one thing that is eating up the advocacy profession, is overreaching, and it's a bad habit. People have, in as much as there are no tariffs, but a person needs to know that if I've done an X number of hours, I'm entitled to charge for an X number of hours. So
I see you are looking at Mr. Mpofu, not me.
no, because he asked the question. No, he's the one who asked the question. So when you then leave, because you've instilled these values, it's not easy for them to forget them. Because my seniors that I worked with, they made sure that you don't overreach. And once you instill that in juniors, they know that with Norman, there's no ways I could charge this because she's going to return the fee note. So once you instill good values, it's like parenting, really. Once you've instilled good values, yes, the child might go astray at some point, but at least the child will know that this is what mama and dada expect from me. Yes, but it's a continuing effort, and it's got to be done almost all the time, really. Yeah, thank you.
Well, thank you. All I can say, DCJ, is that if she's selected, it will be the bench's gain and a loss to the to the bar. But you are going to the correct province. Don't worry.
Thank you. Thank you.
Judge President Mlambo.
Thank you, Acting Chief Justice. Good evening, Advocate Norman.
Good evening, Judge President.
You know what I'm going to ask you, I'm sure.
Yes, Judge President.
Yeah. I think on a serious note, I just want to understand this. You've acted quite a lot. I've seen, I don't know where most of those acting stints were. Maybe you can tell us, where were they?
They were in the Eastern Cape and Durban.
Uh-huh.
Yes.
You did act in Gauteng, didn't you?
I did, yes.
But the real issue I want to raise with you is, ever since I became JP, the only time I successfully interviewed a Black African silk, a woman, was in 2017. Not before, not after. And it's not because I'm not talking to them.
Yes.
What is it that this JP has? I've spoken to you. I've spoken to you. I've spoken to many.
Yes.
You know the type of work that comes to Gauteng. What is it that I should do? Can you just give us that fair advice?
No, I think what I'll do is to go out and assist you in looking for these silks, senior African silks, women in particular.
No, they are not hiding. They are there. Some of them, you interviewed me.
Yes.
How many times? And I think you interviewed this JP as well.
Yes.
Yes. And they were sitting in this room. I would think Gauteng probably has the largest concentration of African silks.
Yes.
Am I wrong?
No, you're quite right. I think you're quite correct.
So what is it?
I don't know. Maybe maybe I could just offer prayer. Honestly, so I'm sorry, JP.
Okay, no problem. Thanks.
Thank you.
Justice.
Thank you, commissioners on the virtual platform. Is there anybody who has a question? If they are still there. No question. I think we have come to the end of this interview.
You are here, Acting Chief Justice.
Oh, okay, all right. Thank you. Well, I wanted to hear exactly that.
Yes, and send our greetings.
No, I was provoking you into saying something.
Thank you.
Okay. Thank you. I think we have come to the end of the interview. Once again, I want to thank you, Ms. Norman, for availing yourself and for coming to this interview. Thank you very much.
Thank you very much, Acting Chief Justice.
You are
And thank
now
you for the
excused.
opportunity. Thank
Thank
you.
you. Thank you.
Thank you. Oh, yeah. Oh, thank you. Thank you.
Okay, next candidate. Next candidate. I think let me quickly.
Take the water away.
Thank you. This is just a spreadsheet that the JP. Yes, using it as your name. Yes. Thank you.
Good evening, Mr. Ronason.
No, you've got Mr. Renassen's next.
Oh, this is Mullins. Okay. Well, my staff opened a wrong candidate. Yeah. Okay. They must have.
In any event, good evening.
Well, you don't want to go under somebody else's name because you never know what was going to befall you. So, good evening, Mr. Mullins.
Good evening, HSP.
Have we got everybody? Okay. Yeah. Okay, just get them back. Welcome to this session, Mr. Mullins, of the interviews of the Commission. Thank you very much for making yourself available for consideration for appointment as a judge of the Eastern Cape Division of the High Court.
Thank you, ACG.
Yeah.
ACJ, I beg your pardon.
Thank you. I see from the questionnaire that you hold a BA and an LLB. Is that right?
That is correct.
And both degrees were obtained from Rhodes University.
Correct.
You got the BA in 1978 and the LLB in 1980.
That's correct, yes.
And you started your legal career as a prosecutor, is that right?
That is correct, yes.
And later on you became a state advocate.
Yes, in Durban. Yes.
In Durban. Yes. And then in 1988, you began your practice as an advocate at the bar.
Yes, July 1988.
July 1988. And you have continued to practice as an advocate without interruption up to today.
That's so. That is so, yes.
Yes. And that makes it about how many years of practice?
34 years, if I'm not mistaken.
Yes. Would you share with the commissioners the kind of types of cases that you have handled in your practice over the past 34 years in terms of different branches of law?
Well, initially, it was 1988. There was a, as was the custom in those days, you either did pro deos or, as a young advocate, a lot of defending of in political matters. I did, for a number of years, I did criminal work defending a variety of political criminal cases. I was briefed primarily by a firm known as Boy Majidina. I don't know if anybody knew him, who's in fact who's now Justice Mshlanshla. She was my main source of work in those days. But that work started fading away. It was all sponsored work from overseas, and it dried up as time went on, and criminal law was not really my bent, quite frankly. And I slowly got into civil work, mostly motion court work and trial work. Started off by and large in the magistrates' court, and then slowly but surely developed into the High Court. I have Port Elizabeth is not the sort of place where one can specialize very easily. So I have a wide variety of work. I have done very little criminal work in the last few years, and I must say, virtually throughout my career, virtually no labor work. I've done about 3 labor cases in my career, 3 or 4 if I'm not mistaken, and ironically won all of them. But it's something, labor law is something you've got to specialize in. You either do it or you don't, in my experience. Different rules apply, and it's in a different court. So I have done very little labor work.
Yes.
You could say virtually, I haven't done any.
Was part of your practice commercial law work?
Yes.
A lot of it?
In recent years, yes.
Yes.
It's increasing, yes.
Yes. And I see that on the questionnaire, you said about 35% of your litigation work fell under administrative law.
Yes, that is again in recent years. A lot of work there's review of tenders, that sort of type of work.
Yeah.
Work for and against municipalities.
Yes.
It's a growth industry.
Yes. Well, you do say about 10% would be family law.
Yes.
10% medical negligence cases, 10% personal injury, and 15% unlawful arrest and detentions.
Yes. Yes. Those are rough percentages.
Yeah.
It depends on at the time.
Yeah.
You know, as life at the bar, work comes and goes. Sometimes it goes and doesn't come back for a while.
Yes. Yes. And obviously, you would have acted on the bench on many occasions during your practice.
On 4 occasions, which on page 28 you will see the acting appointments which I've enjoyed. Yes.
Yes. And there would be also many cases that you argued which are reported.
Some.
Yeah.
Unfortunately, a number of cases that I was involved in, I fell out of somewhere along the way for some or other reason that were reported, but I started. One of them was, for example, Mocha versus Butters, which went to the SCA eventually and was an important judgment in the field of universal partnerships. And unfortunately, I had to fall out of that matter, but I was the one who started it and took it as far as the SCA, but yes.
Okay, Judge President.
Thank you very much, ACJ. Good evening, Advocate Mullins.
Evening, JP.
You will recall that when I initially approached you for an acting stint, I had invited, I would say, male silks. One of the things that I shared was the importance of transformation. You will remember that occasion in my chambers in Port Elizabeth. You will also recall that one of the things that I highlighted was the fact that you should regularly have a baby junior, even in an instance where you have not been briefed together with a junior. You will remember that.
Yes, I do, JP.
Yes. Did you give heed to that?
I try to, JP. You must understand that it very often it's just not practical. One of the problems that we have in Port Elizabeth and particularly in Grahamstown is that there are not very many young, particularly female black juniors, and the difficulty is that because of briefing patterns that have nowadays, they're either too busy or you've got them doing acting appointments.
Thank you. Is there any scope for...
Sorry,
you wanted to add?
No, it's fine.
Oh, all right. Is there any scope for applying case flow management in the context of appeals and criminal cases?
You know, I have had very little to do with case flow management, being a silk. It's dealt with nowadays in chambers by the Deputy Judge President in Port Elizabeth. My understanding is that it works exceptionally well. The feedback that I get from practitioners is that they're very happy with the way it works. Cases get on the roll much faster. Cases that shouldn't be there are removed from the roll, and things are working swimmingly. As far as appeals, you say appeals and...
I said appeals and criminal cases or criminal trials.
Criminal trials seem to be, and as I don't do criminal work, but from what I hear, the talk in the corridors, getting criminal trials going and finalizing them seems to be an extremely problematical issue. How one gets the judge, the prosecution, the defense, and the accused all available at the same time, especially with COVID issues, seems to be a major problem, and I'm sure it's not only confined to Port Elizabeth, I think it's everywhere. So how case flow management would work insofar as criminal cases are concerned, I'm actually at a loss to help you. So far as appeals are concerned, there would seem to be scope for improvement there, because what happens is a unhappy litigant files a notice of application for leave to appeal, and the procedure is that the parties are supposed to then approach the judge in question and arrange a date. And very often the matter just seems to drag on, and the successful litigant, the last thing the unsuccessful litigant, the last thing it wants to do is approach the judge. So those matters seem to drag on. I would think that case flow management in appeals would probably improve the situation and hurry the appeal along, because unfortunately these things take up to a year to be heard, and it's the old story of justice delayed is justice denied. Yes.
Yes. Well, maybe for the sake of completeness, I should mention that there is statutory basis for implementing case flow management beyond civil trials, and that is Rule 37, capital letter A. You remember that?
Yes.
It came into operation on 1 July 2019.
Yes.
Yes. Thank you very much, CJ. Oh, sorry, just one last aspect.
Okay.
On the issue of implementing case flow management in criminal trials, I invite you after this interview to read the Daily Dispatch newspaper, Monday's article dealing with case flow management in the context of a criminal trial. You will see there that Judge Dokota was allocated that matter to manage. A particular matter is referred to there. It's got to do with the Mandela Funeral Fund.
Yes.
If you read the Daily Dispatch, Monday's issue, you will see something is said there in the context of a criminal case.
Yes.
No further questions.
As I said, I'm really not the right person to ask when it comes to criminal matters.
Yes. Thank you. I appreciate that. Thank you, ACJ.
And thank you, Judge President. MEC Gade, if you have questions for the candidate, I now give you a chance to put questions to him.
No, thanks, CJ. I don't have a question for the candidate.
Thank you. Commissioner Nojesi?
It's just one question.
Yes.
No, when the JP asked you about briefings and Baby Junior, you don't want to tell him that in the matters that I gave you, there were Baby Juniors and all that. You don't want to speak about that.
Yes. Thank you for bringing that to my attention, Mr. Nochezi. I'm currently involved in a lengthy trial in Mthatha, where Mr. Nochezi is the briefing attorney, in which a baby junior, Odwa Makewani, is my junior. She keeps saying to me over and over that she can't believe how much she's learning, and she's so grateful that she's involved in this matter. But quite frankly, I think I'm the lucky one, because she's extremely helpful, and I think it's one of those situations where it's a win-win situation. I might also add that JP, I was briefed about a year ago in a matter by the state attorney in a case which I think has raised its head here in one of the previous interviews, the SPCA case, and Al-Mawashi. I'm briefed there for the various government departments. I pulled in a black male junior, and as a result of that, the state attorney concerned got to know of his existence, and he's now her advocate of choice in all junior matters, and so he's done well there. I also am involved in a matter against Eskom, and where I've briefed, which involves the Dr. Beyers Nordia municipality, where Eskom is suing the municipality for over 200 million. Eskom says it's 200 million, we say it's a lot less, obviously. But there I have a young black-white female, I beg your pardon, a young white female junior, who also, as a result of that, has had a lot of spin-off work. So thanks to Mr. Nochezi, he's jogged my memory. Now, those are 3 current matters. Yes.
Thank you. Commissioners on the virtual platform, is there anyone who has a question?
Yes. Yes, Professor.
Is there someone on the virtual?
No, thank you, JP.
Oh, thank you. Thank you. Thank you. Commissioner Schlemmer.
Thank you, ACJ. Good evening, sir. I just, for interest's sake, checked the law report when you said that you think there are some reported judgments, and I could find about 9 dating back to 2004, just for interest's sake.
Thank you for that.
Thank you.
SJ.
You would like to?
Yes, this morning I learned a new term for baby junior, devils.
Devils.
Yeah.
Yes.
That's another term for baby juniors.
A devil is where a junior does research for you. It's called deviling. It's got nothing to do with Devil's Dorp or anything like that.
Thank you so much.
Commissioner Mpofu.
Yes.
Thank you. Good evening, Mr. Members.
Good evening, Mr.
Yes. Now, I just wanted to question you about one issue which might arise when we do our deliberations, which is your age.
Yes.
As matters look, your age is against you. You are 65 at the moment.
Correct.
Yes. So, how can you convince us that we should overlook or not put too much weight on that factor, vis-a-vis what, because you can't change your age,
No.
but you might be bringing something else that might counterbalance that factor so that it doesn't count against you in the deliberations.
Yes, thank you. The one thing I think that money can't buy, and that's experience. And I believe that I have sufficient experience to walk straight into the job without trying to blow my own trumpet. If one has a reference to the judgments that delivered during during my 4 acting stints, I think they speak for themselves.
Yes, I'm particularly impressed by your judgment on delinquency.
Which one was that, Advocate?
It's the one, it's a long one. It's Nicholas Petrus Blake.
Blake, yes.
Blake versus
yes.
Dry.
Yes, that was a clear case of fronting where the parties had fallen out and they tried to get rid of their black partner. And anyway, I wasn't going to have any of it. Yes. Earlier in the week, I know the acting Chief Justice mentioned just one of the candidates that why should an older candidate be appointed and then get the benefits of a pension?
Yes.
That's where somebody who's been on the bench for 15, 20 years gets the same pension. My understanding of my understanding of the Judges Remuneration Act is that you've got to have served for 15 years before you qualify for a full pension. Otherwise, you only qualify for a portion, or whatever the...
Prorated.
Yeah, pro rata, yes. So that isn't a difficulty. But that's the long answer to your question. The short answer is I believe that I have the experience.
Well, of course, what remains would be that society would get benefits by way of the services of a younger but experienced judge over a long period of time before they get to get the pension benefits. Whereas when you come to the bench very late, there is a limit up to when the number of years you can be allowed
Yes.
to serve
Yes.
is limited, you know. So there would still be that situation.
The retirement age is mandatory
Yeah.
at 75.
Yes, yeah.
Insofar as my age is concerned, Advocate Mpofu, I'm fit and healthy as far as I'm aware, and so there's no difficulty on that score.
Thank you. So all things being equal, you would still have 10 years to offer?
Yes. If I do not succeed in being elevated to the bench, I intend to carry on working indefinitely anyway.
Thank you very much.
Okay. It looks like there is no question. There are no questions anymore. We have come to the end of this interview. Thank you very much, Mr. Mullins. We appreciate
Thank
that
you.
you made
Chief
yourself
Justice.
available. You are now excused.
Thank you, Chief Justice.
Thank you. Hey, we come to the last one. Come to the last one. Oh, is it raining? Oh, well, if there is rain coming, you can close, yeah. Yeah, it's a blessing, yeah. It's rewards for our hard work. Yeah. Hey.
Thank you.
Let's start, commissioners. Good evening, Mr. Ronerson.
Good evening, Acting Chief Justice.
How are you this evening?
I'm very well, thank you, and thank you for all of you being so patient.
Thank you. I think we might have to close here because it's noisy, it's drowning the voices. Thank you for coming to this session of the Commission's interviews, Mr. Ronerson.
Thank you, it's my honor to be here.
And thank you for availing yourself for consideration for possible appointment as a judge of the Eastern Cape Division of the High Court.
That too is my honor, sir.
I see that in terms of the questionnaire, you hold the degrees of BA and LLB, which you got from Stellenbosch University.
That is correct, Acting
correct?
Chief Justice.
You got your BA in 1977 and your LLB in 1979.
That is correct, sir.
Yes, and you started your legal career as a public prosecutor.
That is correct.
That was in 1980. Is that right?
Yes, that's correct.
January 1980.
Yes, in Stellenbosch as well.
Yes, and you also served articles and you were admitted as an attorney?
Yes, I was admitted as an attorney in 1985, Acting Chief Justice.
Yes, and did you practice as an attorney for 2 or 3 years before you went to do pupillage?
That is correct. I practiced in Pretoria for 3 years at an intellectual property firm.
And you started practicing as an advocate from July, was it from July 1988?
That is correct. I did my pupillage in the first half of 1988 in now Gqeberha, and I commenced in July 1988.
But did you later go back to being an attorney with a law firm called Spilkin and Mills?
That is correct, Acting Chief Justice. They made me an offer which I thought was attractive at the time, and I spent approximately six and a half years there. Yes.
Yes, and then in January 1999 you went back to the bar.
That is correct. Where I've been ever since.
And you have been practicing as an advocate since then without interruption up to now.
That is correct, Acting Chief Justice.
Yes, and that makes it a period of about what, 21 years?
22 years.
22 years. Okay. And are you able to share with the commissioners the types of cases that you were exposed to in your practice as an attorney first and in your practice as an advocate over all these years in terms of different branches of law?
Yes. Acting Chief Justice, my initial exposure as an attorney was at an intellectual property firm where I worked in the copyright and trademark department and got quite a large exposure to litigation in that field, particularly unlawful competition litigation and trademark infringement litigation. I've limited exposure to patent infringement litigation, but mostly in the field of trademark and copyright. When I commenced at the bar, I initially did some criminal work. In the mid to late 80s, the Eastern Cape, as most of the country, was beset with the criminal case. Political cases dominated the criminal role in the then Supreme Court, and I was involved in some of those defences. Those defences were sponsored by philanthropic organisations from abroad, but eventually my work, I didn't do any more criminal work, and my speciality was commercial work. It's always been my passion, and cut my teeth in the magistrates' court with civil trials in the magistrates' court, and at the same time developed a substantial motion court practice in the High Court, acting Chief Justice. And eventually my practice has also developed to include a substantial amount of work in the field of administrative law and some constitutional law, which I find particularly exhilarating work.
Yes. And did you take silk in February 2016?
That is correct, Acting Chief Justice.
Yes. And in terms of cases that you have handled in the different courts, there would be cases that have been reported that you had argued, is that correct?
That is correct, Acting Chief Justice.
And you have set them out in the questionnaire?
Yes, I have done so.
Yes. And you have also acted as a judge in the High Court?
Yes, I have done so for 3 full terms.
Yes.
The second term in 2019 and the second and third terms in 2020.
Yes.
A total of, I calculated 30 weeks by my calculation.
Yes. And did you sit in criminal trials apart from civil trials and motion court?
Yes, I sat in totally in two criminal trials in Gqeberha and one in Makanda. One in Makanda didn't progress very far, and the accused were referred for examination, medical examination. And but I sat in 2 criminal trials. One was a particularly lengthy one, which I only completed. I still have to go back to do the sentencing phase of that trial. I completed that in September of this year. It ran in fits and starts. It was great. We had great difficulty with COVID and other technical problems to complete the trial, but it was eventually completed.
Yes. Judge President.
Thank you very much, ACJ. Good morning, Advocate Ranisi.
Good evening, Judge President.
Maybe I should start off by saying that, well, as I did with Advocate Malins, that when I approached you and him and Advocate Bieneke, when I was noticing that we were losing high-quality judges and inviting you to act in my division, one of the things that I mentioned to you was the fact that you need to subscribe to the view or the school of having baby juniors with you. Now, I've received good reports from black female advocates in particular. They sing your praises in that regard. They say you go all out. You always ensure that you have a baby junior with you. For those who may not know what it entails, one of the consequences is that you must share a fee. Will you confirm that?
Yes, if I may elaborate a bit on that, Judge President, what is unique, I believe it is unique to the Eastern Cape, and I was party to getting that going in the Eastern Cape as a member of the Bar Council was what we call the mentoring, junior senior mentoring program, where we felt that deviling in exposing young black practitioners to deviling work was not sufficient to give them the exposure they needed to first establish sustainable practice and to introduce them to attorneys who had traditionally not briefed black counsel. Yes. So the junior senior mentoring program was established where, in terms of which, beyond deviling, black baby juniors were appointed, And they were so, in that manner, they were introduced to practitioners who traditionally had not briefed black juniors, and that was the start of a very successful, and that program continues to be very successful today. I think my colleague Michelle Bieneke alluded to that as well in her interview today, is how successful that is working. And to answer your question, yes, that does involve giving up a portion of your fee as the senior, but the benefits that it has brought to the junior bar, and particularly black females there, to the extent that some of them have developed into outstandingly good counsel, have developed outstandingly good drafting skills and so on, and are now getting the work independently of the mentoring system. And I might add that for the rest of this year, I have a number of substantial matters, including one in the Supreme Court of Appeal, and in all of them, my juniors are African females.
Thank you very much. At pages 31 to 34 of the document serving before you, headed List of Judgments by Eastern Cape Candidates, JSC, October 2021. When you get to page 31, you will find that it sets out all the judgments you penned during your acting stints.
That is correct, Judge President.
You never acted before my era.
No.
Yes.
Gratefully, you were the first to appoint me.
21 opposed application judgments were penned.
That is correct.
21, yes. And then 3 civil trials were run and judgments were produced there. Criminal trials 2, criminal appeals 3, civil appeals 7, review of taxation 1. You confirm that?
That is correct, Judge President.
And you are fair with the notion of case flow management?
Absolutely, Judge President. I am a great proponent of case flow management, and its introduction in the Eastern Cape has reaped rich rewards as far as I'm concerned, particularly for litigants who needed their cases come to court sooner rather than later.
Yes.
You were aware that I assisted you with a short note or memorandum.
Yes, I'm actually getting the counsel. Maybe let's view it from this perspective. When I became Judge President, let's start off with Grahamstown. Would you confirm that there was a resistance of case flow management in Grahamstown?
I would confirm that.
Yes.
Judge President.
And in fact, I had to introduce it in Port Elizabeth first.
That is,
and then once it started working there, and then it was easier for me to bring it to Grahamstown.
That is my recollection, yes, Judge President.
You penned a letter as chairperson of the Eastern Cape Society of Advocates not so long ago.
Yes.
In that letter, you do not only applaud case flow management, but you also point to certain weaknesses in the system that need beefing up. And I wish to place that on record and want to say I appreciate that greatly.
I'm glad if that could have been of assistance to you, Judge President.
Thank you very much. No further questions, CJ.
Thank you, Judge President. MEC Gade, if you have questions for the candidate, I now give you an opportunity to put your questions to him.
Thanks, Jay. No, I don't have a question. Let me plead you to proceed.
Thank you very much. Commissioner Ndolo Klepu.
Thank you, TCJ. Good evening, Advocate.
Good evening.
Thank you for confirming what I was thinking. I always believed in the issue of dabbling. to say that you are actually not empowering. You are actually no. They become your clerks. So at least you have confirmed it. I'm quite happy that it's out there. You know.
Yes,
Yeah.
I remember from one of the other interviews you referred to training. Well, training is a starting point only. The ultimate goal must always be to establish a sustainable practice for a new junior, and particularly the black juniors who have joined our society.
Thank you, Commissioner Mpofu.
Thank you. Good evening.
Good evening, Commissioner Mpofu.
Thank you very much. I just wanted well, firstly, let me start with the positive one. I'm very impressed by the fact that you refer to the places by their real name, unlike your JP. You talk about Kabeja and Makanda, even in your document.
I must, in support
I'm wondering where this JP says he started something in Port Elizabeth. So where is that?
But in his defence, the Act hasn't been amended, so it's still the Grahamstown High Court and the Port Elizabeth High Court, according to the
I know,
Act.
but that didn't stop you from changing your letterhead to Kabeja. Thank you. Now, I wanted to the issue I wanted to raise with you was the same question I asked the previous candidate. I see that you are turning 65 next Tuesday.
Yes, that is.
And you are a Libran like me.
Oh,
so
well balanced people.
Thank you. Yeah, those are the best people. Yeah. So what do you say about that? Why should that not count against you? And I say that in the context of you giving the commission, so that if it arises during the deliberations, give us reasons, because everyone brings something different, would bring something different to the judiciary. So in other words, you say, well, I might be 65, I might only have X number of years to give as opposed to a 40-year-old candidate. However, this is what else I will bring, which might outweigh that factor.
Yes. I would bring to the position my considerable experience over 35 odd years in practice, either as an attorney or as an advocate. I must also point out that with regard to the division in which I seek appointment, we have recently lost to retirement or elevation some very experienced judges, and we will lose to retirement Judge Robertson, whose position is also advertised here. We also lost to retirement Judge Chetty in Kabeja. So there is to some extent an experience vacuum that has arisen, and I am ready to help to fill that vacuum. I don't want to be presumptuous that I could fill it all on my own. But you're talking about having, and furthermore, I think in July, mid-year next year, two judges of 25 years experience each will be retiring. So experience is, in my humble submission, is something that's going to be required on the Eastern Cape pension, and I feel that I could go some way to fill that vacuum, and I'm ready to give the 10 years that remain for me to do so, I recognise what the acting Chief Justice has said to other candidates. You know, you can get more out of somebody who's also experienced if he's available for another 15 or 20 years. But I do come with that experience, and throughout my career at the bar, and particularly of late, I've been heavily involved in mentoring, and the judge present in progressively developing our bench and seeking to achieve the transformation target in terms of the constitutional imperative, will be appointing many, for instance, many acting judges who will be of various levels of seniority and who I'd be very happy to assist the judge present in mentoring them in the future, so that they can ultimately take up positions on the bench in a permanent basis.
Thank you very much. No, I think that's a very good answer. So, in other words, what you're saying is that it's no use having a bench of 25-year-olds. I'm exaggerating for effect. You also need to blend the youth which is needed with the experience. Yeah.
Yes, I agree with that.
Thank you.
Thank you, Commissioner Moiman.
Thank you, Acting Chief Justice. Good evening.
Good evening, Commissioner.
Thank you. In your questionnaire, page 15, 6.3.2 and .3, you make reference to two areas there.
He might be struggling to hear you.
No, I do. I am able to hear.
But it's not on.
Yes.
Your mic is not on.
I'm bringing your attention to your questionnaire under 6.3.2.3, page 15 thereof. What I'm more interested in is probably your just a reflection on the role that you played in enforcing the responsibility of the Eastern Cape government to respect court orders, because you make reference to Jaiya and Kate cases. Both of them was against the social welfare department.
That is correct, Commissioner.
And you raised an issue around the role that you have played, but also isolating these cases as part of your flagship cases.
Yes.
Can you just probably give me a reflection on that? Give the Commission a reflection on that, because central to this case was the bravery of the court to force the head of the department and the MEC to respect court orders. Thank you.
Yes. These cases must be seen against the background of the broad picture in that the MEC at that time was faced with masses and masses of litigation regarding it had become a cottage industry where an applicant would apply for a social grant. The 30-day period would pass, and on day 31 there would be an application served against the MEC, and the court was eventually almost becoming the agency to award social grants, which shouldn't have been the case. Over a period, the MEC was advised how to deal with these applications. I remember one day appearing in the Gqeberha Motion Court in 800 matters on one day. With 800 matters had to be postponed because I couldn't get instructions on 800 matters to deal with them in court. So that had to improve, and the defences were categorised, and the MEC was advised not to willy-nilly oppose these applications where applications had merit, where people qualified for social grants, to give them their social grants. And that is the background to these cases. And I'm proud to say that eventually I was invited to one of the social grant offices in Gqeberha, it was in New Brighton, where in the past people had to come to court to get their social grants, where I was able to walk through with a number of applicants for social grants where they got the social grant, for instance, a child support grant, on that day. They came there and we walked through the application, and half an hour later they had their grant. So that's how matters developed. The Jahia judgment has to some extent been overtaken by judgments of the Constitutional Court where the Constitutional Court has found that even in matters where judgments sound in money on a structured basis, you can have contempt proceedings, what they call civil contempt proceedings. So to that extent, but Jahia established the principle that you couldn't just lock up the MEC for not paying somebody social grant, which was quite correct. The judgment there. The Carte judgment then developed on that. The Carte judgment by Judge Fruneman was the progenitor of a judgment that he eventually gave in a matter which was unreported in the Eastern Cape, a full bench judgment of Birchall versus Birchall, and which was then ultimately adopted by the Constitutional Court. I can't remember the name of the judgment.
Thank you, Advocate. I'm happy with that reflection. I suspect that is what we call positive judicial activism.
Absolutely.
Thank you. Thank you, Acting Chief Justice.
Thank you very much. Commissioners on the virtual platform, is there anyone who has a question?
Thank you,
Okay, Commissioner Barnett.
Good evening, Commissioner.
Thank you. Advocate Ronaldson, you did some interesting work, it seems, on a judgment. I'm referring to the Borchard and Duxbury matter, which deals with the DocuSign app.
Yes, I have received some academic criticism in respect of that judgment.
Well, this is the thing, you know, one has those wonders and concerns when you read it and so on, but you go into certain authorities there. Question is this, has it not become time in South African law to take a serious look at this sort of, easier entering of documents? One understands the safeguards that should be in for fraudulent transactions, that sort of thing. But I'm thinking about the frantic concerns that there were in the COVID time, for example, when during lockdown people wanted to execute wills and it became quite a difficult thing to do, in the initial phases and so on. So just your comment on that generally and your experiences, and maybe also refer to those criticisms as well. Thank you.
Yes, well, the criticisms were that I was perceived to have allowed an electronic signature as constituting sufficient compliance with the Alienation of Land Act to establish the existence of a valid agreement for the sale of land. Now, that's not what I did, because it was not an electronic it was never an electronic transaction, and electronic signatures are applied in electronic transactions for which the legislation makes all sorts of provision, and that provision includes verification of electronic signatures and the like, and builds in those safeguards. But electronic signatures are, in terms of the legislation, are specifically excluded when it comes to transactions for the sale of land. And to answer your question then, maybe it should be in fact extended, because it would make sense in a modern world and enhance commerce to allow electronic signatures even in sale of land transactions, which I would advocate. But one must bear in mind that our property registration system is recognized worldwide as one of the best, and that it is so good because it promotes certainty, and you don't want to have uncertainty. So certain safeguards will have to be established before those signatures will be allowed for transactions for sale in land.
Thank you very much. Thank you.
Does that answer your question, Commissioner?
Yes, thanks. No, we can talk long about it, but we're a bit limited for time. Thank you very much.
Thank you, Commissioner Barnett. Was there another commissioner who had a question on the virtual platform or not? No. Okay, thank
No,
you.
thank you.
Thank you. Commissioner Slem?
Thank you, ACJ. I just want to make a follow-up question on what you just said, concerning that you said you were criticized by academics. Do you think it is important for judges to take care of or to keep up to date with what academics write about their judgments?
Yes, absolutely, I agree with that, Commissioner. I must just add, when I say academic criticism, I think it might be more from the property lawyers lobby in their various publications that the criticisms came than academics. Because I know that judgment might be perceived. Professor Glover's book from Rhodes, his book on he says that for sale of land there must be a wet signature. So I put a wet signature, something you sign with a pen, and I didn't agree with him on that. So that criticism might still be forthcoming, but I agree that very much so. The judiciary must have regard of academic writings and they offer very valuable assistance in formulating judgments. You will note that in that Duxbury judgment, one of the bases on which I found was a suggestion in the law, a contract book written by primarily Stellenbosch academics, my alma mater. That wasn't the reason why, but they suggested that if you could eliminate fraud, there's no reason why you could not use something like the DocuSign app, which I found was constituted a signature for the purposes of the Alienation of Land Act.
Thank you very much.
Thank you. It looks like we have come to the end of this interview. Thank you very much, Mr. Ronson.
Thank you very much, Acting Chief Justice and Commissioners, for your patience.
Once again, thank you for having availed yourself.
Thank you, that is my honor.
But you are now excused.
Thank you very much.
Thank you. Do you suggest that we have 5 minutes break, or do we go straight?
I would suggest that Sichaye is a kuma. Get on with it.
Okay, all right. That's it looks like there is unanimity. The media must vacate, and then we can